If we could sit down and get started. Oh, wow. A buzzkill there, I'm sorry. No. Good morning and welcome. My name's Austin Parrish. I'm the Dean here at Indiana University Maurer School of Law. And it's on behalf of the entire law school, it's my pleasure to welcome you to today's conference hosted by the Indiana Law Journal, the American Constitution Society, on the future of the U.S. Constitution. There's a number of people who are going to be providing introductions, so my plan is to keep this incredibly brief. Those remarks will include the new editor-in-chief of the Law Journal, the law school's ACS chapter president, and Don Johnson, who helped organize the conference. But here at the law school, we have a tremendous history and tradition of bringing in some of the nation's leading scholars to talk about the hot issues of the day. And I'm incredibly pleased that ACS and the Journal can continue that tradition today with really a remarkable panel of tremendous scholars coming from all over the United States to talk about the future of the United States Constitution and some of the most hottest issues that are facing the country constitutionally. I know there's going to be 4 panels. They'll be providing kind of an analysis of a wide range of constitutional issues, and I'll let them do those more specific introductions. My job, more importantly, is to thank a few people. This symposium wouldn't be possible without the tremendously hard work of Professor Don Johnson and of the students of the ILJ and the ACS. I know specific thank yous are going to be made. And it also wouldn't be made without the tremendously hard work of Chelsea Browning, the school's events coordinator, and a number of other staff who did a lot of work behind the scenes. So I hope you'll join me. I know there'll be other thank yous, but to do a quick round of applause for everybody who made this possible. So I think we're in for a simply spectacular day. And with that, why don't I turn it over to the new editor-in-chief of the Indiana Law Journal, Stephanie Goldkopf.
Good morning, everyone. As Dean Parrish said, my name is Stephanie Goldkopf, and I'm the incoming editor-in-chief for Indiana Law Journal. I want to extend a warm welcome to our panelists and thank everyone for being here today. Indiana Law Journal is honored to be co-hosting such an important and timely symposium with renowned scholars in constitutional law. Our team is excited to be publishing many of the panelists next year in the first issue of our 93rd volume. And we look forward to working with all of the panelists through the publication process. Making this symposium a reality has required hard work from many people in the law school. First, I would like to thank Annie Shea, our outgoing editor-in-chief, and Joey Pellegrino, our outgoing executive articles editor, who have been working on organizing the symposium with both Dean Parrish and Professor Don Johnson since last summer. I also want to thank Brooke Harwood, our incoming executive online editor, who worked diligently to make sure all of the blog posts that panelists submitted in anticipation of the symposium got published to our website, and Allie Gardner for making sure all of the panelists had a ride to and from the airport. Additionally, I would like to thank the American Constitution Society and Professor Johnson for all of their help making this symposium as great as it will be. And last, but certainly not least, I would like to thank Chelsea Browning, our events coordinator, for helping with all of the logistics and details. Indiana Law Journal was established as Indiana's flagship law journal in 1925 and has had the privilege of publishing many of the panelists before. We pride ourselves in selecting timely and timeless pieces in all areas of legal research. When we heard the proposal for this symposium, we knew we had to be involved. And even though the symposium was contemplated with different election results in mind, we believe that this sort of discourse is necessary now more than ever. We hope you all enjoy the 4 panels that we will be hearing today, whether you're joining us here at Maurer or from at home. Thank you.
Good morning. My name is Ashley Linderman, and I'm the president of ACS. The American Constitution Society is a progressive legal organization comprised of lawyers, students, scholars, lawmakers, policy advocates, and members of the media. ACS believes that law should be a force to improve the lives of all people. Its mission is to promote the vitality of the United States Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. The student group here at Maurer is but one of 200 student chapters among dozens of lawyer chapters. These ACS chapters all over the country are dedicated to revitalizing policy in classrooms, courtrooms, legislatures, and the media. The Constitution is the driving force of the country, and our organization and our chapter could not be more proud to host these constitutional scholars to discuss the future of the United States Constitution and how to protect the values it expresses. On behalf of the American Constitution Society chapter here at Maurer, thank you for coming.
Thank you all for being here. Good morning. Being here at the beginning of this exciting symposium. And I want to thank Austin, Stephanie, Ashley, second their remarks. And in particular, Stephanie's observation that we began planning this symposium last summer, so 9 months ago. Conversations with Annie and Annie, thank you. I really got to say, the outgoing or current editor-in-chief, who was also the president of ACS and made this happen by explaining the project to the ILJ board, and they agreed to commit the next year's board to do all the work in publishing the essays, so good work with that. And thank you. Had to be unanimous vote, so that was exciting, and we appreciate that. So that started 9 months ago last summer, 9 long months ago. So I just want to stay on first all the hard work that's happened in that 9 months, and in particular, Chelsea Browning, our events coordinator. Is she here? Probably not. Okay, we're gonna have to clap later when we can get her in the room, because she has just been working so hard on this. And thanks to Austin and the law school for supporting this financially, making this possible. And the American Constitution Society National also has supported the ability of us to be here. Many students, in addition to Annie, helped so much. Ashley Lenderman, just want to mention you. I'm not going to mention all the others, but you can imagine what they've been doing, substantively, logistically, during those 9 long months. And so I want to emphasize the 9 long months for a second reason. As Stephanie noted, when we said, let's have a bunch of us panelists, some of us were together at the ACS National Convention last June, and starting up a board of academic advisors. Many of our panelists are part of that or otherwise involved with ACS. Looking ahead, I'm not going to say very much. Just take a minute. Remember last summer? Okay, so I'm just going to let you go where your memories take you, and just remind a little bit that Merrick Garland was our Supreme Court nominee. Looked like we were going to have the first woman president. So we thought, good time. It could be a transformational court, and so much up for grabs. Let's have a symposium, and that's what we were thinking. So here's one other thing. Question. So I'm a law professor, so here's a question. So law and politics, distinct, overlapping, intersecting, and we're going to talk about that. Political affiliation of a justice before they get to the court, not everything. But when was the last time we had a majority of Supreme Court justices appointed by a Democratic president? Who knows the answer to that? Steve was always in the front row in law school, right? All right, anyone in the audience? All right, Steve.
May 14th, 1969.
Wow. So everyone should be repeating that every opportunity, because it should affect how we think about how constitutional law has developed over the last half century. We haven't, and so last summer we thought, hey, that's going to change. And I don't mean to be political. You might have thought that'd be a bad thing, but we all learned the lesson, I think, that elections matter tremendously. So I'll just leave it there in terms of reminiscing last summer when we thought about what we would be talking about today. So our topics have changed a bit, and what we envision for our future of our of our U.S. Constitution in the near and midterm, and to some extent, long term. We're debating last night at dinner how many years, before we can talk about what we wanted to talk about last summer. Some of us, at least. So we'll see. But I do want to say that symposium no less vital. Some of the topics have changed, a bit different. Communities like Bloomington, not unique, but like communities all around the country struggling with various constitutional issues that we now have an amazing group of national experts gathered with us now to discuss. At a time that we'll say is just, it's unusual in our nation's history in a different way than we thought it would be unusual. So I want to say just one more point and then turn it over to our first panel, and that is to remind us, this is a teaser to make you come back this afternoon, Professor Mark Tushnet will kick off. Mark, are you here? Okay. Yes, okay, in the back there, okay. So Mark's going to kick off the afternoon by reminding us that so much of what we need to be thinking about transcends Trump and the current court and the current Congress, and that it is essential that we take whatever your views, but be thinking in the longer term. It's essential to have a principled vision that we can work toward. And so we'll hear more about that. Income inequality, that's the first afternoon panel. Not a new problem, but something that is particularly pressing now. So come back then. And now I am going to end by thanking all and ask for a round of applause for our 15 experts who have traveled from around the country to be with us to help talk about how to deal with these pressing constitutional issues, short, medium, long term, and how to help shape the future of our U.S. Constitution. Thank you.
Okay, well, hi everybody, I'm Steve Vladeck. I teach at the University of Texas School of Law, and I have the privilege and the pleasure of getting this party started. Because, Supreme Court trivia, there's nothing that wakes you up quite like Supreme Court trivia. By the way, Dawn, I have one for you. When was the last time that a Democratic president's Supreme Court nominee was confirmed by a Republican Senate? 1895, if you're scoring at home. Okay, where's a Rufus Peckham reference when we need it? So the title of our first panel this morning is a bit provocative, and I think Dawn got mad at me because I wanted it to be a little provocative. And the title is The Nativist Turn, Immigrants, Communities of Color, and Courts in the Era of Trump. Little did I know that, Jeff Sessions was going to steal my era of Trump language earlier this week when he talked to the Justice Department about how, now this is the era of Trump. What's that? The time of Trump. I'll take that as a friendly amendment. But what does that mean? I mean, so is it really fair to describe what's happening as a nativist turn? What kinds of consequences might that have, not just politically, but constitutionally? What are some of the sort of institutions that might be best situated to respond to these pressures and these developments? How much of this was happening even before the election? How much has it gotten worse or just kept going? And to help try to walk through some of these questions, we have really a fantastic panel of people who actually know what they're talking about, and then me. So I'm just going to introduce them very briefly. You have their full bios. Well, not even their full bios. You have their 200-word bios, right, in the programs. So first, starting on my right, your left, is Chirag Bains, who's a fellow at Harvard Law School and was formerly in several very senior roles in the Civil Rights Division at the Department of Justice, including senior counsel to the Assistant Attorney General. So yay, Chirag. To my left, Anurima Bhargava is a fellow at the Open Society Institute and the Kennedy School, right? I got those. And was the chief of the Educational Opportunities section in the Civil Rights Division at the Department of Justice. I'm sensing a theme.
Yes.
To Anarima's left is Shireen Sanar, who's an associate professor at Stanford Law School, not an alum of the Civil Rights Division of the Department of Justice. So we've got 2 and 2, right? You know, I like our chances in the basketball game. But Shireen, well, yeah. In addition to being an associate professor at Stanford, Shireen was an Equal Justice Works Fellow at the Lawyers Committee for Civil Rights in San Francisco, and also a staff attorney for the Asian Law Caucus, so has lots of experience on the ground working on these issues. So thank you all.
Further to the left of the Civil Rights Division.
And geographically, right? Yeah, okay. But so Shireen, I'm gonna sort of start with you. So Dawn and I went back and forth for about 2 weeks over email about whether I could get away with using the word nativism. I won, although I think just maybe by force of emails. When we say nativism, what do we mean? And do you think it's actually fair to look at what's happening, not just with immigration, but with communities of color, with policing, with lots of other stuff in the news, as representing maybe either a sort of unintentional or perhaps even intentional nativist turn?
Sure. So I actually looked up nativism on Wikipedia of all things.
Oh, well,
because
that case.
well, yeah, I Googled it.
It was on
just to
Sebastian
see
Gorka's
what the
Wikipedia
definition, consensus definition out there is. And it struck me that what I got was a policy or ideology of favoring established inhabitants of a place over immigrants. And actually, I found that interesting because I think that, I would say we can certainly describe part of what's happening as a reflection of that kind of nativism. I mean, there's no question that the anti-immigrant moves of the Trump administration, whether it's the travel bans or the threats to revoke funding for sanctuary cities, the heightened enforcement of immigration law, including in places like courthouses, all of that reflect an anti-immigrant sentiment. But I think in some ways nativism is actually, it's not that you could get away with using it, but it's almost too limited a term to describe what's happening, in the sense that nativism could sound like it's actually some kind of race-neutral preference for those here over those beyond. And I think it's important to identify that when we're speaking, or at least when I think of nativism, I think of it in terms of, frankly, of racism and of white nationalism, which I think it's fair to lay, at least to those in a particular wing, one might say the Steve Bannon wing of the Trump administration. So to me, in some sense, the usage of the term may not go far enough in talking about kind of the racial components. I think one question for us, and then I'll let you go on to the rest of the panel, but one question for me too with this framing of the nativist turn that I think we should speak about is the extent to which it is a turn or a perhaps intensification of existing policy, of perhaps existing currents in American thought that have come more to the fore in recent times, but that are not so much new as historical.
So I think that's really helpful. So let me ask, Charles, let me come to you, right? I mean, so from your time at DOJ and just sort of more generally, I mean, Shireen I think is right to say a lot of this was already out there, right? That no, we didn't have a Steve Bannon type in the White House, and we didn't have a Jeff Sessions type as Attorney General, but there were these concerns about not just anti-immigrant moves, but anti-communities of color, right? You were obviously involved in Ferguson, among other things. I mean, how much of what we're seeing right now, in your view, is different, and how much of it is just sort of more exposed because of the political valence, right? Because it's so much more easily identifiable with individuals who have senior government positions.
Yeah. Well, I mean, I think it's a good question. I don't think things dramatically shifted on Election Day or on Inauguration Day in terms of what was going on in our country. But I do think that the message coming out of the federal government has shifted, and that is where I think we're seeing that turn. This moment is a contested moment. I mean, how nativist are we going to become? And clearly we had an incredibly divided country, an incredibly close election where Hillary Clinton actually got more votes. So we sort of have to remember that in the scheme of things.
But 3 million of them were illegal aliens voting fraudulently.
It's true. Well, that brings us home, I guess, right? We're talking about what does the nativist turn look like from the executive branch? And I think, as Shireen points out, there's a rhetorical aspect to that, but also a core policy, a set of policy changes. On the rhetorical side, I think about the key messages of the Trump campaign and the presidency now. America first. the forgotten Americans, right? All the forgotten Americans out there, echoing the silent majority of Richard Nixon, and Law and Order. And these narratives sort of squish together this idea of who are real Americans, and I do think that's colored by race and is anti-immigrant in nature, and also this idea that there's this looming problem or overarching problem of crime. President Trump now has smushed together crime and immigration. That's been one of the signature moves, is to equate being an immigrant, being a foreign-born person, with the notion of criminality. And now I think that actually goes beyond undocumented immigrants. And I think his defenders will say, well, he's talking about undocumented immigrants. But the best data we have shows that undocumented immigrants commit less crime than native-born Americans. And the data is a little bit hard to disaggregate. Certainly it shows that immigrants as a whole commit less crime, but even some of the more recent studies that have come out show that where we can identify certain markers of what our undocumented population looks like, so people from Mexico, Guatemala, El Salvador, these are the folks that the president is talking about, and who have low levels of education, they appear in our prisons at much lower rates. And there's also been some research showing that cities that have heavy populations of undocumented immigrants have lower levels of crime. And so the narrative that we're seeing doesn't match up to the data that we have. And I think that's really concerning. And I'll come back to some of what you asked about on policing, but the major concern for me is that we no longer have a federal government that is at the front lines of raising up issues of racial inequality and trying to do something about it. Now, the federal government was never the leader in that. I mean, communities around the country were, advocacy and activist groups were, and thinkers around the country, but it helped to have a Holder and Lynch Justice Department that was going to investigate police departments for misconduct and stick up for the rights of all Americans, including those who may be unauthorized.
So, Honorary, let me come to you for a minute. I mean, so Shroud was talking about this from the perspective of policing, right, law enforcement, the criminal side. I mean, you've done a lot of work, obviously, on the education piece of this and on the school side of this. Do you see a similar sort of, I mean, does that sound like a similar story? Are there different currents at play when we're talking about, the less sort of law enforcement-y, the more like community building from the, bottom up schools? I mean, how is that similar? How has that been different?
So I think actually they're quite similar in many ways, but let me go back for a moment and just talk a little bit more about sort of where the turn may be occurring, both in terms of the role of the Department of Justice and the federal government, which in many ways was a role of being the protector in some form, and now, for lack of a better way of describing it, it's the aggressor. And so what does it mean to have that, just in terms of how it is that people think about fear, and what I want to talk about particularly with regards to children is fear. What does it mean to have the fear come from the place that had played a role as the protector? And in some ways, the idea of sanctuary and hope, in all the investigations that we were doing around the country, we often found communities looking to the federal government as a place of sanctuary and of hope. And so the way that language has actually changed as people start to talk about communities being sanctuary and that being something that's actually very much threatened by the Justice Department. So I'm going to go a different route, which is to tell some stories about what's happening around the country when it comes to schools and children, and oftentimes the result of not of actual federal government policies, but just of this idea of what the rhetoric has been and the way in which it's been playing out has been very tangible things that are happening on the ground, which is we've seen drops around the country in students actually attending school since the time of the election. One of my initial responses to that was go to school until inauguration at least, right? But part of the reason for that is not only the concerns about very specific things like school resource officers being in schools who are also right. So how does that play out for kids? But also the ways in which schools are centers of community, and how that breaks down when there's not only a fear of what might happen to you in your school, but also what's going to happen to your family when you might get home. And that has played out in a way that really frightens me in terms of how it is that children are internalizing this. And so one of the little girls I met in Brooklyn, she's African American, 4 years old. Her name is Grace, and what she said to me was about the president was that he can't see my heart because he can't see past my skin. And if you think about what that means for a 4-year-old to be able to take that and how it is that she might actually look at the relationship not only between, how she's viewed in her community, how she's viewed in this country, that's the kind of thing that I think we're going to see manifest in a whole bunch of different ways in terms of how we see how young people see their role and their value and their dignity in American communities today. And I think that's one of the really powerful ways in which we're seeing this turn take impact. The other thing I would say is that part of what I think the role of the federal government and others have been is, and I'll use Ferguson as an example of this in some ways, which is we are seeing a nation divided, but it's also a nation more segregated than it has been in decades. And that's certainly played out in schools, and it certainly plays out in how that manifests itself in all kinds of different American institutions. And part of the difficulty of that is we are not, we've been, and we are right now, in a situation in which we're often defensive and reactive to moments of violence that are happening around the country. Part of the role of a longer-term engagement on addressing segregation, but also addressing some of these divides, and is to look at what leads up to those moments of violence. And so the reason I said I'd mention Ferguson is because a lot of the work on Ferguson were not just about the moment of violence that happened, was about the things that led up on a daily basis to that moment of violence. And I think what's important about our institutions will be to be able to look back and figure out what are the things that are leading up to those moments of violence today. So a couple of ways to start, but there's absolutely for children, it is, they're looking at a place where they feel unwelcome, where they feel like they are going to schools that are very much segregated, and there's a lot of fear, which is manifest in a whole range of ways right now.
And they're grizzly bears.
And they're grizzly bears and guns, as opposed to social workers and counselors and everything else we need.
So I guess, at the risk of, sorry that we've gotten really depressing in 20 minutes, but I think that was inevitable. So let me ask the horrifying question. We've been talking about this as very much a policy turn, right, and as a sort of on-the-ground reaction. The theory behind this conference is the future of the Constitution. How screwed are we? And I mean that quite seriously. Obviously some of this is a shift in enforcement priorities, right? Some of it is a shift in sort of emphasis, some of it is a shift in talking points. But insofar as law, legal doctrines, legal institutions, how big of a problem is this? What should we be looking for? How much sleep are you losing legally?
Legal sleep?
Legal sleep. Shireen, do you want to maybe start?
Sure.
There's a lot of places to go with that question.
Yeah, absolutely. Right, and one could answer it in many ways. I work mostly on issues around national security and discrimination, profiling in human rights in that context. And so on the issues that I am most focused on, in some sense, the constitutional doctrine has been unavailable, or in many ways, certainly from the perspective of being able to hold accountable government officials for rights violations for many years, and as a result of a whole slew of doctrines, procedural, substantive, rooted in constitutional law and other fields. So, and certainly that could be said of immigration doctrine as well, where if you think back to the idea of plenary power, the idea that the government can do in the immigration context, the kinds of things it couldn't do to citizens or in a non-immigration context. And these ideas have been very much part of the law for a long time. So the deference accorded to the executive branch of government is something that's well established in the law. And so in that sense, from the, that doesn't mean that we won't see courts responsive to the current political moment. And obviously with, in certain contexts, as in the travel ban litigation, we've seen courts actually, not quite for the first time, but certainly in a way that's much more significant than in the past, have actually probed government assertions, say, of national security interests in a way that they would have been quite reluctant to do before. I think when we're talking about constitutional doctrine, we're talking about a lot of limitations that have built up in a lot of areas of law. I mean, certainly we could, Chirag, I'm sure, would speak to this in the criminal justice and other contexts, but where for a long time the law has not been particularly protective, especially with respect to some of the issues most facing communities of color.
So can I push back? I mean, it's not push back. Can I ask you to elaborate? So is the problem that the doctrine isn't where we want it to be, right? So this policy shift, this rhetoric turn is capitalizing on holes in the doctrine, or is the problem that the substantive doctrines aren't meaningfully enforced?
Well, I think it's both. I mean, it's certainly the case that the substantive law, in certain respects, is not. You can think of any number of contexts, Fourth Amendment context and others, is not particularly protective. But certainly, it's also the fact that we've built up a whole range of doctrines that, in certain areas of law, prevent courts from even getting to the merits of the questions before them. So in that sense, the problem is a lack of enforceability, particularly in courts. And I speak of it, this is absolutely true of the national security context. It is certainly not only true of that. And in a number of areas of law, we've stripped away the ability of courts to engage in private enforcement. So if you think about changes in class action doctrine, changes in the rules of approaches to constitutional standing, the pleading standards, what you must show to be able to get your foot in the door in court, all of that has diminished the ability of litigants, of individuals, to vindicate their rights in court.
I can pick up on that. I think those same themes sound in the criminal justice arena in enforcing constitutional rights. You have the same hurdles. Section 1983 suits are very difficult to bring. Standing is very difficult. As a result, you don't have very robust private enforcement of constitutional rights vis-a-vis the police. And so there has become an increased reliance, certainly by the communities out in the country, at least during the last few years, on the Department of Justice enforcing these rights. The Justice Department doesn't face the same hurdles. Under a 1994 statute, that was actually a pretty horrifying statute, the Violent Crime Control and Law Enforcement Act. Overall, it's an omnibus crime bill that expanded the use of mandatory minimums and capital punishment, but it had buried within it a small provision that allowed the Justice Department to investigate police departments for patterns and practices of misconduct, and to seek judicial relief if they found reasonable cause to believe there was such a pattern or practice. And the Justice Department started using that in the mid to late 90s, not as much in the 2000s, and then quite robustly in the Obama administration. And that's what we're talking about when it was Steve and Anurima referred to Ferguson, Chicago, Baltimore, and a number of other very high-profile cases where we went in and found, based on our own investigation, cause to believe that there was a pattern or practice of unconstitutional stops, searches, excessive force, discriminatory policing, things that are very difficult to prove, partly due to not having access to the evidence, and then partly due to the procedural hurdles that Shireen mentioned. So, to Steve's question, I am worried. I do think we should be worried, firstly, because we no longer are going to have the federal government doing this work. That became very clear 2 weeks ago when the Justice Department, or I suppose it was last week, Monday, where the Justice Department
Weeks are long these days.
They're really long, yeah. The Justice Department released a memo where AG Sessions asked for a complete immediate review of all consent decrees existing or contemplated, as well as a number of other things the department does in the area of ensuring constitutional policing. And that same day, the Justice Department asked for delay of the fairness hearing for the consent decree in the Baltimore case, where the Justice Department had already entered into an agreement to reform the Baltimore Police Department, and were just asking at this point for the court to enter it as a court order and to exercise continuing jurisdiction over it. I mean, we're way past the point of trying to pull out. And I should say that in my experience, it's usually the defendant that tries to pull out of this kind of an agreement, not the plaintiff, not the Justice Department. But that's what happened. And luckily, the court denied the motion to continue and ended up having the fairness hearing and entering the decree. But the challenge, though, is that the Justice Department is tasked with enforcing that agreement. And so who's going to bring a contempt motion if Baltimore doesn't do what they say they're going to do in the agreement? And Actually, I'm actually not sure if they entered the decree. I'll have to look back at that. But it's quite clear that the judge will enter the decree. But it's up to the Justice Department to bring a contempt motion if the parties don't do what they say they're going to do. It's up to the Justice Department to help select the monitor who's going to oversee the compliance with the decree. And the memo makes it clear that the Justice Department wants to back out of these agreements in other places as well. The narratives coming out of the Justice Department are that these agreements cause police to be less proactive. Depolicing is the idea. Some in this camp have called this the Ferguson effect. So the idea is that police officers, because of scrutiny, will do less work, will make fewer arrests, will make fewer stops, which in some cases may be a good thing, but across the board is the idea, and thus crime will rise. And there's no evidence to support this at this point, but that is the narrative coming out of the Justice Department. So my number one concern is that we won't have federal enforcement anymore. The other thing I'll say is that there are internal conversations that go on within the Justice Department about what legal positions the department will take on key cases. And this is where I think we get closer to your question about what is the impact on constitutional law. So the outcome of cases at the Supreme Court. And the Civil Rights Division is a voice for robust interpretation of the Fourth Amendment. And so there are meetings where the Solicitor General's office will convene all the different parts of the department, civil rights, the civil division, the criminal division, and ask for opinions. And we are often the lonely voice sticking up for the Fourth Amendment. But because we enforce it in both the criminal context, criminal prosecutions of officers, as well as in the civil context I've been talking about. And there are cases, the Justice Department is first and foremost a law enforcement agency, so it tends to weigh in on the side of a narrower interpretation of the Fourth Amendment and of doctrines that allow plaintiffs to bring suit. But there are cases where we at the Civil Rights Division, in my view, limited the damage, so got the department to take a less robust position. And just one is pending right now, the County of Los Angeles versus Mendez. It's a case that involves the provocation doctrine out of the Ninth Circuit. Can you take into account the idea that a police officer may have committed some misconduct or engaged in unreasonable conduct that got that police officer into a situation where they then have to use force, perhaps deadly force? In that case, police executed a search without a search warrant and without knocking and announcing as they should have. The person inside the house or the home moved a gun, and police shot that person and the person sleeping next to that person. And the question is, well, can you factor that into the constitutional analysis? And if you look at the Solicitor General's position in that brief, it is restrictive, but it takes the position that there can be tort liability if there's misconduct early on for that, as long as you can show that the initial misconduct, so the warrantless entry, was a proximate cause for the ultimate harm. And that's a position that this Justice Department might not take. And so I think we are going to start to see shifts like that may not be visible to the public, because the public might not know how these things go on within the Justice Department.
So I want to sort of take the sort of moderate out of moderator for a second and just amplify a point here. I mean, I think Shireen, there's even more, I think, to what Shireen said about the shift away from private enforcement, right? I mean, so if you got law students of the world take federal courts, right? You guys are like, I am. It's hard, right? In the last 25 years, right, the Supreme Court has been increasingly skeptical of implied statutory and constitutional causes of action, 1983 cases. The response has always been, we don't need private enforcement because federal enforcement is available and robust, right? And this is true in the educational context. It's true in the law enforcement context, right? I guess my question is, should courts take into account a shift in DOJ enforcement priorities, and do you have any faith that they will in thinking about when there should be private litigation available in these contexts? I don't know, Anurima, if you want to say anything about that, or put it back to Shireen.
No. I mean, so the answer to should, I think yes. I think there's going to be not. I mean, so I entirely agree with Shireen about the mechanism to actually have private enforcement, and we've seen the dismantling of that in the race context for many years in terms of the ability to bring any kind of cases around racial discrimination, and in particular limiting it to actually have to meet the very high bar of having to show intentional discrimination in the race context, and certainly we've seen it in the context of harassment and sexual assault as well, and so I'm very much concerned about whether or not there's going to be an ability to bring causes of action in courts. And so with the absence not only of the Department of Justice, but the administrative enforcement processes that a lot of agencies had. So the Department of Education had its Office for Civil Rights, which was really the sort of driving engine of a lot of the administrative enforcement work around things like Title VI of the Civil Rights Act, which looks at, and Title IX of the Education Amendments of 1972. So when we think about that piece of it, the fact that there might not be, and I don't want to say there's going to be no mechanism, but there's going to be certainly a broken down, hampered mechanism for any kind of enforcement. Where do people go, right? And where do you take your complaint about what's happening, what might be happening in a local community? And so, and I'm jumping to a different part of this conversation perhaps, but I think there's two ways to think about this. In one way, it is that that we have to that the courts need to sort of step in both short and long term in how to think about having a place of remedy for what's happening in communities and all the different things we want to talk about. The second is, how do communities actually think of this as an opportunity for them to build accountability measures themselves? And so that's a place that I think we should talk a little bit more about later on.
Shereen?
Yeah, I just wanted to say that I think it's important not to think of the Obama era as one in which private enforcement was unnecessary because you could count on the federal government.
Because the unicorns would do it.
Sorry. Yeah, I mean, I think just in general, I mean, private enforcement is always a supplement to whatever other channels of rights enforcement there are available. So even to talk about the Justice Department's work in the policing context, where I think they did do some incredibly important work in Ferguson and many other communities. But there are some 20,000 state and local police departments around the country. So even if you are able to do incredible investigative work and get some wonderful consent decrees, changing policing practices in a few dozen of those departments, that leaves tens of departments elsewhere in the country that are at least not directly affected and that themselves may need reform. I think also there's a danger in, because the Trump administration has shifted our conversation and policy so much to the right, the framing sometimes ends up being that, well, what the Obama administration did is kind of the height and of what progressives could or have been able to do, should do. And I think it's a little bit dangerous to fall into seeing that as kind of the outer limit of social justice, the best that can be expected. And I just want to give a couple of examples, again, from the immigration and national security context, because while the Obama administration did remarkable work in the policing context on issues involving transgender rights, on prosecution of hate crimes.
Although I just got a news alert that DOJ has dismissed the lawsuit against North Carolina for over HB2. So.
Okay. Yeah. So there's been tremendous work in certain areas. At the same time, you look at some of the positions that the Obama administration took in court in the past year on cases involving immigrant detention, where just this fall the government took to the Supreme Court a case in which the Ninth Circuit Court of Appeals had set limits on the length of time that immigrants could be detained long term without getting access to a judge who could essentially give them an equivalent of a bail hearing. Or you think about cases like the Abbasi case before the Supreme Court, where the Obama administration, again, in the last case that it argued, right before Inauguration Day, asked the Supreme Court to create, essentially a near blanket exception for national security and immigration policy decisions in terms of the ability of an individual to sue for constitutional rights violations by federal officers. For damages. But those are just two examples of positions where you can look at the Obama administration and ask how much it was willing itself to limit accountability for rights violations.
So I'm really glad you brought up Jennings and Abbasi, because what I'd love to do is pivot a bit to the Supreme Court specifically. We have these two major challenges to the travel ban. Right, there's the one in Hawaii, which is now on appeal to the Ninth Circuit Court of Appeals. There's the one out of Maryland that's now going to be heard by the full Fourth Circuit on May 8th. We have these really, I think, underappreciated major immigration cases already before the Supreme Court. I would add to Jennings and Abbasi the Hernandez cross-border shooting case, but I'm biased because I'm co-counsel to Hernandez. And also the Castro case, the Supreme Court might deny cert in as early as Monday, right, about whether undocumented immigrants are protected by the suspension clause. It seems like wholly apart from, and even before, right, whatever's happened since January 20th, we were already at this really interesting pivot moment in the constitutional law of not just immigration specifically, but sort of anti-discrimination more generally. And I guess I'm wondering if you guys have any. Hope is too strong. I just watched Rogue One again the other day, right? You know, a movie all about hope where everybody dies. Spoiler alert. Rogue One? If you haven't seen it yet, there's got to be a moving wall. Come on, it's like, you know, if I spoil the ending of Titanic, the ship sinks. I really don't feel like I've done anything. Okay, anyway. But I guess the question I'm trying to ask, right, is wasn't this already happening? And do we have any faith that the Supreme Court is actually going to be responsive to what it reads in the newspaper? And by the Supreme Court, let's be clear, we don't mean the Supreme Court, we mean Anthony Kennedy. Right, that Anthony Kennedy is going to read the newspaper and say, maybe now's not the best time to cut off damages liability for government abuses in the counterterrorism sphere. Maybe now's not the best time to say undocumented immigrants don't get habeas. Maybe now's not the best time to say there's no limit on immigration detention. Am I just overly optimistic, or is this actually something that might happen?
I think it's possible that
4%?
Well, look, I think for courts in general, so I mean the Supreme Court or other courts, they are aware of what's happening nationally. I'm going to steal Chirag's the phrase he used in a recent blog post, which is the explosion of the myth of a post-racial America, and the idea that when you see hate crimes, discrimination kind of across the country, this resurgence of white nationalism, a lot of things that were under the surface kind of becoming much more explicit. I do think that courts may reflect that and think twice before kind of frankly resolving cases on equal protection in other areas in the way that they've done for a long time, which is to discount the durability of racism and intentional discrimination and so forth, and animus and all of that. So I think that's possible. At the same time. It's both that a lot of these doctrines are so rooted, and that in general, I think the courts are not kind of the place where you see radical social change occurring. And so this is more of a general comment on kind of the expectations for the judiciary, and the fact that, in my view, courts are often much more responsive to social movements than they are kind of leading those movements. Yeah. So to the extent that we're looking, you asked before we talked, are the courts going to save us? And I think the courts are going to save us if the people save us, that it's not simply about looking for kind of this heroic role.
But in what order? I mean, right, so and maybe Henri, right, we were talking last night, the great debate, right, about Brown versus Board of Education is, was Brown and the litigation that preceded it the spark that led to the political movement, or was it were there political conditions that actually allowed the Supreme Court to decide Brown? I mean, without answering this 60-year-old academic debate, is that sort of what Shireen's teeing up? Like, are the courts first movers here? Because if for no other reason, no one else is.
So I share the skepticism about the courts being first movers, and I think that's always played out in whether it be in the Supreme Court or in lower courts as well. I do think that there may be a different feeling among the judiciary about their role in a checks and balances system where they're explicitly under attack by the executive branch, and in a way that I don't think the courts have been attacked in this way previously. And so the question of who becomes, again, who takes on this role of being protector of marginalized communities around the country is in flux. It's in shift, and I don't know where it ends up landing. But I do think that courts, at least in this short term, and some of what we've already seen, right, which is, you know, in the voting context, being another place where the Justice Department made a change in their position in terms of in voting and whether or not they were going to support a intentional discrimination claim. You see that the court's stepping in. We see it in the travel bans process. And so it may be that we do see the courts taking on a role of at least holding a line. That is different, however, than saying that they're going to be the ones pushing that line. And so I think the question is the protector versus the, how do I want to describe this, the positive aggressor, the person who's actually going to move some of this conversation and also some of the work forward at a time where I think, again, I'm going back to the fact that I think in many ways that Brown is a great example. You know, we had eras of progress, and we're in an era of retrenchment, and we haven't seen, back to the same question of like where we've seen sort of legal movement, we haven't seen a new sort of a case to address school segregation in more than 20 years, right? And so how do we think about, that doesn't mean we don't have those cases, we have about 180 of them in the Justice Department, but it does mean that we don't see the kind of, that kind of movement in places where the conditions in the country at this time are as bad as they were back in the time where we saw the court take on a much more robust role. I worry about the fact that, you know, we had these movements, we had the courts coming into play, then we had, you know, chipping away at that for a very long period of time, and now we're back at this place where we see the kind of divides, we see the kind of segregation, we see the kind of concerns about marginalized communities, and what do we have available to be able to address that by way of courts other than holding those lines?
Yeah, I mean, I wrote a probably unduly optimistic blog post about how courts may react to this moment in being more protective of rights and rethinking both some of the procedural doctrines in the criminal justice space, and I'd say civil rights more broadly, that have prevented litigants from moving forward with cases, but also maybe broadening their view of what the constitutional protections are in the first place, substantively. And, you know, to your question, like Steve, you asked, will the courts maybe step in or broaden doctrines because they see that DOJ is not doing the work anymore? You know, there's one case that I came across in my time where I saw that argument sort of in play, and it was the Strieff case. Utah versus Strieff was a case where an officer was watching what he knew was a drug house, or he thought was a drug house, stopped an individual who came out of the house, but actually didn't have reasonable suspicion for that stop. He actually wasn't paying attention to when the person was coming out of the house when they left. Stopped this person. The government, in that case, Utah admitted that, or the local government admitted that they didn't have probable cause. Reasonable suspicion for the stop. So clearly unlawful stop. The officer then asked the individual for his license, runs the license, finds an outstanding warrant, conducts a search incident to arrest, and finds drug paraphernalia on the person. And the whole question is, does the exclusionary rule apply? Do you suppress that evidence? And the court ends up holding in that case, no, you don't. The exclusionary rule doesn't apply. The warrant is enough to attenuate the taint of the stop. And this bitterly divided the court, very clear divide in the court. And one of the arguments made by the Solicitor General's office in the case, which took the position that you should not apply the exclusionary rule, don't suppress the evidence, was that, look, to the extent that you, justices, are worried about systemic misconduct, we have DOJ to investigate those kinds of cases. And this idea, I mean, Ferguson specifically appeared in the oral argument, in the briefing, and in the opinion at the end of the day in Justice Sotomayor's dissent. Ferguson is a place where in a single year they issued warrants on 9,000 people. That's a city of 21,000. And even if you take the fact that there are people from neighboring jurisdictions that were coming through the town and maybe picked up charges, failed to show up for court, and got a failure to appear warrant, it's still an incredibly high number. There was a time when 16,000, at the time of our investigation, 16,000 people had warrants outstanding on them in the Ferguson Municipal Court. So the justice's concern was, well, what about these places where everybody has a warrant? Isn't there concern that the police will just stop someone knowing that there's a pretty good chance they're going to be able to keep whatever evidence they find on them because they'll first run them for a warrant and then conduct a search? And the Solicitor General said, no, don't worry, the Justice Department is here. And I don't think that argument carried the day. I think the justices were going to come down where they came down. But it was clear that the justices were thinking about this issue of systemic misconduct in a way that they had rarely done in previous cases.
And it sure pissed Sotomayor off.
It did, yeah. I mean, her dissent was amazing, and I think folks should read it. It shows sort of how far the law has changed to be protective of officers and to be to not protect the rights of individuals interacting with them. So I think they're aware. I think they're aware partly because the Justice Department did an investigation, but more because there was, at that point, for more than 2 years, a movement going on in the streets around America where people were responding to police violence and discrimination. So the question is, what do courts really react to? I think it was helpful to have DOJ there, but they're going to react to the popular sentiment. And so I am hopeful that courts will step in. I think we've seen some of that, but I think the sort of institutional biases that exist will continue, and where the court is most likely to be a check on, or protective of constitutional rights, I think it's going to be in being a check on the executive. So where the executive branch now is actually violating people, progress, I think, on the travel ban cases. Whether that makes it, how that comes out at the Supreme Court, I think is a question. But I think probably the most movement we're going to see is courts realizing that they have to be a check on this federal government.
So, I mean, I guess, and I wonder in that regard, I mean, Shireen, we saw some of this, right, in the Bush administration, that the Supreme Court's reaction, especially to post-9/11 counterterrorism policies, was very much about preserving institutional roles and not about individual rights, right? And that indeed, once the court really finished asserting the institutional role of the federal courts vis-a-vis the political branches, they largely receded? Or is there something different about the sort of the turn we're seeing today from the sort of scope of the authority that President Bush was claiming early after 9/11?
Yeah, I was actually thinking just of that as we were having this conversation, because it is certainly is one explanation for why the Supreme Court stepped in for a period of about 4 years in the post-9/11 environment. You know, the concern there's a series of cases involving Guantanamo detainees, and the court, at least in particularly Justice Kennedy, was very concerned about the court itself having an institutional role and the executive not being kind of the final say. How will this play out in these cases? I mean, part of the question really relates to which courts you're talking about, and I do think that for a lot of lower court judges, concerns around discrimination, concerns around individual rights are preeminent. And so, why we've seen certain judges, certain district court judges respond to the travel ban cases, I think, is the fact that they saw evidence of invidious intent. I mean, we all saw the evidence of invidious intent that was so kind of bald on its. Sorry?
He didn't mean it.
He didn't mean
He
it.
says
Right,
lots
of
of
course.
things over and over again.
Right. No, and it was right. It was all before the election. So once you take the oath of office, everything in your views change, right?
In the last week, everything has changed, right? I mean, NATO was irrelevant. Now it's not, right? North Korea was not worth talking about. Now it is. I mean, sorry, I'm just.
Yes.
I'm not
No.
even really trying to play devil's advocate. I don't know what.
Right, so I do, to get back to it, I do think that for certain judges, that sense that we are seeing kind of overt prejudice, of a kind that used to be more hidden, will affect the way that they approach cases, and the sense that the judicial role is partly to protect minorities who may not be, whether it's racial, religious, or anything else, but those who may be less protected in the political process. Although at this point in time, it seems like that really encompasses. Everyone, minority or majority alike. But that view is something that a lot of judges will find to be important. Now, at the Supreme Court level, I don't know. I do think that, judges like, including Justice Gorsuch, do care about the institutional role of the judiciary. I don't know how far they will be willing to go to, for example, to identify discriminatory intent if they can point to, say, plausible, national security interests for a policy.
So I want to sort of take the point that you made, which I thought was very powerful, about how courts can sort of draw the line, right, but they can't necessarily push the line. If that's true, right? I mean, if Chirag and I have too much faith in the courts, which I'm sure we do, who's left? Right, that is to say, if there's a problem and it needs to be solved, and the courts are going to sort of hold the line but not advance things, for folks who care about these issues, for folks who are interested in in pushing back against these trends, I assume the answer is not Congress as the bastion of protecting underrepresented groups. But so if it's not Congress and it's not the courts, I suspect it's not the executive branch. We're running out of institutions, aren't we?
Right. I'll change one word in that. I'm not sure. I think that the courts can't push the line.
Well,
The point was whether they would.
Right.
I think there certainly have been times in history where they have pushed the line. To what extent and how much that was important, we can debate. But so this is my moment of optimism of a different sort, which is, I mean, certainly around the country, the conversation since the election and certainly since inauguration has been one about how do we sort of return to local and state institutions and mechanisms and process, and so and a lot of that has been around making sure that we have people run for office. The other way in which we can think about some of this is that and I just want to pick up for a second on Shireen's point, which is the federal government had pretty limited resources to do the kind of work we were doing in civil rights enforcement. And so that means that the vast majority of complaints that were coming in on any issue, we weren't really addressing. So there was a certain way in which what we were trying to do was retail work that had wholesale impact, right? So we would do a few cases that would then sort of signal to the country how to look at those issues in their jurisdictions. But the other ways, and I'm coming back to your question, I'll just for a quick.
My students don't answer my questions either.
No. I want to note a couple other things, which is, and particularly since we just saw the HB2 litigation pulled, is that part of the way we worked on something like transgender rights and is we had multiple different forms of doing that, which is there was the work that was done in actual cases with schools around the country and resolution agreements that came out of that, and that was a couple of years of work. There was work around what we would call statements of interest and amicus briefs, where the United States was coming in and saying, here's what our view is of a particular issue. And then there were things like the active litigation around something like HB2. But there's just lots of different ways in which you see, you saw sort of influence. And the reason I'm raising this is because the last thing we did, which was really engage in a whole bunch of different ways, different forms of guidance to schools and communities, and frankly to law enforcement around the country, is also incredibly important. And the reason we did that is because people were asking all over the country for help about how to address some of these questions. And I think that is a place where, with some of the tools that might have even come out of the last administration, there are not a lot of them, but there are some, is to really think about how it is that communities can now, this is where I'm optimistic, communities can now play a role at looking at accountability, even, so I'll take something like a school harassment case. Incredibly difficult to get through the courts, both because of the standards and because of the process. And by the time you go through the courts, you're going to have someone who is likely graduated. So the question is, what do communities do about that? And what I'm hoping is that there are ways in which some of the tools that have come out of this past administration, but also that are really in local. There's a lot out there to try to address some of that within communities themselves. And my view of the Justice Department was, while we were there, was that there was a lot of, like, again, where I started, there was a lot of hope and a lot of energy channeled towards the federal government to try and come in and address some of what was going on in communities. What I would want to have happen is this be a moment of opportunity where people think, okay, well, if we don't have that, how do we actually sort of address some of this on our own? Which is ultimately what all of the consent decrees and the work that we're doing is trying to get at, which is equip communities to be able to do some of this in a sustained way on their own. Because there's not going to be a federal government that's going to be sitting there for long periods of time, with maybe the possible exception of school desegregation cases where the federal government's been involved for decades.
Yeah, just to build off that, I think this is a moment where liberals are suddenly going to find themselves embracing federalism.
States' rights.
Right. We're all states' rightists now, and I think that unfortunately that's where we're going to have to go. And partly, who do we look to as the champions of defending constitutional rights and the rights of the vulnerable? In part, we look to the states through the courts. Some states and some cities, right? Indeed.
Some of us live in states that are further to the right of this one.
Your state is rapidly changing, though.
Not fast enough.
At any rate, we've seen lawsuits brought by state governments and by local governments. We've talked about the travel ban, but also the challenge to the threat to pull money from sanctuary cities, right? Santa Clara County, San Francisco, a couple of cities up in Massachusetts. They're going to be leading the charge on this. Now, that's still through the courts, and I think there are going to be some challenges there, but they've got some good arguments in that set of cases. The other thing, though, is that we may want to just stay away from the courts for a while. I think what Don talked about, this being a moment of promise last summer, there are a lot of constitutional doctrines that could be on the table, maybe bring them back to the court. Now, not so much, and if this president gets a second seat on the Supreme Court to fill, I think progressives would do well to stay away from it for quite some time. And in the criminal justice sphere, which is where I focus my energies, there's quite a lot that can be done apart from constitutional law. I mean, it's satisfying to bring cases to change the meaning of the Fourth Amendment, but what you're really concerned about is individuals' lives and how they interact with the police and in building trust between communities and reducing violence, there's a lot that can be done through, at the very granular level, what policies govern the operation of your local police department. And in that sense, the Supreme Court is far behind, where local governments are. I mean, look at the Plumhoff case, where the Supreme Court approved shooting at a vehicle after a car chase. It is becoming a best practice in police departments around the country to ban shooting at vehicles. So where the field is, this is chiefs and police professional organizations, is 180 degrees away from where the Supreme Court is on that particular issue. And there's a lot more in that vein that can be done through the democratic process, through community engagement, change the way that police interact with their constituents.
All right, so you guys are being way too optimistic. So let me sort of inject a note of skepticism as someone who lives in Texas. Well, actually, I live in Austin. But we're surrounded by Texas. And this is relevant, right? Because, so Austin is, perhaps not surprisingly, right, a sanctuary city, right? Austin is a very progressive place. And Austin is under siege from its own state legislature, right? The Texas state legislature is basically trying to pass a law that will send the sheriff of Travis County, Sally Hernandez, to jail because she's refusing to comply with ICE detainers that she thinks are unconstitutional. Right? So I don't know that maybe, where you stand is a function of where you sit. I sit in a state that may be trending purple, but that's holding on to, the red part of purple as hard as it can. And I guess I'm just wondering if, the local focus, right? The focus on local organization, local community building, local and state government is going to be super effective, Shireen, in your state, right? And maybe in yours, right? And not so much in mine.
Yeah.
And that will further polarize and further exacerbate the schism.
Yeah, I think we need to take the long view on this. And of course, there's going to be tremendous resistance. No social movement ever succeeded without encountering tremendous resistance. And sometimes the resistance is what impelled a movement to move forward in any range of contexts. David Cole has this book on, Engines of Liberty, the power of citizens activists to make constitutional law. And it has these great case studies of the marriage equality movement, of on the right, the gun rights movement, and about how those movements were built over many decades largely at the local and state level. And so if you think about these issues not in terms of the pushback that they're going to get now or tomorrow, but you think about this in a 10, 20, 30 year frame, because it's not just the onslaught of current policies, but it's about building communities that are not just going to push back against the ICE raids or ask for sanctuary policies today, but continue to work at the local level for policy reform, and then spread that where possible, to the national level over a much longer period of time.
So the future of the U.S. Constitution on our issues is very much one that should be looking at local, ground level operations.
I think that's where it starts. I mean, of course, we would want to see, eventually federal constitutional law embody those changes. But, my point is that they don't, it doesn't begin at the top. It begins and grows and gains force from, the actions of many people over a long period of time, and usually with quite a few setbacks in the courts and otherwise before there's actually progress.
I'm not sure how this plays in, but I think that one of the things that the question of sort of where do we see locus, like the places of energy right now, and certainly there's energy around the country, and that's part of the reason for my optimism is like how do we actually channel that energy that's around the country that I don't think I've seen in my lifetime, and certainly want to figure out a place for it, and the place for it may not be what a lot of it has been, which is calling representatives or trying to actually figure out, and that has been reflected. And the energy has been reflected in some of what we've seen in the courts already, but I also just think let's take one of the many news stories of the week, United Airlines, like and part of what.
What did they do?
Yesterday there was a scorpion on a plane, so
Which they didn't throw off.
I feel like I set that up so perfectly for you. So I'm not going to talk about United Airlines other than to say this, which is one of the things that it reminded me of was the similar video that came out a couple years ago of a young girl in a high school in South Carolina, and she and a school resource officer went in, pulled her out, and dragged her across the room, right? And that's the first thing that came to my mind when I watched this video. And part of the reason I'm raising this is because in some ways we've started to look enforcement or to police or to force as a way to address what's going on in our classrooms, what's going on, in interactions on planes, what's going on in a whole bunch of parts of our communities, and the reason I'm raising this is because I think part of that process, right, which we don't outsource the process of actually trying to figure out how we address issues that are coming out to force or to violence or to policing, and so it's not only how do we actually bring some of that energy in to figure out how, so my advice to most people when they ask me what to do these days is like, how do you actually interact with people who are directly around you, and figure out how to address that, because that's in part where not only do we sort of, the change that we're seeing around the country is in part what's being signaled as norms from the federal government, and those signaling is the signaling of norms that might be very different, explicit signaling, which is part of what we're dealing with. The way to counter that is to really sort of change some of the norms that we see right around us, and so and that I think is a different way to look at what the future of our communities will be, and then consequently over this long period of time, some of the future of our Constitution.
It's been a rough week on the PR land. Although the Pepsi people are very happy.
Yes.
Right. The United did them a solid. And then Sean Spicer, well, okay. Anyway, so we've been talking a lot. You guys have been very patient. I want to give the audience a chance to ask questions and or make comments that we prefer in the form of questions. Dawn.
Thank you for calling on me first here, and I apologize for jumping in, but I just want to put two things on the table. One, Bloomington very much like Austin, Indiana very much like Texas, and so that's a problem. A lot of time about cities driving progressive change, but the states are here in Indiana as well, in a whole range of subjects taking authority, trying to take all authority away from cities. More important, I want to talk about the Office of Legal Counsel, the Department of Justice. So really depressing to hear about, actually I think I'm supposed to be using the microphone, so I'm sorry.
This one coming to you.
Great, thank you.
Two coming to you.
Thank you. I think this might be important for recording purposes. So my first point was just that cities need to be important players, Bloomington, Austin, and states like Indiana, Texas, but the legislatures are wise to that and trying to take away that kind of authority on a range of issues. So, second thing, really depressing to hear people from the recent administration, Department of Justice, talking about what, in detail, even more than I kind of remembered, the law enforcement role includes and what's going to be lost. I also want to mention the Office of Legal Counsel, where I worked in the Clinton administration, is a very important, usually behind the scenes, constraint on the executive branch doing illegal things. And the point about immigration, national security, areas where the courts just never have played much of a role in individual right protection is in part the internal role of the lawyers advising the president, because the question, traditionally bipartisan, is what is legal, not what can we get away with in the courts. I mean, that's what the president's advisors should say. So just want to add, when that broke down in the months and years after 9/11, the courts stepped in, absolutely, and hopefully will again. But important specifically to call the president's lawyers on that, and that, remember the uproar about the torture memo when it was leaked from the Department of Justice that basically said the president can torture people even though Congress said he can't, and really deviated from that institutional role. That's another thing to fear from the current administration, and something that I think is really important, that especially people who have served in the government before, and David Cole's book is, I think, amazing on this kind of point. All citizens and persons affected, to call on the government, even if the courts don't step in this extraordinary time, it's another pressure point, hopefully.
So I think that's a really important point, Dawn. I would just say, for the bureaucracy internally to be a check on the political actors, there has to be a bureaucracy. And I think one of the most underappreciated and, to my mind, alarming sort of structural developments of the last, guys, it's only April, 3 months, right, has been the number of senior internal legal positions in particular that not only haven't been filled by the Trump administration, but haven't even had people nominated for them. Yes, there's a graphic out there about how like the top 30 some odd jobs at the State Department after Tillerson have no nominee and are empty. But the one of those that's the most important is the legal advisor, right? There's no nominee for OLC, right? I suspect you and I both know folks who have been considered for OLC and were rejected by Sessions, right? Like, it seems to me that you need lawyers in order for the lawyers to push back, and that's actually an issue.
Yeah, I just want to. I agree with that, and I just slightly disagree. That I think it could be a good thing that a lot of these political positions have not been filled, given the folks who are in place right now. Yeah. I'm more concerned with the wall that should exist between the Justice Department and the White House on investigative matters and sort of legal rulings like those that come out of OLC. There should be.
There's a wall?
There's supposed to be a wall. There was a wall when I was there. The wall famously came down during the Bush administration. There were congressional hearings about that wall coming down, and lawsuits and an inspector general investigation over the politicization of the department. And so I think what we need to watch very carefully is the career element of the bureaucracy, right? 99% of DOJ are the career appointees. They're employees who are there not because they worked on a campaign, not because they have some partisan affiliation, but because they're qualified for the job. And so if those people start leaving and get replaced by people who do have some kind of loyalty based on party, And for those who don't know, during the Bush administration, a guy named Bradley Schlossman at the Civil Rights Division went through resumes and was looking for signs of being loyal Bushies and good conservatives, good right-thinking Americans, and would look for people who are pinkos or commies or part of the Politburo to sign immigration cases.
So Michael Flynn was not eligible.
But
No. How can I not make a Michael Flynn is a Russian joke? I don't know.
At any rate, I think that's where the action is, and I'm actually heartened that not that many positions have been filled at this point, because I think that means that the career officials who are still at the department have a little bit more influence, and it's a smaller group of highly charged political folks who are trying to drive things in a different direction.
And let me just build on a little bit. I mean, I do think that, so first, there are a lot of career people within the Justice Department who have withstood these transitions before, who are not leaving, in many ways. And I think we have to think about their role and the importance of their role more broadly. I think people underestimate how hard it was to get even in the Obama administration, to get anything out the door that was even in the slight bit controversial. And so most of the battles that on any issue that I worked on, or my team worked on, were internal battles, both within the Justice Department and with other agencies, and in some occasions with the White House. And so, and there's good reason for that. So part of the, and I think about something like what happened with the state anti-immigration laws, HB 56, SB 1070. Those were long conversations that occurred that I think led us in some ways to particular positions that were informed by a variety of perspectives. So while I certainly agree that there is this incredibly important internal checks and balances role to be played. It is, and that maybe in some ways, not having people in these positions can allow for some space for work to happen. I do think that just the practice, the process, the idea of valuing the process of any kind of position going through a robust conversation within the Justice Department, that's also what we're missing. I mean, that was absolutely true in any kind of conversation about what happened with the travel bans, which was it didn't go through any of that kind of process. And I worry about things being proclaimed without that, regardless of who's part of that process, that there's some value placed on it, to begin with, which is what in many ways, even though it's difficult, should be what happens.
I two short defenses of why I also think the political positions are important, right? I mean, I think you guys are exactly right. I would just add, for the positions that require Senate confirmation, the confirmation hearings themselves, I think, can be very useful, right? Not because the Senate Democrats are going to block any of these nominees, but because they can at least put things on the record.
Because you might say something that might give rise to a perjury charge at
You
a
might.
later date.
I mean, You might, Jeff Sessions, right? But that. I mean, look at this is a really random example, but John Brennan's nomination to be CIA director turned into a national conversation about drone strikes, right? Because one senator, Rand Paul, wanted to use, his authority to filibuster, to force concessions out of the Justice Department. I'm not saying that's going to happen here, but there's at least some marginal utility. But also that those people can also be canaries in the coal mine. I mean, yes, we'll notice when when civil service folks in the Civil Rights Division are leaving, but it's not a national story the way that if the head of OLC resigns,
Yes, right.
In protest over being asked to do something he didn't want to do.
I don't disagree with that. I think, of course, you need people in these positions. You just want people who are going to be independent and who are going to fulfill the responsibilities of the job. When you have the Attorney General making speeches about what the enforcement priorities are going to be, as he did this week in terms of immigration cases, and framing it as the time of Trump, it looks like that wall doesn't exist in the same way. So if that wall stays in place, then absolutely we need to fill these positions and have these folks do their jobs.
Of course, if the president's tweeting at the FBI to go find the leakers, that changes things. Questions? More questions?
There's a lot of them.
Jamal.
Thanks for all these comments so far. I guess I think a lot of us have the feeling that that this administration sort of acts along the lines of the Trump campaign itself, which was just kind of play a strategic game of whack-a-mole where there are so many different places to fight, and then the next week there's another one, next week, and the next one may not be related to the last. And I wanted to ask about immigration in particular along these lines, where there are the sort of headline cases of, well, I'm going to build a big beautiful wall, and even the travel ban to some degree as what gets all the attention, but there's lots of other policy proposals that are, to my mind at least, as troubling, from expanding detention, from changing procedures for who can get picked up and where, giving wide discretion to ICE without a lot of policy guidance. I'm sort of wondering on that issue in particular if there are where should one's energies be focused? Are there sort of stealth issues that aren't getting attention that are worth surfacing a little bit more?
I'm going to send this to Shereen in a second, but I think that's true of every area, right? Which is there's the big headline news, and there's a lot of conversation about every time there, and then there's so much that's going on that's invidious and incredibly damaging that might not be what's in the headlines. So and there are wins that are happening. For example, the numbers of people in the last month who came across the border is, I think, something like 85% down. So the way in which signals, not even just policy, but the way in which some of the signaling is actually changing what's happening on the ground. So I think that's true of everything. And I think the question is, like, for lawyers is who's on the big headline processes. It's also true for people in communities around the country. People like to be on the hot topics, and so I think in some ways people are missing all the other ways in which we're seeing dismantling occur. As to the substance of it, I will hand it over to you.
I'm actually not an expert on immigration, but I will say that first to just second your thought that much of what's happening that's so pernicious does go below the surface, and that actually I think connects to the earlier conversation we were having about courts, which is that courts in some ways are very responsive when there is something like thousands of people showing up at airports to protest the travel bans, but the kind of day by day moves in the immigration space, the number of changes that you mentioned, reduced procedural protections for individuals, at all points in the detention deportation process, just stepped up enforcement of immigration law, the widened expansion of sort of who's thought to be a priority for deportation. I mean, that itself is huge. The idea is supposedly that we're targeting criminals for immigration enforcement, and then of course the concept of who is a criminal is just about anyone potentially. I think it's absolutely right that those are issues that don't get as much attention. I mean, to me, that also connects back to the conversation we were having about why local activism is so important. I have the privilege of living in California, where there is a lot of this. But just in seeing how communities, faith communities, progressive activist communities, folks from all kinds of walks of life have come together to form rapid response organizations to respond. So if there's news of an ICE raid, the word goes out to people who are committed to being there. If nothing else, just to witness. And also, frankly, it's just that having that sense of solidarity and support can be important when part of what is so pernicious about all the policy is the fear, the shockwaves of fear that it sends out across communities. So just having a group of people there, ready to be there, to see what's going on, to observe, to point out violations potentially, and to connect individuals with lawyers who can represent them in very individual cases that are not likely to get the headlines at all. I think that's extremely significant, and that can only happen at the local level.
And I'll just add, Jamal, on the immigration point, you hear a lot in my neck of the woods about the sort of ramped up raids, about ICE going into ICE and CBP, right, going into sort of neighborhoods, going to courthouses. So with that in mind, I mean, I actually think one of the most remarkable documents I've seen in the last couple months is this letter from late March that Attorney General Sessions and John Kelly, the Secretary of Homeland Security, sent to the Chief Justice of California, right? So the Chief Justice of California wrote a letter to the Justice Department, Homeland Security, saying she was very concerned about reports that customs immigration agents were, in her words, stalking courthouses, right? Were, going to courthouses and using the, where individuals who might be out of status were going because they had contract disputes or domestic violence cases or any number of other interactions with the law, and using that as a forum for picking them up. And the letter back, it's not the substance of the letter, which says they're allowed to do it, it's a public place, probable cause, the end. It's the tone of the letter. I mean, it's dripping with this sort of venom and shortness, right? For the Chief Justice of the nation's largest state, who's not exactly a community organizer, right? So I think it's much more, as you say. I think it's much more than what you see in the headlines. I think a lot of this is actually happening on a much more micro level that's not getting the attention it deserves.
Yeah, but sometimes, the news gets out in the concerned communities, even when it's not making national news. So, I mean, for example,
Right.
the cases in which recipients of DACA were then, subject to, government enforcement actions, I mean, those made tremendous news, I think, among people who, in immigrant communities. So what may barely be making the national headline still can create extreme fear, or the individual cases of again the woman going to the courthouse to get a restraining order and suddenly being arrested by ICE. Like that kind of incident, it just has a dramatic informational spread in terms of spreading fear.
And spreading fear, but not necessarily
Activism. That's right. Yeah. Not enough anyway.
Neil.
Thank you all. Steve, you mentioned how confirmation hearings can be an opportunity for a national conversation, right? So I think the Gorsuch hearings
Can.
right? I think the Gorsuch hearings should have been an opportunity for Democratic senators to inspire a national conversation about the importance of courts, the importance of judges, the difference that having the Garland hearings versus the Gorsuch hearings makes. And so I want to distinguish two questions. One has to do with the extent to which this Supreme Court or the lower federal courts, once they're reconstituted by the Trump administration, the extent to which they can be looked to vindicate important legal entitlements, from a different question about the importance of courts generally. Courts, right, in a democratic society play a limited role, but it's still a vital role. And more than a few sophisticated academics, more than a few sophisticated politicians, more than a few relatively young liberals, right, have taught or learned that really courts are not where the action is. It's really about activism and organizing and movements and legislatures. And to put it bluntly, I think if enough people on the left look past their personal misgivings with respect to Hillary Clinton, right, and vote for the better option from their point of view, the way social conservatives look past their personal misgivings about the current president and kept their eye on the importance of the composition of the Supreme Court, I think you probably easily have a different election outcome. And so what I'm concerned about now is another 4 years of rhetoric and innuendo from the left that really courts don't matter. Courts are not where we should be focusing our energies. You have to be looking elsewhere.
I mean, I'll maybe say something because I did have a more pessimistic view of how much courts can achieve. And I think partly it's about who you're having the conversation with. So I think the tendency in law circles is to sometimes place too much emphasis on the role of legal rights and of courts and enforcing those rights. And so it's not that courts don't matter. I mean, certainly I think it's not just even in the public law context, but the opportunity to vindicate rights in all kinds of contexts that is being, so even in more sort of straightforward dispute resolution, changes in procedure have made it much more difficult to enforce rights in private settings as well. So to me, it's both that courts do have a role to play in getting that message out, and I think that it shouldn't only be the case that we talk about movements in the absence of securing the institutions that can have some role in that. But for me, the more important thing when we're talking, especially to communities as a whole, is to not let people think that the courts will do the work for you. And I think even with the travel ban cases, to some extent, after a weekend of activism, when the courts seem to, start stepping up, the crowds dwindled and moved away because, there's a sense that, all right, now they've heard us, now they're doing their thing. And I think even in that limited context, what we'll see over the next, months is, is not the same sort of judicial activism that we did initially. So there's a long way of saying that I think it's important for people as a whole to just remember the power of their own activism, regardless of what's happening in court.
I also think there's a disconnect between, so I think there's probably more of a focus on lawyers and on legal organizations around the country than we've seen in a very long time. A tangible result of that is the amount of money that's going into legal organizations, and particularly those protecting sort of civil rights. I do think that the communities and the people around the country who are putting money into those organizations may not realize exactly what you're talking about, which is part of the place in which we should be our energies and our focus should lie is on the people who might be coming into the judiciary, and I think we have to figure out a way in which to raise a level of importance and actually just the understanding of the ways in which this process works and who's in it has such an incredibly important where these cases get to and who they are in front of is a conversation we hardly ever have for I think in some ways for a lot of people who are putting the money into the institutions themselves, and so I just think there's a disconnect. I think that there's a tremendous amount of focus on the legal movement and the legal activism, and not as much on who's that's going to come in front of, at least in the next couple of years. And I think that's a shift we should try and make.
In the back, yes, sir.
Oh, hi. So I'm Steven. I'm actually in town visiting for Easter from South Carolina. So been in a very interesting place if you all have watched the news in the last couple of years. And I guess my question is, we've talked a lot about courts and we've talked a lot about, I guess, politics, but I'm a social worker, and so I do some work in these systems, but not as much. So I guess my question is kind of like, what should, I guess, the social activism people's role be? You see in Ferguson, people turning over cars, setting things on fire during the Michael Brown situation. And then with the Charleston 9 situation a couple years ago, you see people praying and kind of coming together. But I guess kind of my argument as a social worker is I don't necessarily think one is worse than the other. The media will tell you that the people in Ferguson were thugs and bandits just trying to destroy their community, but I mean, no one talked about how the girl climbed the State House to take down the Confederate flag, or that people were spray painting really vulgar things on the statues of Confederate soldiers. Things that were happening in South Carolina that just didn't get a lot of media attention. So I guess kind of my question is kind of like, what should our role be? Because you've got some people who are, raising holy hell, and then you've got people who are praying and kind of responding in a different way. But is there one response that's more effective than another? And then I guess kind of a follow-up question to that is should people continue to do the things like Ferguson? Do you think there will be protections for those people? Or do you think it's going to be one of those things where Trump's going to be like, oh, lock them up, they're just raising holy hell?
Yeah, I think the key is just to get out there and be active. So, I mean, I'm not advocating people, burning down a Quick Trip or anything. That got a lot of attention. The few people who were involved in, committing damage to their community or may not even been from Ferguson, but committing acts of violence or destruction. But the vast majority of people, thousands and thousands of people, were out there marching peacefully, and that's been the nature of the movement for police accountability. It's not as sexy, it doesn't get as much attention. But even then in Ferguson, I mean, it went on for 17 days, right? We saw a video of people in the streets, and that gives quite a lot of, in a time of an administration that's interested in these issues and wants to have investigations, it gives momentum to the Justice Department. And I think it is a wake-up call for courts as well. So I think, as a social worker, getting out there in your community, being active, being visible is effective. In terms of what the administration's response is going to be, I do have concern that this administration is going to respond with repression rather than with opening investigations and meeting with community members because of the way that the president and the attorney general have talked about these issues. I mean, the attorney general has said he's going to pull back from the work investigating police departments. He's talked about bad apples, so seems to believe in individual actors who may be bad, but not systemic problems.
Which are different from bad hombres.
They're very different. They believe in bad hombres. That's a real thing in the administration. But the president has also talked about sending in the National Guard to Chicago to deal with crime. Of course, sending the feds, he said. The feds are already there. We've got a Civil Rights Division investigation with a set of findings, and there's a process going forward. But I don't think this administration is committed to that process. So I'm very concerned. We haven't actually seen it tested. There's been, to Jamal's point, there's been so much going on, so much to react to coming out of the administration, that the issue of police use of force and the killings of people in interactions with police have really not gotten the airtime that they had in the last couple of years. And it's not that the numbers have changed. I think we're around 300 or some people who've been killed in interactions with police. And I'm sure some of those have been caught on video, but we haven't seen them go viral. The oxygen hasn't been there. It'll be very interesting to see how the administration reacts once this becomes a crisis moment for them, as it has been, or as it was for the previous administration.
So we have time, I think we have like 2 minutes left, so why don't we do, sorry, Andrea.
Let me just do this really quickly. I think you're asking two questions, right? One is, how do communities handle what is trauma and fear and grief that are going on after incidences that are around the country? And the second is, what's most effective for change, institutional change to occur, right? And those are two separate conversations, and the acts that you might engage in may be quite different for what it is that, and I think the first, which is how do we actually address the trauma and the grief and the pain, is so critically important, and we have to continue to do that. That's the kind of work that you're doing and many are doing around the country. The second is, how do we then take that and figure out how we make it so that doesn't happen again, right? And that's a larger conversation. What I certainly agree with Trog that like what we've seen is that people who've been engaged in some of the people who've been protesting may have actually been gotten harsher punishments for the protest than for the people who actually might have engaged in some of the violence to begin with. So always want to keep account of that when you're out there in the streets.
So why don't we take two last questions? There's a woman in the back and then Nancy up front. Why don't you guys both ask your questions, and then we will briefly try to respond in concluding. So, behind you in the back first.
Hi, I had a related question. I guess one prominent example of a police shooting that honestly didn't receive any attention for a while was Laquan McDonald in Chicago. He was shot 16 times, 14 of which were after he was down, and the police footage wasn't released for, I think, about a year. And in that case, the police report said that he was lunging at them with a knife, and multiple cops had attested to that. Whereas if you look at the video, he's walking away from them without even the knife. It's not visible, and they shot at him. So is there any sort of relevance to having federal oversight for local police forces in terms of instances of police brutality or any potential misconduct? Because with Rahm Emanuel at the helm and the local police department, you have instances of torture, you have shootings like this, you have a larger issue of police violence and a disconnect between the police community and the civilian community. So do you think it's important, rather than having local prosecutors who know the local police force and have a friendly rapport with them, is it more important to have, an unbiased external opinion of having, the FBI or some sort of federal investigation come in to investigate these kinds of issues?
Great, thanks. So let's hold off on that for a second. All right.
So this may bleed into the next panel, but since part of the reason, the thing that we saw in this election was hijacking of the press, an enormously fundamental change in the national debate. So the question, do courts matter? You file a lawsuit and you get press. I mean, courts are the conveners of public opinion. To be sure, when they then go off the rails, the press then, you may lose a case on a procedural ground, and then it looks like you lost, and it delegitimizes the effort. But there's no question that this is part of the territory of public contest here, which is the way we do things in this country. The second thing is that it seems to me so critical. The only benefit of this administration is its capacity to go too far, which is on the one hand horrific and on the other hand a benefit. It makes clear things that were not clear before. It makes apparent tendencies that we're on the right that were not clear before. And I think it's critical, both in terms of litigation and political mobilization, that we not normalize that. It's however exhausting the past couple of weeks have been, it's critical that this not be normalized in any way.
Gerard, do you want to take the first question really briefly?
Sure. Yeah, I think it's incredibly important to have independent oversight. I mean, you're asking about criminal investigations. I've been talking a lot about the systemic investigations, and clearly I think there's a role for the federal government, or some states California actually has that power as well for the state attorney general to investigate police departments. But a lot of the public's focus has been on these shootings and other in-custody deaths. And there I think it is important to have independent investigations. At the beginning of my DOJ career, I was a prosecutor of civil rights crimes, crimes by police officers, excessive force, and hate crimes and other crimes. And I often found that the locals didn't want to touch the case. I mean, they actually relied on the fact that we existed in order to have someone to do this, because they had relationships with officers, the same officers that they might need to prosecute or investigate in some situations where they're witnesses in the mine run of their cases. So I think that's important. And at the same time, that is not likely to be something that's going to be robust in this administration, I think. So, right. So, I mean, even under the Obama administration, look, I was in the Obama administration, but I recognize our limitations as well. There are a number of cases that we weren't able to bring. Partly that's due to the limits of the federal law. There's a single federal statute on point. It requires that the Constitution have been violated, so excessive force and all the Supreme Court's doctrines around cabining Fourth Amendment law apply there and are hurdles. And it also requires an intent standard of willfulness, very high standard. But there's been some public reporting on the Eric Garner case, for example, where at the Justice Department there's some internal debate about what to do in that case. I suspect this administration is not going to go forward with that. It appeared from the public reporting that the Justice Department was moving forward on that case, and likely not at this point, based on what the Attorney General has said about police reform in general. So I think you want to look at other models of accountability. So one model would be to have a different jurisdiction's prosecutor's office do the investigation and make the prosecutorial judgment. Many prosecutors are resistant to that, and we have to be aware of that. They believe that they are constitutional officers, state constitutional officers. They have responsibility to review all cases and determine whether there was an offense here or not. But the public is calling out for it, and I think if that cry continues, then you will see a movement toward independent investigations and prosecutors investigating other police departments from other jurisdictions. But it'll only happen if the public continues to care about it.
So I'm going to jump in and say that's as good a place as I need to stop. We're going to give you a little break. So let's come back in 10 minutes at 11:05 for the next one.
This one's next, yeah.
Chelsea was supposed to bring back more little water bottles.
Okay.
Can you run up to the dean's office?
Sure. I got it.
All right. We just need one more for this panel, but if we get more for the afternoon, that would be great.
Like response.
Oh yeah, that part where she was saying it was didn't. Yeah. What she was saying, we can't trust locals to do this. They buried the video.
Which is why we had a Department of Justice investigation. Right. I mean, that's. But also, I think part of the story Chicago continues is the ways in which.
By the way, I told you that would work out.
Nice work.
Yes.
Not that moderate. Not that moderate.
Try.
Yes.
Fantastic.
Well done.
And I think it was pretty coherent.
I don't know. I always wonder, every time I do a panel or speak anywhere, the audience is getting something. Is this any good?
I mean, if they didn't leave their stuff, they probably all come back. So that was. Actually, could you do me a favor? Yeah, sure. Could you just? Of course. Yeah, no. You have anything you need to do. All right. Thank you.
My name is Jamal Green. I'm the Dwight Professor of Law at Columbia Law School, where I teach constitutional law and a bunch of other things that you can talk to me about later. Welcome to the second panel, which is entitled The Nativist Turn, Fault Lines. It's listed second. We're going to do it again. Fault lines in our constitutional structure. This panel, I think, is more directly addressed to Steve's question, which is how screwed are we? And really, a part of the question is, Steve said this is all very depressing, but part of the question and part of our charge, I think, is to talk about the degree to which we should be depressed. How depressing is this? How anomalous is the moment we're in? To what degree is it an outgrowth of a set of political and constitutional arrangements that can be questioned, that can be changed? And so we're going to be talking about structure, both constitutional structure and political structure. We're going to be interrogating some of our assumptions, some of the current institutional configurations. We're going to be talking maybe a bit more about process than about substance than some of the other panels. So I want to try to sort of encourage both the panelists and those of you in the audience to think creatively as we dive into this session. And so what I'm going to do is I'll very briefly introduce our panelists. They'll each talk for a very brief amount of time, on the order of 5 to 7 minutes, and then we'll have a bit of a conversation among ourselves before opening it up to the audience. And I want to make sure that I leave plenty of time for audience feedback in the nature of both this particular topic and this conference in general. So going from my immediate left to my far left, Nancy Gertner, who is a senior lecturer in law at Harvard Law School. From 1994 to 2011, she was a federal district judge for the District of Massachusetts, and she has very wide-ranging expertise in civil rights and criminal law issues. Bill Marshall, who is the Keenan Professor of Law at University of North Carolina. He was a former Deputy White House Counsel and Deputy Assistant to the President, former Solicitor General of Ohio. He also has wide-ranging expertise on lots of things. Separation of powers really comes to mind when I think of Bill Marshall, but it's quite a number of things. And to his left, Neil Siegel, who's the David W. Eichel Professor of Law and Professor of Political Science at Duke Law School. And Neil, not surprisingly, also has wide-ranging expertise in constitutional law, and I tend to associate Neil with federalism and constitutional theory, but his expertise also goes beyond that. Neil is also consistent with his question at the last session, has participated quite a bit in confirmation hearings over the last several years, and is a former law clerk to Justice Ruth Bader Ginsburg. I'm just going to kind of go down the line, essentially, and then I'll circle back to me, and I'll so you don't need to hear me for more than a couple of minutes at a time, and start with Nancy. To just talk for a few minutes about
Judge Nancy to you. We had this conversation.
Right,
Is it okay
that's
to call me
the Honorable Judge Nancy.
Hun. You can call me Hun, but go.
And we'll each throw out a few ideas, and then we'll get the ball rolling.
Okay. In one sense, what I want to talk about is a little bit of a segue from the last panel, because I want to talk about the courts, and not just the big court, not just the Supreme Court. I do want to talk about the lower federal courts in this institutional structure, and I'm stuck in talking about that because it's like, to a hammer, everything looks like a nail. So to me, I'm looking at judges. We've seen in this administration a significant failure of checks and balances, not just the Congress being all of one party, but checks and balances in the way that the previous panel talked about. The Office of Legal and its relative independence from the administration is a check and balance. The civil service is a check and balance, and in a whole host of ways, the administration has undermined those checks and balances, making the court more of a backstop than we have seen in a while. There's sort of no filters before you got to the court. In a sense, the judicial backstop looks different in 2017 than it did in 2016 and 15, et cetera. What I had seen on 17 years on the bench was a court, a lower federal court, that I would not have had great confidence in being a backstop. In fact, the first thing I wrote when I left the bench is about how the principal political pressure I felt as a judge was not right or left, it was not ideological. It was, as I described it, to duck, avoid, and evade. It was the pressure, it was not judicial restraint in the constitutional sense, it was really the avoidance of any substantive decision-making of any kind. And it was reflected not just in what judges did, it reflected, this is a larger conversation, with the way we teach students. Students learn the limitations of civil rights laws, learn the procedural tripwires of habeas corpus, long before they learn what the institutions are about. It is what we teach judges. I went to baby judge school in 1994. That is, in fact, what they call it. And I had a trainer who was a trainer from the Bush administration who is teaching now the new crop of Clinton judges. And he begins teaching civil rights by saying, literally, here's how we get rid of these cases. I wasn't confirmed yet. I raised my hand. Everyone around me told me to shut up. So you saw that procedurally, in terms of ducking, essentially, if there is a range of options with respect to statute of limitations, if there's a range of options on standing, and there always is, the law rarely enforces itself with clarity. If there's a range of options on the procedural tripwires, every pressure was to get rid of the case. And then when you finally got to the merits, there were the doctrines that were also obfuscating, like harmless error, like good faith. And now this is on top of the constitutional doctrines that enabled, I'm calling it ducking, others might call it judicial restraint, standing issues, political question issues, immunity issues. So duck, avoid, and evade was the mantra. And then, in fact, this was not my observation, a student from one of my classes that I taught named Richard Ree was talking about a concept known as reversing from below, which is that the district courts would be interpreting Supreme Court precedent sometimes more narrowly than the precedent was entitled to, almost predicting the direction that the court may be going in. There was a rightward trend in the district courts anticipating the rightward trend in the Supreme Court. I saw that in the minutes after the Walmart decision when, in fact, judges around the country dismissed class actions, interpreting Walmart far more broadly than it needed to be. Walmart was a mush of a decision. It was incoherent in many respects. There were lots of different interpretations, but duck, avoid, and evade meant you said, aha, now I can get rid of this case off my docket. It is a version of what Robert Cover wrote about Civil War judges who were anti-slavery and enforced the Fugitive Slave Act with a rigor that no one anticipated, that they didn't have to enforce. They had no choice, they say. So we saw this kind of much, I have no choice to dismiss. I have no choice but to deny. There are a whole host of reasons for that, and I'll get to the present in a moment. There are a whole host of reasons for that. Part of it, I do think, is the politicization of the bench, the politicization of the selection process, that it's just easier to be a judge if you keep your head down. It's just easier. You don't get criticized. You're seen as fabulously efficient, and it's managerial. What about now? So this was not an institution that I would have ever expected would step up to the plate with respect to being a backstop to this administration. And then you have what I've come to talk about, and I thought I invented this, judging in a time of Trump. I sort of wanted, we should have some screen, judging in a time of Trump, where all of a sudden the background narrative to these decisions is different. Context always mattered, and to some degree, a duck, avoid, and evade court was possible at a time when you think things were basically okay. This is from Chirag's, it was post-gender, post-race. The institutions of government were generally functioning. Now you have judging at a time of a different narrative. And suddenly you're seeing, I'm convinced, how far this goes, I don't know, that we're going to see some changes in the way that judges are interpreting some of the kinds of issues that I'm concerned about, because you can no longer assume that everything is fine. You no longer can assume we're post-gender, post-race. You no longer can assume that the institutions of government are humming along. How do you deal with this? How do we deal with this going forward? I almost want to encourage people to look at, this was also at the end of the last panel, who gets on our federal bench. The district court is not politicized in the way the Supremes are. In Massachusetts, for example, if they want to find a right-wing Republican, they're going to have a hard time. You know, our court went from moderate Republican to moderate Democrat, except for me. So we have to look at the selection process at that level. I'm just about finished. We have to look at the academy. As I wrote in the blog, the academy has to stop speaking in tongues. A dean of the Harvard Law School spoke to my court once, and one of the judges said to her, "We never read law review articles." Never, ever. They are boring. I don't even understand them half the time. They're talking about things that don't interest me. That particular dean leaned over to the judge and said, amazingly, "I don't care. We're talking to the university. You got to start talking to the profession. You have to start talking to the judges." The recent, I don't take credit for this, the recent Seventh Circuit decision that changed that adopted a definition of Title VII that included sexual preference. I had a decision like that in 2005. I wrote a similar decision. I can't say I came up with the idea. I read a law review article. That plumbed the corners of this Title VII, and I adopted that. But that's because I understood it. So there are lots of things we can do, we can talk about later, but this is going to be a backstop that we have to pay attention to, even if the Supreme Court is not as much. Sorry, I talked too much.
Thank you. Well, you're about to hear from 3 law professors in a row, so we have our charge. We have to be comprehensible.
You know, speaking in tongues.
Well, let me start off by thanking Dawn for all the work that she did putting this all together. Let me thank ACS, and let me thank the Indiana Law Journal, and let me also just thank the University of Indiana Law School. I've been out to this place about as many times as Alec Baldwin's hosted SNL. I really love this institution, and I really love coming here, so it's great to be back. I'm going to talk about the other 2 branches real quickly, and the project that I started working on called Congress's Power to Do Nothing is something that I started thinking about actually before the election took place, in part because I think the most important constitutional issue and expanded it. Both Donald Trump's use of presidential power, and I think there's some difficult problems with the kind of expansion that we've seen. Certainly, writing back in the 1950s, Justice Jackson in the Youngstown case said already the power of the presidency has expanded far beyond anything that the framers had in mind. Now, there are a lot of reasons why presidential power has expanded. We could talk about just the need for acting quickly, which only the president can do and Congress cannot do in many areas. The massive control of information the presidency has, and there are others. But I want to just quickly talk about 2 that are less thought about. One is the public expectations that go with the presidency. And by the way, the Democratic side of this is worse than the Republicans because the Democrats have much greater turnout on presidential elections than they do on other ones. They discount the value of the other races. And what does that do? They think that the presidency is the source of all power and all governmental power, and that in turn invests power in the presidency. And the second reason why I think there's been power vested in the presidency is because of Congress's response, Congress's gridlock. Congress has two choices. One is they can give in to the president, whoever that president might be. That expands presidential power. And the second one is they can fight and deadlock. And paradoxically, and that's a little bit what I want to talk about, that has also served to expand presidential power. Because when there's a deadlock like that, presidents often say, well, if Congress isn't going to do something, I am, and use that as an opportunity to jump in. And there's a second way. That's sort of expanding presidential power through the front door. There's also expanding presidential power through the back door, which is that I think there's a disillusionment that's created when government gridlocks and people start looking to folks who have easy answers. And it's not just Donald Trump. Remember Ross Perot ran on the same kind of program, and until he imploded, he was going to get a lot of power, a lot because he came in there and said, just give me I'll open up the hood and I'll fix it. We sort of have a hunger to have things done efficiently. Now, what can we do about gridlock? Because on one hand, when Congress does nothing, or when Congress opposes the president, that is the best thing it should be doing if our idea is separation of powers and checks and balances. So in that sense, it's an incredibly important function for the Congress to be able to have the power to do nothing. But I think what's happened is that there's been an expectations game that has changed with that. And my project here, and it's got a tremendous amount of flaws to say the least, but the project here is to sort of change expectations, because now I think Congress goes in there with the sense of we don't really have to do anything. If we don't do anything, we aren't violating our constitutional obligations. There's no constitutional imperative for us to do anything. Now, some in Congress on both parties say, well, you should be doing things, but often the response is, well, we don't really have to, so if we don't do anything, that's perfectly within our function. And I think what we ought to do is change the language a bit and say that there are certain areas where Congress has to do something. And by imposing some obligation on Congress, maybe what we're going to end up doing is actually strengthening Congress in the long run. Maybe this is just rhetorical. I haven't gotten so far to think about whether or not we can go and mandamus the Speaker of the House to consider legislation, or mandamus. So what? Yeah. Or not in this presidency. Or mandamus the head of the Senate to order hearings on certain Supreme Court candidates. But I do think we can change the political rhetoric somewhat and suggest that there are obligations, and maybe that'll help change the culture that we have found ourselves in, and it might also think it has institutional obligations. And one of the more powerful law review articles, dare I say the word, recently is Darrell Levinson's and Richard Pildy's separation of parties as opposed to separation of powers, indicating that our entire separation scheme has changed, and rather than Congress looking at itself institutionally, it looks at itself at what party the members belong to, and that in turn has weakened Congress as an institution. So the beginning thing that I've tried to figure out is what areas can we say that Congress actually has an obligation? I think one area is the budget, because government can't work without money. So we might say that in that area, Congress has a true obligation to act. Also, maybe an area with particularly the Senate that has a subsidiary role to the presidency in terms of appointments. I think that in that area, there's a pretty good argument that Congress has a role, that they should have hearings, and that it's a constitutional violation if they do not. I do not, however, think it's fair to say that Congress has an obligation to pass legislation that the president is interested in, or even take up legislation that the president's interested in. And I know I'm going to get some blowback on that. Why? Well, in part because Congress is supposed to be the primary movement on legislation, not the president. The president has a recommendations power. So the area where you would think that Congress would have the total prerogative of whether to do something or not would seem to me be in legislation. Now, what they have done is put themselves in the back seat and waited for the president to set the priorities. But it might be a good idea if we think backwards on that. There are a couple other areas that I think it might be interesting to try to figure out. If there are constitutional violations, is the filibuster unconstitutional because it inhibits congressional action is the so-called Hastert rule in the Congress, in which the Speaker says they are not going to take up legislation unless the majority of their party supports it. We make arguments that that's constitutional or unconstitutional, both of those. And then finally, what I think is maybe a really difficult one to figure out is the obligation, does Congress have a constitutional obligation to oversee the presidency and use its investigative power, or is that something that is completely with their discretion? But that's the project that I am thinking about, and I'm thinking about it because of the long-term issues. Congressional gridlock has caused major disillusionment. I think it's one of the reasons why, there are many reasons why this election happened the way it did. If Donald Trump wasn't going to be elected, I don't think it was too many years down the road that somebody else carrying similar kinds of cachets were going to be elected, because they would be running on the sort of disillusionment with government. So that's what I want us to think about.
Well, good morning. I also want to thank Dawn and the law school and the Law Review and ACS. This is an important gathering, and I'm grateful to be included. I also want to thank all of you in the audience. Having come now to the university for the first time, I can comfortably say that this is the largest crowd ever to witness a panel in the history of this university. Standing room only, and I want to thank you for that. And I jest because it's actually relevant to what I want to say. What are these fights over crowd size about? What are they a proxy war for? There's a certain dichotomy that underlies a lot of sophisticated constitutional argument as well as political rhetoric, and has done so for the last at least 50 or 60 years. And this is the sharp distinction that is drawn between the Supreme Court and the federal courts on the one hand, and the political branches, the president and the Congress on the other. Alexander Bickel in 1962 famously coined the phrase the counter-majoritarian difficulty. And where do these unelected judges get off telling popular majorities what they can and can't do? And the idea is that judges face a democratic deficit, which is a charge that matters in a presumptively democratic society, in contrast to the political branches, which can safely exercise partisan political power because of their special democratic warrant, because they represent majority will or majority sentiment in the nation. And I think one way to understand the expressions of frustration, of anger, of disillusionment in response to the 2016 election results is as declaring emphatically that this conventional view, this stylized dichotomy, is simply not true in the case of the political branches. It's not simply a substance objection that the Trump administration and congressional Republicans are going to do things that we disagree with. I think it's also a process objection that national political institutions have in an important sense failed the majority of Americans, that formal electoral processes result in the election of officials who in turn pursue policy agendas that lack majority or even plurality support in the nation as a whole. And that link between electoral processes and policy outcomes is actually the sum of two sublinks, between electoral processes and elected officials, and between elected officials and policy outcomes. And the concern is that both of them encompass a certain kind of democratic deficit. We have counter-majoritarian electoral processes, and so you can lose the popular vote by 3 million and still win the presidency. You have equal representation of states in the Senate, notwithstanding dramatic differences in population. You have the phenomenon of gerrymandering and clustering in the House, and so if the Democrats win 50% of the votes nationally, they're going to lose a House majority by a substantial margin. And then you have all kinds of counter-majoritarian constitutional rules, congressional practices, and political dynamics that dramatically affect the policymaking process as well. And so that's how I understand, for example, signs at the Women's March, right? She got more votes, or even the jokes that are speaking truth in jest. He's orange, he's gross, he lost the popular vote. Right? This is a claim about structural processes that we possess that are not majoritarian in the way that they're often asserted to be. Now, political scientists have known this for quite some time. They've been documenting all the counter-majoritarianism in the electoral processes and in our political processes, our political process. Constitutional scholars have also gotten wind of this, but their interventions have mostly been limited to issues of constitutional design and judge-made constitutional law. Sandy Levinson wants a constitutional convention to get rid of the Electoral College and a bunch of other things. John Hart Ely famously articulated a theory of judicial review that he thought would be democracy promoting as opposed to democracy inhibiting. More recently, Karina Lane has written an important article in Georgetown arguing that in certain circumstances the courts are simply substantively more majoritarian in terms of their results than the elected branches. And in my project, I'm proposing two contributions. And the first is that these counter-majoritarian difficulties facing the political branches are not just relevant to constitutional design and constitutional law, they also may be relevant to how elected officials should feel entitled to behave. That they can't simply assert or assume that they can do whatever the formal electoral processes have legally authorized them to do just because they won the previous election. That in fact, the way we tend to think about judges and restraints on judges may have some relevance to how we think about elected officials. And that speaks to my second intended contribution, that if you're worried about counter-majoritarian difficulties facing the political branches, a good place to look for inspiration and resources, for methods and approaches to negotiate or manage the problem is in the constitutional theory literature on the counter-majoritarian difficulty, as well as the broader cultural anxieties that it reflects, which have found not inhibiting, but cumulatively meaningful ways of limiting or restraining the conduct of judges. I don't mean duck, evade, and avoid. That's simply, I think, an ideological objection to certain kinds of constitutional rights as opposed to others, right? But I mean various methods and practices that over time the hope is will have some meaningful restraint on the conduct of judges. And the one I want to emphasize here, right, it's a multi-generational project of cultivating, right, a sense of institutional role and restraint. Ideas like moderation, ideas like judgment, timing, tact, ideas like statesmanship, taking some account of the conditions of one's institutional public legitimacy, that we ought to think about elected officials more like the way we have traditionally thought about judges, that elected officials also have their own counter-majoritarian difficulties to negotiate. And there are a variety of implications if you accept this invitation and begin to think this way, because I think this will enable us to actually address the circumstances of American political life for the foreseeable future. I think elected officials might consider not just what kind of legal authority they possess, but also what kind of democratic political legitimacy they might require in order to pursue certain objectives. And I also think there are implications for practices of political resistance. I think it's very common to hear claims like elections have consequences, we just had an election, it's just politics, if you don't like it, win the next time. These are conversation stoppers. And it seems to me what those statements ought to mean is not the end of a conversation, but an invitation to contest exactly what the previous election settled and what it did not. When people try to justify counter-majoritarian political action by invoking the outcome of the previous election, it seems to me those who disagree with the particular agenda at issue might speak the language of democratic political legitimacy in response to those claims. Thank you, and for the time being, I will resist the urge to respond to the other contributions to this mother of all panels.
Thank you, Neil, for recognizing the awesomeness of us. So I'm going to continue the awesomeness. Bill, in his few minutes, or towards the end of his few minutes, said that if it weren't now, it would be eventually, in the next several years, that we'd get something like the Trump presidency. I think back to this quote that was being circulated right around November 8th or so, or really November 9th, by H.L. Mencken from about 1920, where he said, sooner or later, we're gonna elect a narcissistic fool as our president. And that was almost 100 years ago that he said that. So he was right, but it's a question of timing, I suppose. So part of what I'm interested in is the degree to which the moment we are in is something that is either presaged or predicted by our constitutional arrangements and how those relate to culture and to politics. And what I mean by that, when I think about what the moment is and when I think about what Trump is, I'm not thinking about it in purely partisan terms. When I think of the problem is not that Trump is pursuing a conservative policy agenda to the degree that he is. The problem is that he is mendacious, he's conflicted, he is demagogic, he is indecent, and he doesn't care about policy. I can see that. I could imagine someone like that becoming president from the left as well. I think there are various reasons why that's somewhat less likely, but I can imagine it. I can see it happening. And so the problem is not, at least as I'm articulating it here, is not a purely partisan problem. What I want to focus on, and I think Bill's right that there are lots of reasons why we have the presidency we have, why the election turned out the way it did. Some of those are contingent, some of those are less contingent. But I want to focus on one set of problems, which I put under the label of the kind of clunky label of disintermediation, which is a term that comes from economics and comes from discussion of supply chains mostly. Intermediaries are people who connect buyers to sellers by and large. So I think about, I live in New York City, and when I go food shopping, with my kids, we go to Whole Foods, and the Whole Foods is a place where my kids are never going to see Cocoa Crisps. That's not why I go to Whole Foods, but as it turns out, they don't even know that exists, right? That there are foods as glorious as Cocoa Puffs or Cookie Crisps. And there's an analogy to that in information markets, in the sense that there's been this great diffusion of intermediaries because of technology, because of other reasons as well, that also occurs in information markets. The traditional intermediaries in information markets are the media, and really what we now call the MSM, right, the mainstream media, so as to distinguish them from the other media. It used to be that's what the media was, is the mainstream media. But now it's much more diffuse, and that affects the way in which we receive information. And the suggestion is that and this is certainly not original to me, is that we are not all having the same conversation. We're all in some kind of conversation with some set of people, but we're not really engaged in any real deliberation in which we're operating, we're responding to the same arguments, operating with the same set of facts, and really engaged in the same deliberative process. I think that the political moment that we witnessed this last fall, we saw someone taking advantage of that fundamental disconnect, where we really don't trust each other at all. We don't trust each other's source of information. There are no checks and balances that anyone really trusts from some different orientation or some different political perspective. And I want to suggest that that problem, and I do think it's a problem, is a problem of constitutional dimension. It's a problem that has constitutional contours. And what do I mean by that? Why do I say that? Well, as I think about checks and balances, and I also think about the Rick Pildes and Darrell Evanson article that Bill Marshall mentioned of the ways in which political checks happen in 2017 is not through a differentiation of institutions in the Madisonian design, where it was the House has different interests than the Senate, which has different interests than the states, which has different interests than the president, and so forth. It's a party checking system, so that the national political parties are the ones who check each other. And so what the game ends up becoming is each party trying to control as many institutions as possible, and then push as maximally possible towards their policy agenda. I think that the constitutional design, and I think this is a good feature of the constitutional design, was designed to support a system in which policy and governance occurs through mutual accommodation, occurs through negotiation, occurs through compromise, rather than occurring through wild swings back and forth between various political extremes. And I think that that disintermediation and technological change has contributed to that. Part of my question, and it really is a question because I don't have definite answers on these things, is what we can do to try to restore what I call the political middle or the American middle. And that doesn't mean as a policy matter. That doesn't mean we need to have sort of median policy outcomes. It means that we have to have a conversation in which we are talking to each other and arriving at mutually acceptable compromises. And that may involve creative thinking from the far extremes. It might involve more idea proliferation rather than fewer. So a few thoughts very quickly, and I'm not keeping my own time, so I can talk as long as I want.
Oh no, you can't.
I control that. I paid for this microphone. So one is, and this may be in some tension with what Bill just talked about, is supermajoritarian requirements. So things like the filibuster. I think the Hastert rule goes in a somewhat different direction, but I think that it's potentially problematic, both in the space of appointments. I think less so even in terms of legislation. I think filibusters for inter-branch appointments is actually quite important, and I think the legislative filibuster and various other veto gates and supermajoritarian requirements might actually be very helpful in getting people to talk to each other and to require some coalition building. We have an electoral system that very effectively supports a two-party system, first past the post voting. We don't tend to get very creative in the ways in which we elect people, so that third parties are not non-viable because they don't have ideas or don't have supporters, that they're non-viable because they cannot get elected under the current structure of voting, the current voting process. Campaign finance is an obvious location where the last panel, I think, Anurima talked about people running for political office, but I worry that is limited functionally to people who are rich, famous, or corrupt, or all three, and we won't get we won't get enough meaningful political diversity. Creative ways of financing media. I don't have very good ideas along these lines, but I know there've been more philanthropic efforts than in the recent past to think differently about the role of the media in society. And the last thing I'll mention before saying I want you all to have your own thoughts about this is the very way in which we think about rights and about constitutional rights, which I think in the American way of thinking, and this is a longer conversation, but the American way of thinking tends to be very categorical or all or nothing, rather than thinking very, very seriously in terms of balancing various conflicting rights, balancing governmental interests and individual rights, and thinking about remedial flexibility so that one doesn't necessarily expect to get everything one wants from a court. I think that cuts in both directions politically, but I think it's actually important for us to engage in a conversation about what it is that government can do and what it means for government to be acting in good faith, and what that entails for rights protection. And we can talk about that at greater length, but I'm curious about everyone else's thoughts. So what I want to do is just to get the conversation rolling and to get some cross conversation a little bit. I want to open up the conversation space to each of the panelists to say a little bit, if they want to, about what the others have said. That can just be a couple of minutes. I have my own thoughts, but why don't we start with Neil, and I'll give you the opportunity you were yearning to comment on us.
Yearning is putting it wrongly, but I'll take the opportunity. So I think to Nancy, what I would say is, look, there's a lot of, it is true that law schools, particularly the elite law schools, there's an important part of them that are oriented towards the university, and I'm prepared to defend that. But there's also an important part of them that are oriented towards the bench and the bar, and there's a lot of good legal scholarship out there, and it's not just how judges are used to ordering people around, right? It's not just how legal academics need to change, it's how judges need to change, right? One of the many things I admire about Justice Ginsburg is that she always had her law clerks who were preparing a bench memo for a case to look for the relevant legal scholarship, and she wanted to see it, right? And I don't think she was unique in that regard. So if you want to know how to respond to whole women's health, right, read Reva Siegel and Linda Greenhouse in the Yale Law Journal. One example among many recently, right, of that kind of relevant scholarship. I'm going to echo what Steve said in the earlier panel about the importance of federal courts, because I think what Bill is proposing is a version of Henry Hart's essential functions thesis, but not as applied to Congress's power to strip the Supreme Court's jurisdiction. The question is, under Article 3, Section 2, you have this exceptions and regulations clause. Could Congress use it to simply get rid of the court's entire appellate jurisdiction? And the traditional conservative hardcore Fed court's view is yes, the clause means what it says. And then Henry Hart, who was sympathetic to that view, said, hold on a second. Right? There are certain essential functions of the Supreme Court and the constitutional system. Congress can't destroy that. This is in Hart's famous dialogue. And I think what Bill is talking about, the essential functions of Congress, the essential functions of the executive branch that Congress is not empowered to severely undermine by doing nothing. And so I think there's something important to that thesis. It is to this day the official position of OLC. A recent paper I published has a debate between the young John Roberts in the Justice Department and Ted Olson, the head of OLC, about whether or not Congress can simply severely impair the court's appellate jurisdiction, and Olson won. Roberts lost, and the official OLC opinion is the essential functions thesis of Henry Hart. Now, the problem with it is that it's notoriously ambiguous. What's an essential function? How do you know? Right, so I think, right, you're onto something important, but how you actually would operationalize it, as you know, would be tremendously difficult, although I think there are lines that one could draw. The Constitution requires one Supreme Court. It's simply not consistent with the Constitution for the Senate to do nothing and whittle the number of justices down to 1, to 0. Right? And so too, if you fill no executive or branch appointments, there are certain lines I think you can say can't be crossed, because then you violated the essential functions, but it is difficult to operationalize, but that's what I see you doing. I think, Jamal, you make an important point. So I'm talking about concerns about counter-majoritarianism, whether it's judges or legislators, which is not to say that I'm offering majoritarianism unmodified. Right? There are important circumstances in which one should behave in a counter-majoritarian fashion. And likewise, just because you have bare majority support doesn't mean that you're licensed to do whatever you want. Sometimes it's more important to speak for the whole and not just for your bare majority, which is part of what supermajority centering kinds of with them is that it could also, particularly in a polarized environment, make it impossible to do anything. Right? That if you need a supermajority in order to act, then you're going to act even less often than Bill is concerned with.
And you should feel welcome to respond to charges or praise in the course of.
I seldom get a chance to respond to praise. People cite my articles always with "but C" in front of them. I've never quite figured out why. Let me also follow up a little bit with what Nancy said. I do think there is actually a fair amount of scholarship that is being written towards judges now, and I think some of that trend is coming back. There was an article that my friend Doug Laycock used to make fun of called "Wittgenstein in the Uniform Commercial Code." I don't think every article is kind of like that, but I also do think that academics have a responsibility to create germs of ideas that later grow, and it takes a while. And give credit to the Federalist Society on this. I mean, they planted seeds 30 or something years ago. It didn't affect. I mean, I think the ideas, many of them are completely antithetical to what a lot of what I think is correct. But what they did, and by the way, what ACS was trying to do is replace that set of things with longer range looking at the world. I do think that sort of setting of that long-term ideas in motion is a critically important one. With respect to what both Neil and Jamal are talking about, I think what we're all talking about here, in large degree, is, it's the title of the panel, is where has our Constitution gone wrong, if it has gone wrong at all? And how do we sort of make it a much more moderate, workable kind of document? Part of what's happened, I mean, part of the answer is polarization. We see each other on different basketball teams right now, right? No matter what the other side does, it's wrong, and no matter what we do is right. And there's no sort of criticism that we aim at our own side anymore. There's no sort of effort to sort of to try to do that, in part because of the nature of the so-called permanent campaign, that we never want to give any benefit to the other side because they'll use that in the next election, in part because it's campaign finance and other kinds of things that have forced us to look at the other side continually as an enemy. It's one thing to say, vote for Harris over Jones because Harris is a better candidate. It's another thing to say, give me $10,000 because if you elect McCray, what am I going to say? They're going to say the end of the world is at hand. I mean, that's increased the sort of polarization in the way we go on, and looking for ways to moderate our politics, which is what I think everybody on this panel is talking about, is a good one. And that means we have to run away from the constant vilification that we're doing. I think in what I was trying to say, I think building up Congress as an institution is an important one because, unlike the presidency, which is a single person, Congress has to work together. And if Congress could get in its head that it's an important message to send to engage in action that transcends just party identification, I think it might work helpfully to minimize some of this polarization.
In one sense, because we're all lawyers and law professors, the enterprise is looking for a procedural fix to the polarization, some set of, on the theory that the checks and balances in the Constitution, and even the Electoral College and all of these devices were in fact a mechanism to require consensus building and accommodation. And while these are interesting ideas, certainly with Neil and Bill, I can't figure out, they are hortatory. They are, here's what we think Congress should do, but I don't see how we get from where we are to there. I mean, I was actually playing around with, and whether there was, this is just because, again, to a hammer, everything looks like a nail. Did anyone try to challenge the failure to give Garland a hearing in court? There were challenges to that went nowhere.
There were some standing issues.
Yes, profound standing issues, right? But I mean, but the question is whether or not the publicity surrounding that would raise some of these issues. But I don't know how procedurally to do to get, other than urging Congress to be different than they have been when all the procedural pressures are going in the other direction. Jamal, I see, is trying to come up with some procedural devices that would force accommodation. The filibuster in a time of, time when the Congress is captured by one party, doesn't force accommodation at all. If anything, it provides a megaphone to one side or the other. So I don't know that I can see a procedural answer to the current situation at this panel. And the only reason I turn to the courts is at least that's a place where I don't see a procedural answer there as well, but it's a place in which we can raise and highlight these kinds of issues. I mean, the only answer I see actually continues to be a political answer, and it was both those people who talk about the importance of organizing at the local level, at the state level, local legislators, and I see this also at the local court level, that to some degree we have to be talking about developing a bench, essentially, like you would in basketball, developing a bench that would be able to go up. Rightfully or wrongfully, we pick judges at the top from judges all the way at the bottom, but I can only see a political answer, not necessarily a structural answer.
I suppose I take I completely accept the problem of certainly what I've proposed. I think the same is true for what Bill and Neil have proposed as being hortatory. What goes with that is that I'm not optimistic, right? So that doesn't mean I think it's impossible, but I'm not. I don't think I'm naive here. I'm quite pessimistic, actually, about the future of the nation, of the world. Take that for what it's worth. With respect to the filibuster, I mean, I guess I'm one question in response to what both I've said and what Bill has said is, if you want Congress to do things, is it better to make it easier for them to do things on their own or unilaterally, essentially with one party, or is it better for it to make it more difficult for any one party to do things and to try to force compromise? And to go back to another parenting analogy, right? If your kid isn't eating broccoli and you say, eat the broccoli or you're not going to get up from this table, right? Some set of kids are going to eat the broccoli eventually, and some set of kids are going to sit at the table. And I'm not optimistic that Congress is going to eat the broccoli, but I don't know what else to do. So I'm at my wit's end, just as parents often are. So I guess that's part of the kind of institutional question is what the do you use how do you use a hammer or do you use a carrot or do you use a stick? And I'm not sure what the answer is. With respect to Neil, and he forecast this problem a little bit, but I think it's a very rich set of insights, and I think it's worth an article, which I guess Neil will write, but also maybe thinking even more broadly than that, might be even a full research agenda in terms of thinking about what's the right way of, or what's the right perspective from which to critique or to shape policy, given our generally counter-majoritarian electoral arrangements. But figuring out what the baseline is really hard. The Electoral College is, of course, looks really counter-majoritarian right now, but it's very hard to measure what the outcome of the election would have been in some alternative universe in which there were not incentives to campaign in a particular way. Do you go with polling? Do you go with, which is also unreliable in various ways? It's hard to figure out sometimes what counts as a majority, and even asking a policy question, the way in which you ask the question will shape what the answers look like. And so it's a really hard problem of if the premise is, if the intervention is we're going to have a different frame of mind when we are when there's not a majority, then it's hard to operationalize that. One potential alternative way of thinking is to try to go away from process and to go more into substance and to think, well, what does it look like for a governing entity, whether it's the president or whether it's Congress or whether it's a state legislature, to behave responsibly in a democratic sense towards their political opponents or those who didn't vote for them? Are there certain substantive commitments they have to make or substantive entitlements that or substantive or some sense in which we really do need a very powerful political mandate to do certain things, and that's part of the culture, is maybe another way of thinking about this. And on Nancy's point, this is a question I've been asking myself for a long time, and it's really been exacerbated by, especially thinking about the travel ban litigation, is to what degree judges, you talked about judging in a time of Trump, really, to what degree judges should pay some attention to who the policymaker is. We see lots of conversation, and certainly from the Trump administration, in response to this litigation, of, well, you're supposed to give X degree of deference to the president, depending on who's talking and which brief you're looking at. That's either 100% deference or 98.5% deference or something. You're supposed to give X amount of deference to the president, and a lot of the conversation in response to that has been, well, no, you aren't supposed to give X amount of deference to the president. Your judges have X% role to play. But I wonder if it's productive to have a conversation about the degree to which, quite openly, judges can talk about having different levels of deference based on the track record of a particular administration. I know judges are not willing to do that typically, but we're engaged on this panel in the kind of utopian thinking that Mark Tishnet's going to talk about a little bit later. And so we actually have a really interesting experiment, a really interesting kind of test case where you have an administration that openly lies about lots of things and doesn't seem to have much remorse about it. This is not, one doesn't need to be partisan to say this is not typical behavior from a presidential administration to lie so openly. I actually think that the behavior of the administration is something that falls into the definition of judicial notice within the federal rules of evidence. That this is a lying administration is something about which a judge could take judicial notice. They won't, probably, but even putting that on the table is to say that that the level of deference that one gives to executive policy very sensibly should change depending on who's doing the policy making. Are there other responses or interventions?
Respond to that for a moment. I mean, for one thing, I don't want everyone to be depressed. I mean, I think that there's a political mobilization around legal issues. In other words, there's a political mobilization around the issues that Neil and Bill were talking about sort of what the essential role of a legislature is, what is appropriate. I also think that I want to pause. I want to press the pause button before we talk about even envision major structural changes, because I want to understand whether or not Trump was an aberration. I want to understand whether Trump was sort of the perfect storm of a number of issues and therefore not go to changes in the constitutional framework if he is only an aberration. And then in terms of the notion of deference, it is not an unusual observation to say that the context matters. And as I was saying in my presentation, if you believe that the discrimination is largely over and the market is perfectly rational in terms of who it values, then you believe that the discrimination cases should be restricted to the aberrant actor, the intentional discriminator who just didn't get the message. If you believe that there are structural issues in discrimination, you might interpret the discrimination laws differently. I think that judges necessarily will take into account the context in which, and that's what they did with the Muslim ban was issued. And it's not a sort of precedent for future presidents in the sense that this kind of situation I can't imagine would recur. It is so clear that if Trump had waited a month to implement the ban with appropriate levels of decision-making and findings, the result would have been different. So if a court takes into account this context, this is just as they would have taken into account a different context, which may have been better at obfuscating what his real motives were, but it would have been a different result. So I don't have a problem recognizing this particular context and saying it was extraordinary, and you take into account the things that he said, and that's still within the frame of judicial decision making. That's still within the frame of what should I take into account and what not.
So I'd like to briefly respond to Nancy and to Jamal in response to the idea that it's hortatory or merely hortatory. I'm trying to act within the existing constitutional structure because it's not going to meaningfully change, right? So I don't think Sandy Levinson, for example, is proposing ideas that are actually going to come close to coming into operation. And I also think there'd be at least a number of them there'd be reason for concern if they were. So the question is, how do we do the best we can operating within the existing structural arrangements? And I can't say that I'm terribly optimistic, but I'm also not just pessimistic. There are things to be done, and things could look very different in 2018 or in 2020. So I think a noble charge for law teachers over the long run is to teach the future politicians in their classes, not just the future judges, that a restraining role morality applies to their own counter-majoritarian elections and conduct. It's not going to happen tomorrow. It's not going to be immediately relevant to a judge deciding a case. But if we have this culture of role morality with respect to judges, we don't with respect to politicians, because we buy this stylized idea that the legislators speak for the people, the president speaks for the people, and it's often simply not the case. I think more immediately, I agree with you, it's political. I mean, I've heard a good number of liberals say, I get it, elections have consequences. And that is accepting, right, the conversation stopping quality of the claim. Look, we won, you lost, get over it, we can do what we want. And I don't think I think it has consequences in the world the more people on the ground, people in Congress, people in state houses, people on editorial pages push back against that. That in fact, you didn't have majority support when you won, and you have even less support now. And I think that speaks to Jamal's observation. You know, I'm not an empiricist, and I'm not operationalizing much of anything. There are problems with using any baseline measure, but I'm just not sure how much of a problem that is for my project. I think if Trump's approval rating was at 3%, we wouldn't be at a conference, we'd be in the streets, right? If it were at 80%, I think my project really would be purely theoretical, not practical, right? But we're going to have these kind of razor's edge elections, I think, for the foreseeable future, and the kinds of concerns that I'm raising are going to apply regardless how you exactly operationalize it. And having said that, you know, I mean, I think we can be confident. I mean, the polling before the election is tracked pretty precisely, the extent by which Hillary Clinton beat Trump in the popular vote, right? And since then, if you look at issue after issue after issue and poll after poll, including questions phrased differently, much more often than not, Trump lacks majority or plurality support. So the idea that we simply can't know whether he's a majoritarian, supermajoritarian, or minority president seems to me implausible, right? His approval rating is what, at 35%? It matters whether it's 35 or 55 or 65. So again, I agree that it's difficult. I'm not sure how much that matters, and I'm not sure in this particular case whether we simply can't know.
Well, I partly agree with Neil and I partly disagree with Neil. Because the disagreement comes where it's hard to figure out what majoritarian is. I don't think the obligations that you're talking about should make a difference whether Hillary Clinton won the popular vote or if she lost by 25 votes or 500 votes if we go back to the election of 2000. I think you're talking about something more broadly about kind of a duty that politicians have to even the people who didn't vote for them as well as the ones that they did. And phrasing it as majoritarian I find a little bit troublesome. I don't think Obamacare had a majority support at the time it was passed. I think most of the country was against it, as I recall, at that particular point, because of the way it was framed. So I'm trouble doing it that way. But I do want to get back to this kind of hortatory note. Yeah, we aren't going to come in there with courts to enforce what some of us are talking about. But I do think expectations make a difference. And if you tell a politician that if they get into office, they can do whatever the hell they want because they just won, that's a different set of expectations than if you say, look, office, you've got a broader obligation than just simply to that kind of constituency. So I think it does actually change the way people behave. I think if we tell Congress, I think the Freedom Caucus is all about saying we were elected to say no. And that's all we have to do to fulfill our constitutional duty. And I think, and right now, by the way, there are a number on the left who think that they are there just to say no. I think telling members of Congress that actually you have an obligation to do something more than that can change behavior. It's not going to happen right away, but I do think the dialogue is worth changing, and changing the dialogue that does have results in the long term.
I have plenty more for us to talk about amongst ourselves, but I want to give the audience a chance to weigh in. Maybe we'll start with Pam, and then we'll move on.
So this was a terrific panel. The thought I have is the following, which is you've been focused a lot on the structure, and that's true in particular with regard to Congress and elections and like. But one of the things that strikes me as not exactly hortatory, but something we ought to be talking more about is the fact that Congress, and this is a point that James Bradley Thayer made more than 100 years ago, that Congress and people don't make constitutional arguments anymore. And so one of the striking examples of this is, Arlen Specter voting for a bill and then filing an amicus brief with the Supreme Court saying, strike down the bill I just signed because it's the bill I just voted for because it's unconstitutional. Or one of the frustrations of the Gorsuch hearings was the utter inability of most of the members of the Judiciary Committee to have a serious constitutional discussion, because even if they could read the first question that their staff member had for them, they couldn't follow up at all. I mean, you saw, Amy Klobuchar did a pretty good job, Dick Blumenthal in the second round of questioning, but a number of them, especially the ones near the top, they couldn't have a constitutional conversation because they don't actually understand the Constitution. And so one of the things I think that we need to press for is understanding the Constitution and taking it into account. And the place where I would argue perhaps we ought to be pressing for this especially is the one part of the Constitution that we all care a huge amount about that specifically tells Congress they're supposed to be doing something, which is Section 5 of the 14th Amendment. And one of the ways we should be pressing is to say, your duty is not just to pass the budget, your duty is to enforce the Equal Protection Clause and the Due Process Clause. And you're not doing that. And so I just wonder whether that can be folded kind of into the program you're talking about, especially Bill and Neil and Jamal, but maybe also Nancy.
That's a brilliant argument, Pam, as usual. I'm not sure how to put that into the framework that I'm doing, frankly. I got to think about how you get that and what that means exactly. But I think I'll just compliment you for making a great point and tell you I got to digest it a little bit.
Yeah, I think it fits comfortably within mine. So when I think about people, there aren't people doing constitutional theory who are making the kind of argument, as far as I can tell. But when you think about how Burke thought about the duties of a legislator, or wasn't it your colleague Paul Brest on the conscientious legislator, member of Congress, right? That there's a role morality that's restraining. And part of it, look, I think whether it's minority or majoritarian, it's not all that matters, but I think it does matter. But I also think other forms of normative self-restraint, like constitutional limitations, right? Or constitutional obligations, responsibilities to legislate. Now, one way to try and operationalize this, because I share, right, without naming particular senators, I share your concern about, Pam, I'd love to have you there. I wish a senator could give you their proxy, right? And you could not just ask the first question, but the second and the third. Because the senators are trying to say, wow, this is pretty extreme, and the nominee's saying, actually, this is utterly reasonable. Right? I'm just doing my job. And then they don't know the doctrine, what it is, what might be wrong with it, which way it's heading. They don't know enough of that. So one way to try and operationalize it is that, right, maybe the law professors shouldn't be. One reason that law professors have some influence with judges is because they send them law clerks. It's not the only reason, but it's one. Right? it would be nice to be sending people to the members of the Judiciary Committee, staff members, right, graduates, some of the top graduates of the good law schools. And it's not just judicial clerkships, and it's not just in the executive branch, but they're actually Judiciary Committee staff who can then work with the senators, and not just when the hearing arises. Now, the senators are insanely busy. Being around them makes me not want to be one, right? They're doing a lot of other things, but some way of not just telling them this is important to your job, but here's how to operationalize it. We're going to give you, right, the kinds of minds the justices have, other federal judges and state judges have, in order to develop that kind of interest and capacity to execute when it matters.
I'm just going to very briefly add something that I think sits in slight tension with the way the conversation has been going, but I think is sympathetic with, I think embedded within Pam's question, is that it need not necessarily be the case that the way in which members of Congress think about the Constitution is the way in which judges think about the Constitution. So that it may be that the members of the Judiciary Committee can't go toe-to-toe on Supreme Court doctrine with Neil Gorsuch, but I don't think we should expect them to do that. And I think it might be quite fruitful, actually, for them to not do that, which is to say, rather than having a conversation about, well, do you support this precedent of the court, which is going to be framed in very particular doctrinal terms, to say, well, what do you think about a right to health care? And he will still say, well, I can't talk about that because blah, blah, blah. Well, here's what I think. To articulate a more of a legislative constitutionalism that doesn't rely on the various constraints, institutional constraints that we apply to judges. Riva.
Thanks. So just on that one point, and then I'll throw my question out. It could be that in the hearing setting that the senator's goal might not be to reflect on legislative constitutionalism, in other words, what would be within their own role ambit, but to be in a dialogue with their constituents about what the stakes of the nomination decision is about. And that's going to sound different than the kind of conversation that Pam would have if she were going toe-to-toe with Gorsuch, but it might be just fine if people were clear about what the role there was. That is to say, to explain the link between their choices and the electorate's choices when they go into the polls, namely that voting for public officials is part and parcel of picking judges and why that matters. And that's a different way of understanding constitutional stakes, and they're just two very different pictures of what could be going on in the hearing, and I think Neil had adverted to that. So my second point was going to be about this right to health care that Jamal just invoked. So Neil, if I understand, I may be misunderstanding you, but if I understand you, you're talking about a way of talking about the role limitations of elected officials through this critique. So it becomes a way of imposing limits on what it is that they have authority to do in office if, in fact, their basis of support is less than the stylized picture we have of majority support. I was listening to and thinking it might also be a way of imagining making claims on authority for those who don't have governmental power at the moment. So on this very right to health care point, I think I mentioned to some folks at dinner last night, it's possible that what we just witnessed in the healthcare vote debacle is the emergence of some public understanding of there being a right to health care. That as the Republicans went after the ACA over time, they shifted from repeal to repeal and replace, and they shifted from talking about mandates and death panels to, your premiums are too high, or they started talking about the quality of the public good that you were getting, such that they raised expectations about what was out there. And the polling at the time of the president's proposal seemed to suggest that people actually thought there should actually be health care. And it could be that one entailment of what you're saying, Neil, is the idea that people should actually talk and speak like they actually have authority to speak for the people, even if it diverges from what it is that the Congress is saying at any given one point in time, or the president is speaking at any one point in time. And that this even could be done in a way that tries to bridge in some of the ways that Jamal was talking about. namely that some of this could be talked about in terms of where there seems to be support across party lines. That was my sort of rumination on the healthcare exchange.
Yeah, I mean, I was thinking about it in light of our conversation last night, and I think what you're proposing is very much part of what I have in mind, right? It's not just what members of, well, I think it's part of restraints on what those who our electoral processes have conferred legal authority to act upon, what they should feel entitled to do, right? The fact that they won and the fact that they want to and the fact that they promised to, right, doesn't necessarily mean, or asserted they, doesn't necessarily mean they get to do it. And why might it mean that they don't get to do it? Because you have other people pushing back, right, saying no, say actually we are entitled to this. This expectation, right, has arisen over the past 8 years, and you're going to pay a price if you now suddenly take our health care away, right? So it's that's what I mean about practices of political resistance. It's empowering people out of power on the ground to speak the language of democratic legitimacy, and I think you could say individual entitlement, right, or statutory rights, which I think is part of what that kind of democratic legitimacy confers. So the ACA, when it's passed, doesn't have majority support. It does. It gains majority support finally at the very moment it's most existentially threatened with repeal. And I think what you saw is more moderate Republicans in the House taking pause and saying, we just can't go there, which is.
But it's not just auditory, it's framing, start speaking that way. In other words,
Right.
don't wait for an election, just start speaking like there's now a mandate.
That's right. I mean, it's expressing. It's now at the town halls, right? It's at the town halls in which you have, conservative citizens booing, right, conservative politicians who are just continuing to say what they've been saying for the last 8 years, which is we're going to get rid of this thing. And the answer is actually no, you're not.
But how do you figure out the time of the majoritarian action on that? I mean, because at the time, it's why look. I mean, I like where you're going as a policy matter, but why is now the relevant time as opposed to the time the ACA was passed?
I act as a political scientist when you're answering. In other words, you could ask that question as a political scientist, or you could just, as a citizen, sort of take the occasion to start speaking a certain way. That is to say, to register that this support exists and start claiming it as authority.
But the other side of the coin is the other side of the constitutional debate that has become part of the public discourse, which is the public debate about the Second Amendment, the public debate about religious rights. I mean, this then becomes, and as well it should, a robust discussion of political constitutionalism, where we talk about what the Constitution requires, but we have to be ready to. But it's on all sides. It's really on all sides, particularly on the religion area, and particularly in the. It's one thing to talk about the ACA, but you also have to talk about the cab driver who took me here last night, who was pro-Trump because he believes in his gun rights, which made me feel really comfortable.
That's what we have, and so the question is
Right.
to engage in it or not.
No, absolutely.
Progressives being quiet is not going to cause it to go away.
Right, and in fact, you have to meet those.
Reticent.
But you have to meet those arguments. Also, to Pam's point about, I am not convinced that even you're talking about not only knowing the Constitution, but the constitutional implications, so that you can ask not just the first question, but the next three. I'm not persuaded that even judges and law students know how to do that. That is to some degree related to my this incredible focus on the minutia of constitutional litigation as opposed to the big picture of constitutional litigation, which applies to law students and which applies, I think, to judges as well. So I'm not surprised that the Congress can't figure out the next three questions, because many of my students can't either.
So I've been authorized to go to about 12:35. That's in about 5 minutes. I'm going to take a couple of questions at a time and see how far we can go with that. So Mark Tushnet, and you had your hand up, Jack.
This is a follow-up on Jamal's idea about disintermediation.
and it's about a disintermediation that's actually directly I think, in our domain. Because time's limited, I'll just be very assertive about this. There's been, again, I would have to defend this in more detail if I had more time. There's been a rise of what I think of as legal hackery, where people, I have some in mind, who read the newspaper and find out what their side wants at the moment and generates constitutional arguments in support of their side's position at the moment. And I think that's bad for the academy. It's bad for us as academic lawyers. And I think we actually probably have some obligation to call them out. But that's in some tension with Bill's idea about engaging in civil discourse. If I say X is a hack, it's not a nice thing to say. Although X is a hack.
And then, yeah, I just wanted to sort of ask about Judge Gertner's initial point and maybe tie it to the previous panel a little bit. So there's this, we think about courts and their ability to respond to social movements, but there's this whole separate issue of justiciability doctrines and these, various mechanisms for judges to duck, avoid, and evade. And because those doctrines are so baroque, and because it's more of an sort of overarching issue of how to get cases to proceed to the merits, it seems difficult to build social movements, to build popular support around reforming those doctrines. You can't get people to protest about standing in the way you can about police practices. And so I was wondering if there's a way to make those issues more salient to social movements or to the population, how the courts would then respond to that.
So just a public service announcement. Right after this, there's a rally about mootness on the green, so bring your signs. Yeah.
I thought it was canceled.
Yeah. So I don't have a great response to Mark on legal hackery. I mean, what it sounded like you were describing is lawyering, which is you decide what you're to pursue that position. One wants to distinguish between academics and lawyers. There's not to bite the hand that feeds you, but there may be some tension with organizations like the Federalist Society and ACS blurring that distinction, and I think that's something that we as academics have to be very attentive to. Is engaging in sympathetic argumentation rather than being part of the problem.
But I mean, you raise an interesting point, which is that these discussions are taking place in the public forum, and if people are translating constitutional rights to support one side or another, I think you have to respond. Maybe it's not the academy, but someone has to respond. The sort of legal blogs have bled into something less than an academic discourse, but I do think you have to respond. I spent some time writing an op-ed about Gorsuch when I finally unpacked what his rejection of Chevron deference meant and how it was the reverse of this view that he was, limited judicial approach. When you took out Chevron deference to administrative agencies, he was just making stuff up. The only way to describe it, but I mean, I think so figuring out how to translate that to a wider audience then can deal with the teaching the public about implications. Justiciability is a hard one to popularize. There's no question about it. But I think that then there's an interesting question, and I'm struggling with how to answer it. Even when you're talking about doctrines that seem to cabin judicial decision-making like that, there are always a range of options. These are not decisions that you plug into, Watson and come out with an answer. And so one interesting thing is I've seen empirical work now on courts, individual judges, for example, and how it happens that I haven't seen it with justiciability, I've seen it with civil rights, how it happens that they throw out every civil rights claim. And in fact, there was a study of judges in Atlanta. Some of the judges had 100% rejection of civil rights claims. Now, I don't know how the doctrine can be sort of transmogrified to that extent. It can't be that every case is meritless, but it seems to me that that's something that you want to raise, because there's always play in the joints, and if you're putting people on the bench who only see the play in one direction, we have to call it.
Yeah, Mark, I agree with you, but that obviously if there's political hackery going on, you call out political hackery going on, but there are ways to do it. And it's not just the politician that you want to criticize, it's figure out who your audience is. Are you just trying to fire up your base to talk about how bad the other side is, or are you trying to bring people onto your side? I really don't think the Democratic tactic of telling people how stupid they are as a reason for them to vote for you is a good one. And it's about time we stopped. I think it's time to sort of try to figure out common ground. You may not get the politician. And the other part of it is we got to call out ourselves. I mean, we can make fun of Mitch McConnell all we want of accusing the Democrats of being obstructionist. But our dances that we did on the filibuster have less intellectual, it does the same amount of intellectual dishonesty that the other side does. And if we aren't being harsh on ourselves, we don't have any credibility with anybody else.
Bill's a stupid hack.
We can all agree on that.
We'll reconvene at 1:45. Please join me in thanking our panelists.
That was a great job. I wasn't sure how we were going to pull it off, but it was a great job.
Is it just that it's too hard to figure it out? Or is that even if you do it?
That was helpful. I keep on wanting a proposal for tomorrow. That's what you're hearing.
So what I need to do is I'm much more comfortable about the fact, you simply say you're the legislature, you're the president, you speak for the people. So that if you want to justify your action, you need something else. Other than simply I speak
Nice
for
to
the
see you
people.
too.
But I agree that speaking for the bare majority versus speaking for the
Yes, gotcha.
I mean, not senior, I'm sorry, you're the third year.
Yes.
All right. So many undergrads don't work with it anymore,
Yeah. I'm going to work with the Justice Department. Actually, I'm going to Texas. I'm in one of their other courts. I've actually never been to Texas before, but Fort Israel, which is like the very southern tip.
Texas, tough state. You're not in Austin. Tough state.
Yeah, I'm gonna. Well, I'm gonna go visit right after graduation. Right by South Padre. So I'm gonna go with my mom and we're gonna go have vacation while we meet.
One of the interesting strategies a lot of agents is to, maybe this counts as hortatory, but I think not useless, is to actually,
The afternoon session?
it's somewhat counterintuitive to
All
try
right,
to
good.
good lawyers in front of hopeless judges to show them that not every claim is fake.
That's the first step. I haven't seen Kate and Joey for a while.
Well, Kate was at lunch.
Yeah. See how Ashley did up there.
I achieved that myself.
You did, okay.
I went down. I
did
found.
request that
I
we
went
would
down
have those.
and found a soda machine.
Good work.
And
I
I
knew
paid
where that
$1
is.
for my Diet
I could
Coke
do
in
that.
the basement.
But,
so I acquired it
my request was
on my
more
own
than-
at great. Yeah. So I was surprised we didn't have them. And
Yes.
so
Thank
I sought it out. Yeah.
I'll criticize someone for that. Okay, if everyone could please take your seats. We're going to start in 1 minute with our afternoon session. All right, well, welcome back to our afternoon session of the future of the United States Constitution. I think that's our title. We settled on, yes, the future of the U.S. Constitution. And I'm Dawn Johnson, teacher at the law school, and I will be taking part in the next and final panel. For now, I just wanted to welcome you back, take the opportunity again to thank those who work so hard to make this possible. Again, I don't see our events coordinator, Chelsea Browning, in the room, but special thanks, shout out to her and all the students. Thanks to all of our visiting panelists for being with us. Thanks to all of you for coming. So I am just going to very briefly introduce the next speaker, Professor Mark Tushnet. Those of you who are here in the morning know we are dispensing with lengthy bios. You have a little program that has really just a short bio of these really incredible constitutional experts we're so fortunate to have with us. Thank them again for coming. But I just want to say just a few words about Mark Tushnet in particular, by way of introduction, and then have him kick off the afternoon, final two panels. So you can read his bio. Mark Tushnet is the William Nelson Cromwell Professor of Law at Harvard, and a lot of other impressive details in there, including written more than a dozen books, including the most widely used constitutional law casebook, which I have used for many years and recommend, co-author of that casebook. I just want to add to what's in the program that what is perhaps more relevant to our discussion today is at least as much as anyone out there, Mark has been leading these kinds of conversations about constitutional meaning for decades, as long as I've been teaching and before, when I was in practice, very aware of his work as well, in trying to work on helping to develop constitutional meaning from nonprofit advocacy, and then working in the Clinton administration, Department of Justice. So Mark is just, I just want to say I consider Mark one of our moral constitutional consciences, keeping us on the right track, looking at the long term, looking to really develop the future of the U.S. Constitution. And in particular, I want to mention Mark's critical role in the formation of the American Constitution Society. I forget now how long, almost 20 years ago, when those conversations started, and the need for an organization like the Federalist Society that existed already at the time to be thinking about these big picture, long-term progressive questions. So it's a particular privilege to be able to introduce to you and say thank you to Professor Mark Tushnet.
Thank you, Dawn, for that overly generous introduction, and thanks to everyone who's been involved in the organization of this event. About a year ago, when, as we heard this morning, circumstances were different, I wrote I think I have to call it now, notorious blog post called Against Defensive Crouch Liberalism. It wasn't notorious because of that theme. It became notorious because of something else embedded in it. It's not worth going into, not relevant here. And the idea of defensive crouch liberalism was that for a long time, progressive litigators who had to deal with the Supreme Court would count votes and figure that to win, they had to develop arguments that would have some chance of getting votes from Justice Kennedy and maybe Chief Justice Roberts. So they would say, well, maybe we can win by showing how what we think the Constitution means in this case is consistent with what, say, Justice Kennedy thinks it means. It means in some other case. And now for litigators, although I should note it's not the only one, studied the Jehovah's Witnesses litigation in the late 1930s, early 1940s, and their arguments were, I think it's fair to say, non-standard arguments. Their arguments were, you judges should rule in our favor because that's what the Bible says you should do. Now, this is not an argument that persuaded the justices, but it made them think hard about what claims these people were making. So under the circumstances, the defensive crouch liberalism made sense for litigators, and to the extent that scholars think of themselves as providing theorized or more reflective arguments that litigators can adopt or adapt, it's also a sensible course for some progressive scholarship, even if, since I don't engage in litigation, I have a certain detachment from reading. When I read this kind of progressive scholarship, even if it sometimes seems to me to treat, say, Justice Kennedy rather implausibly as having especially deep insights into what the Constitution really means. But defensive crouch arguments aren't the only ones worth making, and even, I want to say even now, they're not the only ones worth making. So on the first page of Rousseau's Social Contract, there are there's one very famous line, and then there's another line that I am going to take off from. The most famous line is, people are born free, but everywhere they're in chains. But he also says, again, it's on the same page, describing what his project is, I'm going to take people as they are and laws as they might be. So my description of utopian thinking for progressive constitutionalists is, well, let's take the Constitution as it is, and the Supreme Court, and Congress, and the polity more generally, as it might be. Not take what we have now, other than the Constitution, as fixed. Now, here are some examples of utopian constitutional theory. So, affirmative action. A robust defense of affirmative action might sound in restorative justice or reparations or distributive justice. And indeed, before the Supreme Court forced progressives into, again, the defensive crouch of justifying affirmative action as promoting diversity, progressives did indeed defend affirmative action on those broader grounds. Now, what's happened, because of the way the court has shaped the discourse, we've gotten increasingly ingenious articulations of the diversity rationale for affirmative action, but utopian progressive theory might return to the themes of reparations and distributive justice, for example. Similarly, with campaign finance, the court has held that regulation of campaign finance can be justified by showing only by showing how regulations reduce the risk of corruption, and so progressives like Larry Lessig and Zephyr Teachout have come up with sophisticated accounts of what corruption actually is. And there's nothing wrong with that. But there's another path to take, and it's actually, I think, the path that motivates people who are interested in campaign finance regulation. That is, unregulated campaign finance is inconsistent with our fundamental commitments to political equality. Now, it turns out, in my view, that working out an account of political equality that will lead you to justifiable restrictions on campaign finance is going to be quite difficult. And there's a task here, an intellectual task. But again, putting aside the defensive crouch and thinking about what we really believe, it's pretty clearly worth devoting a fair amount of energy, intellectual energy, to working out that notion of equality. There are lots of other areas in which utopian theorizing might be useful. For me, a prime candidate would be developing a theory of constitutionalized social welfare rights, like the right to health care that already was articulated and talked about this morning. Others might be more interested in developing a theory of constitutionalized environmental protections. Both of those would, of course, reach well beyond where the Supreme Court currently is. There's another kind of utopian thinking, which I want to sort of label institutional utopianism, and this is, I know there are people who clearly will disagree with the idea that what I'm about to describe is worth pursuing. So I myself think it's there's an important task to be done in what I would describe as delegitimizing the Supreme Court. This is picking up a line from, I think it's Dahlia Lithwick. I think I actually do think we should start writing articles that say, in an opinion for the Supreme Court, Justice Neil Gorsuch, parentheses, Republican, Colorado, held thus and so. Just to make it clear that there's a discourse about politics and partisan politics on the Supreme Court that we think that the partisan dimension of the Supreme Court is really worth emphasizing. I've taken this project of delegitimizing the court pretty much from the beginning of my career. My first article as an academic was called "Only Wealth Will Buy You Justice." This was written before Citizens United, so I feel, I was ahead of the curve on this. And I'm going to come back to this article at the very end of my talk. The other thing that I think we really should start thinking seriously about and writing about and bringing to people's attention is there's this discourse going on that, well, if Trump gets another Supreme Court appointment, the progressives will have lost control of the court for a generation or two in the future. Maybe not, and the reason is maybe not. I myself think that at the moment political conditions are ripe, we progressives are entitled to two more seats on the Supreme Court. One to nullify Gorsuch's vote, and one to get the vote that Garland should have been gotten. So now, how do you do that? Well, you add 2 seats to the Supreme Court. Nothing, if it should so happen that both Justices Ginsburg and Kennedy leave the court before 2020 and the Democrats retain control get control of the presidency and Congress in 2021, I think we ought to have in our pocket a proposal that says we're going to expand the size of the Supreme Court. That would be a 6-3 court to 13. So we'd have 7-6 because they, stole it, in my view. So we can steal it back. This is, what's his name? I think it's Senator Hayakawa's line about the Panama Canal. We stole it fair and square. Okay. So all of this raises another question, and this picks up on a theme that was introduced in the last panel. In what sense is this a project in constitutional theory rather than in merely political theory? So how could these theories be connected to the Constitution? Well, the first point is, and it's been made already, that the Constitution isn't, contrary to Chief Justice Hughes, only what the Supreme Court said it is. It's also what the American people say it is, even when what the American people say it is contrary to what the Supreme Court has said it is. That's what the scholarly literature on how social movements shape constitutional law demonstrates. Of course, you got to make some lawyerly moves to connect the utopian claims to the Constitution, but at least for the topics I've suggested, those moves aren't esoteric. Indeed, they're pretty straightforward, invoking the way the language of equal protection of the laws has been used in U.S. political discourse would actually go a long way to connecting the utopian accounts of affirmative action, campaign finance, and social welfare rights to the Constitution. And here I think of the academic work of Jim Pope and Willie Forbath and Joey Fishkin. Second, because the Constitution is owned by the people, we can look to the ways in which constitutional has figured in political discourse in the United States to find the connections we need between the utopian accounts and the Constitution. In all the examples I've given, and I'm sure in many others, we can find a reasonably robust tradition of constitutionalized public discourse. And often enough, when that discourse was going on, everybody knew that the court then in place, the Supreme Court as it was, wasn't going to adopt the utopian arguments, but that didn't stop people from making them, from saying that the Constitution allowed or required what they were arguing for. The fact that the American people have defended seemingly utopian programs in constitutional terms puts the programs within the domain of the Constitution. Now, doing utopian thinking of this sort, of course, as Dawn's comment introducing me suggested, requires adopting a long time perspective. The court, as it is, and as it's likely to be for the next how many years, unless people get on board with my, expand the court idea. It isn't going to endorse utopian interpretations, although here too, we shouldn't discount the possibility that one or two justices might do so. Here I have in mind Justice Sotomayor's dissent in the Schutte case, which comes within inches of saying that affirmative action is not just constitutionally permissible, but constitutionally required. That's something that even Justice Marshall, my Justice Marshall, never said. So again, without disparaging the admirable efforts of litigators to squeeze out of the Supreme Court as it is, the victories they can achieve by taking a defensive crouch, we can also build a repertoire of arguments about the Constitution as it is and the Supreme Court as it might be, as it might someday be. And I want to end with this, I've been a law professor for a long time, and, I see, Times horsemen, around me. And so I want to end with, I think, a statement about the attitude that we ought to have at this point. It's from the Italian communist Antonio Gramsci. It gets translated in various ways. This is my preferred translation. It is pessimism of the intelligence and optimism of the will. Thank you.
So thank you to Mark for those great remarks. Officially on your program, you'll notice that we are switching to a new panel on economic inequality and plutocracy. And to start us off, I wanted to first thank Indiana University for having us at this great event, and ACS for sponsoring this and putting it on. And I also want to thank Dawn for all her hard work in helping this happen. You all know her as a professor, and maybe from her days in the Clinton administration. I first encountered her when she was on the Vice Squad in Miami, and feel like that was really one of her great contributions. But what can you do? Dawn Johnson. So a quick introduction of somebody got it there at the end, I see. So a quick introduction of our panelists. Mark, you've already met. Next to me here is Joey Fishkin, who's a professor at the University of Texas Law School, and this year is a visiting professor at Yale Law School, and the author of a great book called Bottlenecks on Opportunity. Kate Andreas, at the end of the row, is at the University of Michigan Law School and was formerly an associate White House counsel during President Obama's administration. I'm Ganesh Sitaraman. I teach at Vanderbilt Law School. So the topic today is economic inequality and plutocracy. And we all know a fair bit about economic inequality, and maybe even about plutocracy. We all everyone in this room lived through the 2016 campaign. We may wish we had not lived through it, but we did. And on both sides in that campaign, whether it was Donald Trump's campaign or Bernie Sanders' campaign, there was a lot of talk about economic inequality, economic anxiety, and how economic inequality had turned into political inequality and resulted in a rigged system that was making America work for the wealthiest people, the plutocrats, and not for everybody else. If we dig a little deeper, you probably have heard of Thomas Piketty's book, Capital in the 21st Century, on the rising share of wealth going to the top 1% and 0.1% of people in America. And you probably have heard a lot of news in magazines, articles in the newspaper, even TV shows about the shrinking middle class. And so the question is, what does any of this have to do with the Constitution? And I think what we'll get today are some different perspectives on that from members of the panel. I'll start by giving you mine and then turn it over to Joey and Kate to add to it with theirs or to disagree with it as well. So my argument is that the Constitution doesn't say middle class in it. It doesn't say economic equality. It doesn't say economic inequality. In fact, it says nothing about any of these things. But I think economic equality, relative economic inequality, a large middle class, is actually central to our constitutional system. And the reason why is that we first have to go back and look at the basic design structure of our Constitution. So for most of the history of the West, people were very concerned about inequality. They were worried that if you had a divide between rich and poor, the rich would oppress the poor, or the poor would try to confiscate the wealth of the rich. And the result is you would have strife, violence, and revolution. The answer to this problem, the way to solve the instability that came from economic inequality, was to build economic class right into the structure of government. So in England, you have a House of Lords for the wealthy, you have a House of Commons for everybody else. In ancient Rome, there's a patrician senate for the wealthy, there's a tribune of the plebs for the plebeians, for the poor, for everybody else. And the idea is that both economic classes have a share and a stake in governing, but also a check on the other. And that's what creates stability in the system. Now, you'll notice our Constitution doesn't have a tribune of the plebs. Our Constitution also doesn't have, say, property requirements for becoming a United States Senator or President, a member of the House of Representatives. And that should be surprising to you, because in fact, most governments prior to that, of these kind of Republican forms, had some design structures like that. In fact, our own state constitutions at the time of the 1770s and 1780s had these kinds of design structures within them, but our federal Constitution does not. And I think this is a big change in constitutional structure, and it's an important one. And the question is why? And one of the core reasons why our Constitution isn't one of these, what I consider class warfare constitutions, because they build class right into the Constitution, is that America at the time did not have the deep divides in inequality that we might think it did. In fact, at the time of the founding, America was relatively equal economically. I know that may sound crazy to you, but let me explain. In the late 18th century, America is a pretty sparsely populated place just on the eastern seaboard of the Atlantic Ocean. There are some medium-sized cities, Philadelphia, New York, but nothing huge. And the real center of the universe for the Americans is Western Europe. It's London, it's Paris. Western Europe is what civilization is to them. And when they look across to Europe, what they see is how different they are. There's no feudalism in America, unlike in Europe. There's no hereditary aristocracy in America, unlike in Europe. The richest people in America, people like George Washington, who have these big estates, great houses like Mount Vernon, are just nothing compared to the dukes and duchesses in England who have gigantic marble palaces. I mean, if you've been to Blenheim Palace, for example, that place eats Mount Vernon for breakfast. I mean, it is just a gigantic palace. The scale is unmeasurably different. The last change is that America has vast lands available to the West. And so what that means is that any white man, we could talk about race and gender issues, but it was limited to white men at the time, could become a property owner and have a measure of economic equality and share in the egalitarian system that was late 18th century America. And so with this in mind, the founding, I argue, actually was a period of time in which the social conditions in America, relative economic equality, meant that you didn't need to entrench class right into the structure of government, and we didn't in our constitutional system. The challenge today, of course, is we now have increasing economic inequality to a pretty severe degree. One quick stat on that, in 1976, the top 1% of people in America took home about 8.8% of the national income. Today, they take home more than 20% of national income. That's a huge difference, 8.8% to 20%, going to the very, very richest people in the country. That's the kind of inequality that our Constitution didn't contemplate. And I think it's a threat to our constitutional system because our Constitution isn't designed at a structural level for that degree of economic inequality. And so that's the argument of my new book, which I encourage you, just to plug for myself, to buy. It's called The Crisis of the Middle Class Constitution, available Kindle, Audible, and hardback. And so I'll stop there and let Joey take it from here.
Nice. Illustrated plug. That's great. So, thanks, Ganesh, and thanks to Dawn and to everyone who organized this great symposium. So I'm working on a book project also, which I'll just get right out there and plug at the beginning, although it doesn't yet exist. It's going to be called... Yeah, thank you. Yeah, it looks like that right now. It's called The Anti-Oligarchy Constitution. It's with my colleague Willie Forbath. And as you can imagine, since the election, we've been hearing from a lot of people saying, hey guys, it's your year, you know? I mean, last year Bernie Sanders talked a lot about the 1% and about billionaires, but I don't think anybody contemplated that it might be the case a year later that actually 1%, nearly 1% of the billionaires in this or their families would actually be running the administration. That concentrates the mind. And because of that, and also because of President Trump's sort of mind-boggling refusal to put any more than a very thin fig leaf over his conflicts of interest, there's a lot of talk about oligarchy now in what I'm going to label as kind of the Russian sense, that is ruled by a bunch of super wealthy, self-enriching insiders. And so you see the beginnings of a set of arguments about that that are starting to say, I think there's a constitutional problem here with this situation, and some of those arguments are crystallizing into arguments in the public discourse and also some lawsuits around this emoluments clause, saying there's a problem with all the money that's changing hands between Trump and foreign governments, and various things like that. So that way of thinking about this problem zeroes in on one of the ways Trump is very different from the Republican presidents who preceded him, like Reagan and George W. Bush. And I have no problem with making those arguments and trying to invigorate the emoluments clause, but I think that's not the right way to understand the constitutional problem of oligarchy in relation to our present situation. So oligarchy, the concentration of political and economic power in the hands of a few, is something that we all ought to be worried about if we're small r Republicans or small d Democrats. But I think the biggest danger is not in these differences between the Trump administration and recent past Republican administrations. It's actually in the continuities and where we've been headed since 1980. So this kind of way of thinking about oligarchy as a constitutional problem does not lend itself to saying this is a problem we're going to solve with a lawsuit in court. Today, unfortunately, and I think this has very interestingly become the theme of much of the last panel and of Mark's comments, unfortunately, most of us on the left and the right actually have come to think about the Constitution as essentially a court-enforced thing that sets the boundaries of politics. That's how we think about it most of the time. And that's not how Americans have always thought about the Constitution or about the constitutional problem of oligarchy. The rise in inequality that Ganesh described that we're seeing today, this concentration at the top, hollowing out at the middle, has actually happened before. And for a long stretch of American history, from the founding through roughly the New Deal, ways argued that changes like that were turning the United States into a society with a, quote, moneyed aristocracy or, quote, ruling class, an oligarchy that is not a republic. So, my book with Willie Forbath is essentially tracing the story of this tradition in American constitutional argument, most of which, but not all of which, takes place outside the courts, in campaigns, in legislatures, in state constitutional amendments, and sometimes in courts. There were arguments about constitutional political economy. And one set of those arguments that we are labeling the democracy of opportunity tradition argued, essentially, that we can't keep our constitutional democracy, our Republican form of government, unless we keep certain essentials, the first of which is restraints on oligarchy. Second is a political economy that protects and sustains a broad, open middle class. And then in Reconstruction, these principles become linked with a third idea, which is a constitutional principle of inclusion on the basis of race, and later on other bases too. And that last principle, inclusion, is interestingly the only part of this whole tradition that today sounds like constitutional law at all. Because today we think of equal protection, any claim that's about racial inclusion, we can see how it's rooted in Reconstruction and in the Equal Protection Clause of the 14th Amendment. But there actually was another equal protection before the Equal Protection Clause. In the early republic, legislators argued that equal protection and equal rights protected the rights of white men to a fair chance to join the middling classes that were the bulwark of a Republican government. And so they thought the Constitution demanded laws that protected us against oligarchy. And the result was that a lot of things that don't sound to us today like constitutional law have been viewed for long stretches of American history as being constitutional law. From antitrust law to tax policy, the regulation of currency, labor law especially. The predecessors of today's laissez-faire libertarian types were making constitutional arguments then as they are now. And the difference is that for much of our history, up through at least the New Deal, their opponents were making what they saw as constitutional arguments too. Again, not arguments directed primarily at courts, arguments directed mainly at legislatures, who are the ones who need to enact the laws that we need to maintain our democracy and avoid oligarchy. So in other words, in this tradition, the Constitution is mainly not a judicially enforced constraint on the boundaries of democratic politics. Instead, it's the substance of a democratic constitutional politics. And I think it still can be today. So today, that might mean that instead of just, and this is very much, following in Mark's tracks here, that instead of just arguing that the Constitution permits Congress to regulate campaign finance, we'd argue that the Constitution requires it because without it, we're drifting away from being the kind of republic responsive to the people that the Constitution clearly contemplates. Or we can make arguments about the middle class as a bulwark against oligarchy. We can argue, rather than just permitting Congress to enact Obamacare, the Constitution affirmatively requires Congress to do something to ensure that people have enough access to health insurance to have what we now view as middle-class lives, which, in the 19th century didn't require this, but today, having health insurance is part of what it is to be middle class. So this is an unfamiliar way of thinking about the Constitution because our current discourse has become so court-centric, but I don't think it has to be. And so I think part of the project of ACS going forward into the next generation is going to be to build out and more fully articulate some of these actually long-running but currently not familiar arguments about the Constitution that don't run exclusively through courts that can help us address oligarchy and questions of inequality.
Great. I also want to just extend my thanks to Indiana for having us, to the ACS, to the Law Journal, and really to Don, who's just done a tremendous amount of work in organizing this. So Ganesh talked about how our constitutional structure is predicated on the existence of a middle class, that it presupposes an equitable society and can't function in the context of extreme inequality. And Joey talked about how in the past our Constitution was understood to speak to problems of oligarchy, and it can today. I want to focus on problems of inequality today. It's the relationship between inequality and the election and responses to the election, and also a bit on constitutional doctrine. So I really don't think we can emphasize enough the extent to which ours is an economy and a political system from which many ordinary Americans feel excluded. They feel forgotten by those in power, and they worry that their opportunities are declining. And these perceptions are based in reality. As Ganesh has mentioned, as Joey's mentioned, income inequality in the United States is at its highest level since the period leading up to the New Deal. Ganesh already mentioned the statistic that the top 1% of earners in the US take home about a quarter of our national income. Another statistic that is just important to confront is that the 20 wealthiest people in the United States own more wealth than the bottom half of the population put together. So what that means is 20 individuals have more wealth than another 152 million people. Workers' real wages have barely grown during recent decades, even as productivity and educational attainment have increased. The situation is most dire for people of color, particularly African Americans, but white men have also fallen behind, suffering mounting health problems and diminishing opportunities. I live in Michigan, where you can drive through the state and see countless communities devastated by the loss of good jobs, and I imagine the same is true here in Indiana. And in the meantime, political inequality has soared as well. Here, the statistics are a little bit harder to just sort of encapsulate, but there's really some really striking studies showing the extent to which at every level of the legislative and administrative process, wealthy individuals and big corporations have more influence than ordinary Americans. So Jamal talked about how the decline of, I'm not going to be able to use his big the decline of intermediaries, the rise of disintermediation, played a role in this election. I want to talk about a different cause of this election. I think that Trump came to power in part because of these problems of economic and political inequality. His election, like others around the globe, reflected voters and really non-voters' widespread dissatisfaction with political elites and with our existing system. Unfortunately, I think most indications are that the problems in the political economy that contributed to Trump's victory will only grow worse under this administration. And of course, this inequality, I think, represents a failure of American politics, but I also want to talk about how it represents a failure of US constitutional law. Not necessarily a failure of our Constitution, but of the doctrine that's been elaborated by judges. So I'll give a couple of examples of how constitutional doctrine contributes to, facilitates this system of oligarchy or of political and economic inequality. So campaign finance, which has been mentioned already, is probably the most notorious and well-known example. Most people, I'm sure, are aware of the Supreme Court's precedent declaring that Congress cannot restrict expenditures in political campaigns by wealthy individuals or by corporations. Most people are also aware how weak the reasoning is in that in those cases, and that it is a product of 5-4 decisions, right? These cases could have come out the other way. And there's absolutely nothing predetermined about this doctrine, but it is the doctrine that we live with. But campaign finance is by no means the only doctrine to blame. So I want to offer two other examples. Our constitutional law recognizes almost no protections for workers' rights to organize and to strike. And as a result, a great deal of legal restrictions on the ability to organize, to bargain, and to strike are tolerated. And in practice, many workers in this country have very little right to engage, or at least no effective right to exercise the right to organize and to strike. And the consequences are significant. Some scholars estimate that the decline in unionization in the United States is responsible for up to 1/3 of the climb in income inequality in recent decades. Now, of course, I'm not suggesting that the only explanation for the decline of unions is constitutional law, or that the decline of unions is the only explanation for inequality. It's all far more complicated than that. But constitutional law has played a role, constitutional doctrine has played a role in these developments. And to be clear here, the problem is not a lack of supporting constitutional text or sound historical arguments, as the previous speakers alluded to. Another example is the doctrine on education, right? Despite the famous case of Brown, recognizing that education is a fundamental interest in our society, the Supreme Court has allowed vast disparities in educational funding without requiring governments to show any compelling reason for those kinds of disparities. And again, just an example from my state, there's pending litigation about this, but in Detroit, many students go to school with rats, right, with vermin, with no paper, with no water in the bathrooms, with sometimes no teachers to teach them, with no heat, no air conditioning, and functionally do not learn to read as a result. And there's litigation pending, but it's certainly under the existing doctrine faces significant hurdles if it is to succeed. All right, so that's bad news, right? And with respect to the constitutional law doctrine, I think things are likely to get worse before they get better. But I want to offer some reasons to be hopeful. The Trump administration's moves to consolidate power further have been met with an extraordinary outpouring of opposition. And much of this energy, certainly by lawyers, has been aimed at defending basic and long-standing constitutional principles like the separation of powers, due process, equal protection. as currently defined in the doctrine, in really important efforts. But I think the protests also suggest a more ambitious constitutional vision for the future. So in opposing Trump's nominees and opposing some of the recent legislative efforts, citizens have coalesced around support for a right to quality public education, one not privatized for profit. As was alluded to earlier, we've seen a remarkable outpouring of support for healthcare as a right, healthcare for the needy and maybe even for all. And we've also seen an outpouring of support for a more robust conception of workers' rights in the opposition to the first nominee for the Department of Labor. I think as progressive constitutional law scholars, we ought to take seriously the budding rights claims of the opposition around these issues of economic and political inequality. So basically, I agree with Mark and with the previous, with Ganesh and with Joey, that we should abandon any defensive crouch and start elaborating constitutional arguments that support this more ambitious and inclusive and vision for our society. I guess I'll just end by saying I would quibble with Mark on one point, which is I don't think this project should be conceived as utopian, at least insofar as utopian implies something imaginary, remote, or impossibly ideal. Because in fact, as everybody has acknowledged, many of these arguments were quite plausible, quite real, and for much of our history, or for certain points in our history, and they continue to be. And so I think we should view these efforts for change as both plausible and imperative. I'll leave it there.
Great. Well, thank you. So to this point, I think it's worth us talking for a moment about to what extent these are utopian arguments versus things that are both historically there to be revived or plausible in kind of a deep way. And maybe Mark, if you want to respond to Kate on thinking about utopianism, we can start there, and then we'll move to some more presentist considerations where we do the work of coming up with some of the new ways of thinking about inequality.
Sure. I was about to say I'm not committed to the term utopian, except I think I am committed to the term utopian, because we need something to counter, or we need a language to counter the sort of "it ain't gonna happen soon" response to this kind of reasoning, because it ain't gonna happen soon. And if you have a short time horizon, then that's more or less a conclusive objection. So what we need is some way to describe thinking about the Constitution with a longer time horizon. I don't know. I think for me, utopian actually does do that. But if there's another term, it's fine with me.
Well, so what I'll do if we're there is I think what's interesting to start with is everybody said something about thinking about either economic equality or inequality, or in the broader context, the Constitution, and trying to make arguments that are affirmative from a progressive perspective without either the defensive crouch or short-term kind of thinking. And so what I thought I would do is, and they have no preparation for this, so mind you that, is assign each of you a topic and have you make some arguments for us right now. So we're going to start with Kate, and we'll work this way. So Kate, I was thinking maybe you could tell us a little bit about secondary boycotts in statutes and what you think of their constitutionality, and explain what that is and talk about that. And just to preview, Joey, maybe you could talk a little bit about education and San Antonio versus Rodriguez and educational opportunity, welfare rights, that kind of thing. And Mark, you mentioned environmental law and a way to make that constitutional. I think that was a provocative and interesting statement, so maybe you could elaborate on that a little bit more. So Kate, do you want to kick us off?
Sure. Okay, so the Wagner Act, which was passed in the 1930s, protects workers' rights to organize, private sector workers' rights to organize unions and to collectively bargain. in the 1940s, in the late 1940s, there was a backlash against unions and efforts just to sort of curtail the rights that the statute provided to unions. And the Taft-Hartley Act was passed, and it curtailed union rights in a host of different ways and expanded the rights of employers to try to campaign against unionization. It also tried to sort of get at some abuses by unions and gave workers rights not to participate in unions. But one of the most important reforms that was in the Taft-Hartley Act as part of this sort of retrenchment on union rights was a prohibition on secondary boycotts. So a prohibition on the ability of workers at one company to strike, essentially, to support workers at another company. And this was in part in a response to a lot of sort of class-wide solidarity, so general strikes in the country, sort of workers at one factory or one store, sort of exercising economic power to support workers at another place. That is now prohibited by our labor law, and it's prohibited, and many things are prohibited by our labor law but done anyway because there really aren't any consequences for violating the law in many respects, but this one does have consequences. There's significant penalties if workers engage in secondary boycotts. So when the court first was asked to sort of confront the constitutionality of this provision, it's one of the hardest parts of the labor law class to teach because it's like impossible almost to follow the doctrine, because in order to, they had to, the First Amendment seems to create a problem, right? Because you have a right to engage in freedom of speech, and this is a sort of targeted at a specific kind of speech. It's not neutral. It doesn't apply to all picketing. It applies to union picketing. Anyway, the court sort of did lots of work on the statute and interpreting it, but ultimately did uphold the restrictions, notwithstanding First Amendment doctrine and notwithstanding doctrine that allows quite a great deal of protection in other contexts, upheld the law's restrictions on secondary boycotts. Many lawyers and academics think that is incorrect as a matter of First Amendment doctrine. So there is certainly sound and constitute arguments that as a matter of First Amendment doctrine, as a matter of First Amendment, the restrictions on secondary boycotts should be protected by the First Amendment. And then you can add to that the work that Mark alluded to by Jim Pope and Lee Vandervelde and others about the 13th Amendment and how the original conception of the 13th Amendment was not just to ban chattel slavery, but to enable workers a certain degree of freedom at work. And so I think there are certainly some quite strong constitutional arguments that again aren't implausible, aren't utopian, aren't remote, right? That could lead to the conclusion that the restrictions on secondary boycotts are unconstitutional. The reason that's particularly important, just one last point, in today's economy, the way workplaces are structured, is most people don't actually work for, like, for example, Walmart, right? They'll work for someone subcontracted way down the line. But yet, because they can only exercise economic power really against their own employer, it creates significant limits on the ability of workers to engage in effective strikes.
Great. So Ganesh was not kidding about this being totally sprung on us, but
He had no warning at all.
3 things to say that I can. So the first is zooming way back and not thinking in a presidentist way at all about educational inequality. I think it's very instructive, and here I'm going to sound methodologically more like Ganesh than like my own project, but it's very instructive to read what Thomas Jefferson's plan for Virginia in particular in the founding era thought, and that's just the strongest example, but there are others, thought you needed to have in the way of an educational system if you wanted to sustain a republic. It was nothing like what existed at the time in terms of, he thought you needed a system of schools for more or less all that were open, that then would sort of go up in a pyramidal structure where the students with more ability would have a chance to reach, higher education and eventually even to go to the University of Virginia that he was creating without paying any fees. And the reason this was necessary is because just like breaking up large estates and preventing the agglomeration of large, property for landholders, you needed to have not just a diffusion of knowledge, but a mechanism of mobility, a way that if you're going to have a republic, you don't just have a hereditary elite of the children of the educated being able to afford education. So we've had a long history since then, and I won't try to summarize the whole thing, but it became pretty obvious by the 1960s and 70s that the disparities in education within states, let alone the even greater ones between states, were so great that that the forms of education that some students were getting were not going to prepare them for the kinds of roles in the economy that other students were getting. So in this famous case of San Antonio versus Rodriguez, the Supreme Court held in one of these narrow 5-4 decisions that that the Constitution does not require the equalization of funding between the rich and poor schools in San Antonio. This holding is one that it almost immediately, kind of in the manner that Judge Gertner was describing earlier, it almost immediately began to be read to say more than it did. It almost immediately began to be read to say the U.S. Constitution says nothing about education or schools or their funding, which it didn't say. In fact, one of the things that the case explicitly left open was the possibility that schools could be so poorly funded and maintained that you were not even reaching the minimum threshold of what the federal constitutional structure implies people need, the basic tools. That is, even the sort of conservative court, post the conservative turn into the 1970s, the court was acknowledging that somewhere it seemed they needed to leave a door open, that schools might not be providing what was necessary for economic and political citizenship. So what happened as a result of that case is that the action moved to state court, where I think it's a terrific example of progressive continued articulation of constitutional arguments when the Supreme Court seems to have closed the door. Lots of different courts in different states, including prominently some other states, had landmark rulings about fiscal, first the wave was fiscal equity, and then the action moved to fiscal adequacy, to say that, when we think about, as the court in the CFE versus New York case, Campaign for Fiscal Equity versus New York case said, when we think about what is required for someone to exercise their constitutional responsibilities in the structure of our state constitution, which holds that people need to be able to vote and serve on juries and basically act as citizens. If that's going to be possible, there's going to be some threshold of education that they need. And so there's been an enormous fight about that ever since in almost every state, and it seems very uphill and disappointing much of the time. But I would note that there's a recent, really important and thorough recent study suggesting that when you examine, even though it's often hard to find, because education is a complicated problem and some kids are a lot more expensive to educate than others, despite all of these complexities and difficulties, it does seem that we can show that the fiscal equity lawsuits in different states have had measurable results in terms of some children's education. Haven't gotten as far as the state courts think they need constitutionally to get, but they've gotten somewhat far. So you fast forward to today, and there's the lawsuit that Kate mentioned from Detroit, which is a federal lawsuit truly testing the question of, can a school system provide such a poor level of education that actually, even under the federal constitution, that door left open by Rodriguez, it falls below that floor. Now, I think it may be that that lawsuit was effectively decided by the Senate's filibuster of Judge Garland and the confirmation of Judge Gorsuch. But I think it's also a good example of why we need to not limit our thinking about constitutional meaning and constitutional rights to only what can fly in the Supreme Court. Because this is an area where not only is there action going on outside that sphere, both in legislatures and in state constitutional litigation, but that action has actually gotten somewhere, and we need to continue with that work.
I have to preface this by talking about environmental constitutionalism by saying that when I teach environmental stuff to my students, I say, well, I'm not really an environmentalist. And then I also say I have a friend who is an environmentalist who responds to that by saying, well, you like to breathe the air and you don't want to get sick drinking your water, right? And I say, yeah. So, and she says, yeah, you're an environmentalist. Okay, so talking about constitutionalized environmentalism actually can get into complexity quite quickly. And I'm just going to do some very surface kinds of things. The first is, as that anecdote suggests, one way of thinking about environmental constitutional rights is that people have, there is a right to a healthy environment for people. That is, it's just like other rights. It's not a right for trees to be trees. It's a right for people to live under conditions that don't make them sick. That's sort of the second is, this picks up on something that Reva Siegel mentioned before lunch. One way to establish a constitutionalized environmental right is to start talking about the right to clean air and clean water as a constitutional right. Just start doing it. So when Scott Pruitt starts doing stuff not on the, I actually don't think that the climate science stuff is the place to focus on. When he starts doing things to allow more discharges of pollutants into streams and rivers, the language is not you're dismantling the Clean Water Act, but you're violating our constitutional rights to a decent environment. Just do it that way. It's like the healthcare example, except, well, with one interesting and important except in the healthcare context, people who oppose the right to healthcare say, no, you have a right, the rights people have in connection with healthcare are rights of access to healthcare. What that does is to say, well, a market allocation of healthcare is fine. You can't do that with clean water and clean air. I mean, it's much more difficult. And the rhetoric of using the market to allocate clean water and clean air is much more difficult to pull off. Now, this is the last. So sort of the basic line is just, you have a right to a healthy environment because you have a right to a healthy environment. It's a human right. But the last thing I want to introduce is a complication which would have to be confronted. And it is the, well, what about job-killing regulations, right? And what that introduces is the idea that there are distributional consequences to acknowledging a constitutional right to the environment. And at that point, we're back in this territory we started with. So how do we deal with these distributional consequences? These are then, these regulations as job killers exacerbate the problem of inequality. And so if we acknowledge a right to a healthy environment, then we have to do something about the wealth issues that Ganesh and Joey and Kate have already talked about. I have other things to say on this, but
So, Mark, can I ask you one thing? Because so Kate's argument is rooted in the First Amendment pretty cleanly with respect to secondary boycotts being unconstitutional. Joey's rooted in equal protection, and there's a strong argument there. Are you a progressive tenther? Is that what this is? That the rights reserved to the people, or is this a substantive due process, or is there no theory yet, but to be elaborated by maybe some of the students in notes that they write for the larger journal?
So what you're asking is in terms that I use in my talk is, but how do you connect this stuff up to the Constitution we have? And I'm not. I don't find that to be a terribly pressing kind of problem. If you want to gesture in the direction of the Ninth Amendment, that's fine with me. Or you have a right not to be deprived of life without due process of law. And if you have asthma and the air is really bad, you're being deprived of your right to life. I think it's not the kind of thing I do, but I think people who design arguments that or arguments that come to have traction would be able to design such arguments about the environment.
Can I offer one, Ganesh? So just to return to Michigan again, in addition to the problems in Detroit, many people have heard that people in Flint have lacked clean water to drink for quite a while. Just to get, there's been successful litigation there as well as successful political action. But very little sort of sounding in the Constitution. But an argument similar to the one that Joey is making with respect to education rights can be offered about water. I mean, once the state makes a decision to provide water to its citizens, it can't provide it to some citizens and not others on an unequal basis, right? And so if you were to give that as the jump from where our doctrine is to where it would need to get for that kind of environmental claim is actually not all that significant. It's a sort of fundamental interest, equal protection / due process argument that's well grounded in existing doctrine.
So I want to switch to the second part of the title of our panel, which was plutocracy. Because we talked just now about topics that are about workers or the general public or people with inadequate education funding. But the plutocracy threat is actually on the other end. It's the wealthiest people and the political and economic power that they have. And so maybe I can invite anyone who wants to say something about this to say, how should we think about the Constitution in terms of the most powerful rather than the least powerful, which is what we had just talked about, right? Do you want to start?
Well, I'll start in with a couple of general points. So I'm not sure that I completely agree actually with Ganesh's characterization of my little Rodriguez discussion as being based equal protection, because I think it is, yes, and certainly in federal constitutional law that's where it sits, but so much of where it comes from and so much of the action in the state courts as well is really more structural. It's about the idea that citizens have a role in the constitutional structure. That role seems to involve serving on juries and voting and being able to participate and have a certain relationship to your elected representatives. And I think that's where more of the action really is, particularly since most of the successful work in this area has not been about inequality, it's been about adequacy at the bottom. So a whole generation of constitutional theory, of constitutional theorists on the left worked to think about how we should constitutionalize social minima, or in one way or another, the rights of the poor. And a real difference between that project and the one I'm working on now is that I think we actually need to turn as well to inequality in the middle and at the top. Morally, I think maybe the greatest urgency is at the bottom. But in terms of thinking of how to preserve our republic and our political system, the urgency is in the hollowing out of the middle and the concentration of power at the top. So what do you do about the concentration of power at the top? I think there are a couple of different starting points. One is about the interaction between economic power and political power and the way they are mutually reinforcing. So a whole set of reforms that we think of in terms of anti-corruption reforms can instead be understood and here I'm just exactly following, Mark's suggestion. We can reframe these. I think we don't need to reframe them in terms of equality exactly, because maybe people won't ever have exactly equal influence on their representatives. But if we need to have a constitutional system in which the elected officials are responsive to their constituents, as in the way that the Constitution contemplates, then we might say at some point it's just too much. It's too much influence that huge contributions or independent expenditures or political moves of that kind give certain wealthy people. And I think a sort of fascinating, like, funhouse world mirror way of viewing this problem is the Supreme Court even seems to be able to see it if it's about judges. So, when you're talking about judges and judicial elections and expenditures and contributions in judicial elections, this conservative Supreme Court is willing to say, in the case of this important case, Caperton v. Massey Cole, willing to say, okay, at some point it is too much. At some point we think that if a judge has gotten most of his campaign funded by one big donor, and then that donor has a case in front of the court in which that judge is going to be judging, going the way of that donor, there seems to be something wrong here with the relationship between the judge's role and the system we have for putting the judge in place. There's just too much power to this one constituent or this one donor, and it doesn't look to us like a structurally fair system. So all we need to do is extend that reasoning, and we're going to have to extend it outside the courts. Extend that reasoning to the structural role of our elected representatives more generally, who, like judges, are supposed to be responsive to the people and not just to the plutocrats.
So one thing I'll just add on the point about structure, I think one of the reasons why it's very hard for us to think in terms of constitutional structure and inequality is words like oligarchy, plutocracy, aristocracy seem to come from ancient history to us. It's just so foreign to how we think. But in fact, that was not true for most of American history. And you go back to the Gilded Age 100 years ago when people are worried that the country is becoming an aristocracy or a plutocracy or an oligarchy. The people there saw these as live forms of government because many of them had actually fled aristocracies in Europe in order to come to a republic. This was not something that was a fantasy. This was the governments of Europe. That was just the norm, and America was something different. And so there was a sense of that difference, and I think we've lost that, particularly in the post-World War II era, as the shift moved from communism to capitalism as the central divide in kind of regime types. But today, with inequality rising, I think one of the concerns that people are now seeing all across the world, Joe used the word oligarchs to reference the link between Russian oligarchs and here. This is a form of government that exists. It's a crony capitalistic system that looks like an oligarchy, and that is different from being a republic. And that is a structural claim that is live and I think an important one today.
This is related to what's been going on, but mostly it's a nervousness about some of the formulations, which I just feel compelled to express. And it's a nervousness about the focus on, and I think your phrase was the hollowing out of the middle class, the focus on the middle class. I don't exactly know. I think there's probably some biographical explanation for why that makes me uncomfortable. But I do want to note that there's an alternative, quite rich theorization available to talk about the dignity of labor. And it's the social teachings of the Catholic Church, 3 major papal encyclicals, which are expressly anti-capitalist in their formulations. The earlier ones more than the later ones, but still. And it seems to me that's a resource for progressives to draw on in this kind of discussion. So the reason I raise it here is that the connotations of hollowing out of the middle class are different for me than the connotations of the dignity of labor, and frankly, the latter sounds much better to me. So I don't quite know where to go with that in this conversation, but if there were some way to capture at least some aspects of the social teachings in this kind of discourse, I think that would be a really good thing.
Just to piggyback on that, I mean, one thing that I think is important is to think about how actual organizations and movements of people articulate their rights and their claims. And if you look at sort of the claims being made by workers in, for example, the Fight for 15 or by worker centers, it's less about equality and more about dignity, the dignity of labor, but also does relate to structure, because in part it's about having, it's an idea of sort of republicanism, or of having power and a voice in one's own conditions. So when we talk about workers' rights, it's not just about economic redistribution, but also about the right of people to both live their lives with dignity, but also to have control over what their daily, what their existence is like, and have a certain degree of democracy, democratic participatory rights, both at work and in the government.
So I think what we'll do is we'll try to move to questions and get some of you in here. So we'll start way in the back with Shinar. Yeah. Do you want to wait for a second for the mic?
Thanks for the discussion. I think it's an incredibly important panel. So as I heard and Joey's historical arguments for constitutional arguments against inequality, I have to say that I found myself getting a little uncomfortable with what came across a little to me as the idealization of the Republic. And of course, here I'm thinking about the fact that this vision of relative economic equality only applied, of course, to a minority of the population, which was white men, excluding natives, excluding African Americans, and women. And of course, when we think about that in the present political moment, I think it's particularly a relevant question to think about, since, of course, on at least the Republican side, the discussion around economic inequality and the fall of the middle class was not just about the fall of the middle class, and I take Mark's point as well that, should we only be talking about the middle class, but even beyond that, it was often the rhetoric was about the decline of the white middle class in particular. So I just wonder whether it's dangerous to premise constitutional arguments for equality on historical examples of equality that were only envisioned for a very small in-group. And is there any reason to fear that utopian thinking of expanding constitutional rights to more robust conceptions of economic equality might come at the expense of developing, greater notions of racial equality, which of course have been significantly retrenched? So how do you prevent these struggles from being sort of pitted against each other in the way that we've seen now, and which seems like there was tension there in the original history?
So this is a great question. I'll start. The story that you're telling is not only a story today, it's also a story that in my book project you trace through many rounds of American history. I mean, there's the key founding moment for me in a lot of ways is not the actual founding, but Reconstruction, when for a brief period we got not only an idea of racial equality and equal protection, But really, I think it's underappreciated by most people, the extent to which we got that idea through an intertwining of racial inclusion with economic citizenship ideas and an idea of Republican citizenship. So an early draft in the debate that eventually led to the 14th Amendment was a resolution that some important Reconstruction Republicans wanted to pass, which said, there shall be no oligarchy, caste, or class, and all people shall have the same rights of various kinds as white people. Sort of really linking together these discourses in a way that I think was essential for both of them. But of course, what happened is the same thing that you're describing today. What happened in the death of Reconstruction and in the death of kind of cross-racial populism of the late 19th century was that people successfully came up with a way to pit these ideas against each other and to pit poor white people against minorities, and that was, I'm not going to tell the whole story that you know. So I absolutely think it continues to be a problem today. I think that these strands of argument about racial inclusion and the preserving of a broad middle class that's open to everyone, they only work when you entwine them together. And basically, much of the story of American contestation about economic inequality has been a story of efforts to do something about it collapsing, running up against efforts to instead divide poor people by race. And if you look at why the New Deal never reached lots of categories of employment because it had to get Southern white racist senators to vote for it, or we've had several rounds of this fight. Maybe I'll let Ganesh speak to the exactly how do we get around it today. My only real contribution to that answering that question is to say that the way to think about these principles is as linked sides of the same coin, that if we don't frame them that way, they almost always seem to collapse.
So the story that I tell is similar to what Joey just described. And the way I would put it, though, is that the principle of the middle class constitution, what I call it, is that you have to have relative economic equality within the political community in order to have a republic. And then the challenge is, well, who's in the political community? And that's a debate that we have had, including violently over our history. And if we, as I think we should, have an inclusive tradition that expands the political community to include everyone within it, then in order to make the theory that our Constitution was built on work, you actually have to have relative equality within the entire political community. Everybody's got to be able to join the middle class. And that's been our challenge, as Joey has described, throughout our history, and people understood this. So as Joey said, during Reconstruction, it wasn't just emancipation and political rights that the Reconstruction Republicans fought for. Thad Stevens of Pennsylvania said we should confiscate the wealth and land of the top 10% of rebel planters and redistribute that in 40-acre parcels to the freedmen of the South. 40 acres and a mule comes from this time period as an idea. And that was economic opportunity and justice as well as political equality and opportunity. And these things were linked. And so Thad Stevens even says that without a proposal like this, the South can never be a republic, as it has never been up until now. And that is a concern that they understand the linkage between the economic side and the racial inclusion side. So I think that is got to be part of our story. As Joey said, that was that they lost. The redemption movement undid what Reconstruction had hoped for in a bunch of ways. But that doesn't absolve us of any reason, of any argument not to fight for that today. And I think one of the most troubling things now is the persistence of divide and conquer strategies that basically, as Joey said, divide working class people by race or other divisions in order, as we have quite literally just seen, to allow a bunch of the most wealthy people in our society to run the government to support their own interests. That is the purpose of divide and conquer strategies. It's what defeated cross-racial movements in the South in the 1890s that were populist in order to entrench the privileges of the wealthiest people in society. And that is something that I think you fight against by making the argument in a cross-racial way instead of retreating into our own little groups. It has to be a broad movement that pushes back against the oligarchy, as the case may be. Jamal.
I wanted to ask about what may sound like a tautology, which is the political economy of utopian constitutional thinking, and specifically its relationship to federalism. And I'm inspired by Joey's story about San Antonio versus Rodriguez, where one way of telling the story is to say Lewis Powell and the court essentially lacked imagination, and we saw a model for what they could have done after litigation and states followed. But another way of telling the story is that San Antonio revealed that there was another way of directing energies that was much more productive, and not just productive in a complementary way, but productive in a way that was in competition with focusing on the court, so that the Supreme Court, so that the counterfactual might be, so you win, you flip Lewis Powell in San Antonio versus Rodriguez, and then suddenly what happens is that all of our energy is focused on predicting what Lewis Powell and then Sandra Day O'Connor and then Anthony Kennedy is going to do in the next federal education case, and that's counterproductive. So I'm wondering if that sounds plausible to you, and whether you might extrapolate it to other areas as well, where going for the big prize leads you to doctrine that's going to be necessarily thin because you're going for the median vote on an institution that's governing the whole country.
So I'll let other people speak to this too. I hear the story you're telling. I'm a little skeptical of it for a couple of reasons. One is that I am not sure that there is a zero-sum economy of energy here to be divided. That is, imagining narrow, thin victories in the federal courts instead of defeats. It seems like that could be followed by attempts at state level to push beyond that narrow, thin doctrine. I mean, already by the time of Rodriguez, you had a little bit of that beginning in states like California that were starting to see themselves as self-consciously articulating constitutional rights beyond federal floors. So it's not clear to me that you lose by winning, but I certainly think that that there is a danger in thinking about. It's almost the inverse of Marx's defensive crouch. It's sort of the offensive crouch. You're describing like the danger of everybody thinking in terms of these couple of swing justices, and there certainly have been areas where we've seen that happen. But I think in general, those are areas where the swing justices, like with affirmative action, are constraining, using the Constitution to constrain what any other actors in the system can do. So unlike a context like affirmative action, in education this is a question of the federal courts requiring something of states and localities. And it seems to me at a first blush that if the federal Constitution requires something maybe thin and minimal, that still leaves a lot of space to make arguments that state constitutions and state legislatures should do more. In some ways, the more kind of, like I think those kind of rulings could be, to use a very law professor word, jurisgenerative. What's really jurispathic, what really shuts down the development of this thinking is when you're using things like, the Equal Protection Clause to constrain anything that any other actor in the system can do.
I agree with that. I would just add, though, that I think the bigger danger is thinking of the Constitution as only something we talk about in the court. So to the extent a victory in San Antonio versus Rodriguez would have resulted in conceptualizing the right to a minimally adequate education or some degree of equity or dignity in education as something that a claim that can only be made on courts, that seems problematic to me. That actually does seem like a mistake we have made, right? But that's different from the problem of whether a federal right would necessarily preempt the ability to have constitutional rights at the state level. So you could imagine a win in a win that's insufficient on which states can build, and at the same time efforts to articulate a constitutional right through political movement to legislatures, to local school boards, as well as to courts.
Two things occur to me here, and they're at the low level, at the high level. So in the situation you're describing, narrow victory in Rodriguez, we could push for lower court underruling. That is, instead of telling the lower courts, lower courts would say not, well, this is the most the Constitution requires. What the narrow victory eked out is the most the Constitution required. We could push lower courts to say the court has identified one form of unconstitutionality in this domain. There are others, like the one we have here. Okay, so that's one. On the other end, and this is part of the utopian side, not that I'm a big fan of it, but a fan of what I'm going to describe at the top end, but instead of saying Constitution requires some minimum, go for the Constitution requires a fully adequate education for everybody. And then use federalism, or in your colleague Sable's approach, experimentalist approaches, to work out over time what that maximal requirement is. I actually like the experimentalist ideas. I'm not a big fan of courts, but that seems to me another strategy to go for. It is in my terms utopian. It's not going to happen soon, but why not keep thinking about it?
Let's go to the far side over here, Adam.
Thank you. Great and thought-provoking panel. As the panelists know, there's probably strong historical reasons for why economic rights have sort of dropped out of the constitutional discourse. Right? We have the compromise of footnote 4, where liberal constitutionalism embraced the idea that the court was there to protect liberty rights and not property rights. And I raise that point only because it highlights, I think, one of the concerns of economic rights is that will it empower forces such as businesses and sort of anti-government, pro-property rights folks to enable them to articulate more justifiable constitutional arguments in a way that they've been struggling to do. Because while economic rights have dropped off of the agenda by and large, and especially on the progressive side, they are still being argued by conservatives, and there's a libertarian constitutionalism out there where the central principle of the lost Constitution is the strong protection of economic and property rights. And so I just wonder about sort of what the implications might be. So one possibility is that we should be very concerned about this, that we're going to, the law of unintended consequences, remember the initiative process, right? The great reform by progressives that was going to combat corruption was going to be the initiative process. And today it's totally dominated by business and non-progressive forces. 13th Amendment, another one, the litigation over the 13th Amendment, it's corporations that raised 13th Amendment claims in the federal circuits in the 1880s, most powerfully, and almost get away with it. Stephen Field embraces it at the circuit court, but can't get the Supreme Court to agree. So I worry about sort of, are you empowering the wrong concerns in the economic space? And alternatively, and maybe this is the exact opposite, maybe that's a reason why we can, or those sort of common grounds can provide a basis for coalition building, a way for liberal economic rights people to side up and create legal reforms with some of the libertarians on, say, issues like civil forfeiture, an issue that doesn't necessarily divide left and right.
So the very last tail end of your comment, I think there is something to it. I mean, I could get behind some restrictions on occupational licensing schemes too that the libertarians like, but I think the greater area is direct and intense conflict. And the middle part of your question kind of answers the first, which is to say, you know, should we worry that by articulating progressive economic arguments about the Constitution, we might empower, say, imagine a First Amendment jurisprudence that started to protect various forms of libertarian corporate, you know, that horse has already left the barn. I mean, we are living in a world in which the debates of 100 years ago between progressives and, you know, the early laissez-faire people who are the forerunners of today's libertarian constitutionalists, those debates were seen as constitutional arguments on both sides. Today, the libertarians think they're making constitutional arguments, and their opponents are not acting as though we were making constitutional arguments. So I think the answer is mostly not a story of common ground, but that we need these arguments in order to argue in court that there's constitutional weight to the interests weighing against some of the libertarians' claims. But I also want to say one other thing about the place you started, which is that I think there's something ironic and problematic about the way we now remember and talk about the New Deal settlement, which is that at the time that the settlement occurred, that you crystallized in terms of Caroline Product's footnote that we look back on as articulating the kind of work courts are now going to do, you know, FDR and the proponents of New Deal legislation never thought that all they wanted was to get the courts out. They had robust visions of the kinds of economic rights, especially in areas like labor, that the Constitution actually demanded. Just they knew that courts were extremely hostile to those things. So they thought, okay, you know, from these conservative courts, we'll accept that you just say we have the power. You just say we have the power under the Commerce Clause to enact these sorts of regulation, and we will keep saying that actually the Constitution requires it. And we'll just accept that courts are not going to talk that way. So fast forward, and now we look back on that settlement as if it was, you know, the liberals and the conservatives agreeing together that the courts had nothing to say about economic rights. But that's not what it was about. And for the conservatives, especially the libertarians, it never has at any point been what it was about. The arguments, as Kate has argued, and I don't want to steal if you're going to talk about this, but you know, the libertarian arguments, especially in the area of labor, they began immediately. There was no period in which there was a deconstitutionalization on the right side. I don't know.
We'll go right here to the middle.
I'm out of uniform, but I'm a physician, and so and an advocate for universal health care. And building slightly on the last question too, I'm really interested in trying to find ways that the right and left can come together over some of these issues. So I'm going to look at my notes here for a second. So about 6 weeks ago, the Nobel laureate and Princeton faculty economist Angus Deaton spoke about the question of inequality, and he argued that rent-seeking, not income inequality, is the problem. And for those of us who aren't economists, rent-seeking has nothing to do with, of course, how much rent we pay for our apartment or things like that. But rent-seeking is an economic jargon term that speaks to essentially gaining government, businesses and corporations gaining government influence in the government to affect the marketplace, to affect their market share. So Deaton considers himself, I think, a somewhat conservative economist, and he says the problem is rent-seeking, not income inequality, and that rent seeking does not, doesn't generate new products. It doesn't actually create wealth. Talent is devoted to stealing things instead of making things. And then he goes on and he says that the financial industry and healthcare are the two greatest examples of rent seeking destroying our American economy. And this is just a little bit more to read to you. So he says he favors a single payer health system, which I do too, only because our current part private, part public system is exquisitely designed to give opportunities for rent seeking. So, and this is a direct quote. So I, who do not believe in socialized health care, would advocate a single payer system because it gets all this monster that we've created out of our economy, we'll get this monster we've created out of our economy away and allow capitalism to flourish without the awful things that healthcare is doing to us. So I would like some comments on rent seeking and how that is affecting the economy. I'm not sure if that can tie in with the Constitution or not.
Because it would be, I don't know what the right word is, Ganesh can't say this, but Angus Deaton wrote a very favorable review of his book, of Ganesh's book, in the New York Times 2 weeks ago. 2 weeks ago? 2 weeks ago. So front page of the New York Times book review section. Go consult it. Now you can.
Okay, well. Thank you for the again, shameless plugs. I've paid them all off. It's a form of rent seeking. I think, one of the key things about rent seeking is how economic power influences politics. And that there is a cycle that takes place. When you have a political system that allows money to influence policy outcomes through campaign contributions, lobbying, and a variety of other forms of influence, what happens is people use the influence they have to set up the rules to make themselves wealthier. And then they have more wealth, which they then use to make the rules make themselves even more wealthy. And this creates this kind of cycle. One commentator has called this the doom loop of oligarchy, because once you get into it, it's very, very hard to get out of it. People understood this throughout our history too, and I think a very important component of the kinds of remedies that people suggested to preserve our republic and that they thought were constitutionally required was actually things to do to attack corporate consolidation. And in some ways, this gets to the previous question, which focused a lot on economic rights. The other side of that is the economic structure of society. And so antitrust law and anti-monopoly as a tradition the antitrust laws emerged in the late 19th century in the Gilded Age in order to break up giant consolidations of corporate power, partly because these consolidations were having outsized influence on the economy, leading to a wide variety of bad things, but also partly because they were capturing politics and leading to, there's one book called The Menace of Privilege, which is about how privilege influences policy and then leads to more privilege. And so it was both a political component and an economic component, and it was rooted in this idea that you couldn't have our constitutional system unless you had both an economic democracy and a political democracy, and that the great consolidations of the Gilded Age mergers and monopolies threatened both. And so I think that is something that today is a live question in a deep way. You can go back and just read, there was an article in The Nation, I think last week, about a conference at the University of Chicago on antitrust, which pitted the kind of classic Chicagoan Robert Borkian antitrust folks who think that the sole focus of antitrust is efficiency as defined by consumer welfare, and the new, in some ways, old antitrust folks who think that an important component of this is market power and political power, drawing from Justice Brandeis and the original history of why antitrust emerged in the first place, rather than the kind of grafted on later history that emerged only in the 70s. And that's a story that's now coming back and is, I think, another version of kind of a rising interest in these areas, still yet to be constitutionalized in some ways, though the people who talked about it at the time talked about it in constitutional terms.
And I should add that, so of course the synonyms for rent seeking that the right likes are corruption, that particularly the Trumpian and Bannon right, they're so anti-corruption, the fixed system, the rigged system. So that's where I think maybe looking at things in terms
go way in the back.
Hi, thanks. I thought that Professor Fishkin and Sitamoran made very good arguments about how a vital working class or middle class is important, not only to our constitutional democracy, but to democracy in general. And I was very interested in Professor Andreas's comments about how to revitalize the working class. And I think she hit two big nails on the head in terms of public education and revitalizing the labor movement. Now, public education, and now my question is about in the context of the global economy. I think public education is a no-brainer for us in terms of how we're going to compete in the global economy, that's good for our people in general and for the working class in particular. But then the question is, how do we revitalize the labor movement in a global economy where wages are lower in other countries and where other countries have less protection for organizing even than we do, even though we have fairly pathetic protections for organizing. And what I wondered is if the future labor movement in the United States is going to have to focus more on politics rather than actually active collective bargaining, because that's where the working class is not going to disappear. These people are going to be here. They're just going to be poorer. And the question is how are their interests going to be represented in society? And I think it's going to have to take a form of politics, more of politics rather than collective bargaining. And I wondered and also I think the Democratic Party has to actively engage these people again for both the benefit of the Democratic Party and the benefit of our democracy to include these people. And I just wondered, how do we reinvigorate the labor movement in the global economy? I guess.
Well, maybe I would just reframe my answer to talk a little bit about how we might reimagine labor law, as opposed to what precisely the labor movement should do. And I agree with you in the sense that our current system channels collective bargaining at the level of the enterprise, at the single workplace. And that system, I think, makes very little sense if your goal is to address problems of both income inequality and political inequality or rent seeking or whatever you want to call it, right? So I do think that we need to move to a system that is basically a system of social bargaining, right, of sectoral bargaining, where workers are empowered by the state or by the federal government, like would be the ideal, more utopian version, to bargain along the lines of the way many European systems do, where basic both minimum wages and healthcare and other benefits are set at a sectoral level in a tripartite system where workers, business, and the state and the government are bargaining. So that is in some sense politics, but it's not sort of ordinary legislative politics. It's actually a system by which workers have a seat at the table, right, to set conditions at a sectoral level. And I actually think that, again, though, that's in some ways less utopian than it might seem, in that you see the labor movement moving towards that already. With the Fight for 15 and other similar movements, in the sense that they're not trying to win union elections at individual McDonald's stores. What they're saying is, no, we have a right to $15 an hour, and whether we win it through legislation or at the bargaining table, we are collectively demanding that right. And I guess I would say, which is one last thing, is I think sometimes we mythologize manufacturing jobs, which weren't inherently good jobs, right? They were made into good jobs through collective struggle and legislative change. And there's no reason that the service economy can't also produce jobs with dignity. The international, obviously globalization creates all sorts of additional challenges. But even with the existing economy that we have now in the globalized economy, there's no reason why the jobs that we have in this country can't be jobs that provide dignity to working people.
So with that, we're going to take a break, and we will reconvene for our next panel on the hot button Constitution in a few minutes.
Yeah, right.
Yeah.
I didn't expect that. No, it was the idea that, I mean, this the environmental thing that's interesting. I like the idea of progressive term. Yeah. I mean, it doesn't have to be traditionalized. The tenthers are all over the place.
Yeah, we got tenthers coming out right here. So I wonder if we were talking about in the cab, you weren't there.
opposite. Right. And it totally shapes what's
part
going
of
on.
the equality of argument.
Right, yeah.
Okay. Welcome to the closing panel on the hot button Constitution for our symposium on the future of the U.S. Constitution. So for this panel, we will be talking really each about 4 somewhat distinct issues, initially going down the line, and then we will talk about connections, move to connections among and between them, and moving to the subtitle of our panel, Issues That Divide Us in Both Law and Politics. So let me just start briefly with introduction. So I'm Dawn Johnson, and I teach here at the law school, and I'm going to be very, very brief and just limit myself to one fact for each of our panelists, and please read their bios, fuller bios in the program. So Pam Carlin is the Kenneth and Harl Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. The thing I want to highlight is that recently Pam was serving as Deputy Assistant Attorney General in the Civil Rights Division at the U.S. Department of Justice in the Obama administration. Much more to say, but I'm just saying one thing. Restrain myself. Reva Siegel is the Nicholas Katzenbach Professor of Law at Yale Law School. And the thing I want to highlight about Reva is this book here, Before Roe versus Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, which she co-authored with Linda Greenhouse. And I use excerpts from this, I have for several years now, in my teaching, and the students learn so much from it, original source material from pre-1973. So we need to, I think, now be going back to our history and basics, and that's a wonderful resource. I'll also just mention The Constitution in 2020, another wonderful book. Adam Winkler is a professor at UCLA School of Law, and he is the author of this terrific book, Gunfight, The Battle Over the Right to Bear Arms in America. And like Reva's Before Roe versus Wade, both extremely important looks at the history behind what are vital debates of our time, have been for decades, will be for decades, so important to our law and politics. So 2 wonderful books. I also brought Ganesh's book up here again. So The Crisis of the Middle Class Constitution, and Joey Fishkin's forthcoming book next year. Just really all wonderful resources. Keeping Faith with the Constitution, Pam Carlin. I don't have it with me. Another wonderful, free for download on the ACS website. And I think I even asked you to do that book. So I apologize for not doing a shameless promotion of it. And Reva reminds me, Before Roe versus Wade is also, they have made free online, which is what enables me to use it every year and not make my students buy it again, and they very much appreciate that. So we all have a lot of reading to do. There's your reading list for the summer. Okay, so I am going to start off, and as I mentioned, we all are writing about different issues that we'll talk about how they intersect. But first, I'm going to begin because I really want to follow directly from our last panel, and also on economic inequality. This is my first time wearing reading glasses in public here, so this is from CVS. So, because I can't read otherwise. So, also want to follow up on Mark Tushnet's call for utopian thinking, and hopefully you all heard that last panel. But just to repeat, Mark urged us all to get out of all this, I should say, all the liberals and progressives, get out of the defensive crouch. It's very evocative, I think, And I think especially after the election, I heard a lot of people talking about being in the fetal position for a while before they get out of bed. So that makes me wonder, Mark, are you here? There's Mark. Okay, good. So it just got me thinking the last couple of days about what is the posture that's opposite of a defensive crouch. And so one thing that came to my mind was driving headlong off a cliff, Thelma and Louise style. So that's what, I hope that's not what you have in mind. And my preference that what comes to mind is charging a bear. And maybe that's because a couple of years ago we were hiking in the Canadian Rockies and there were a lot of fires and a lot of bear. And they said, one thing they said, don't go alone, which is good advice, I think, following up on Mark's, what we should be doing. But the thing that you need to do when you're confronting a bear, backpackers out there know this, is you make yourself as big as you can, you make as much noise as you can, and you charge the bear. And the nice thing is it works. It actually works. So I just want to put that out there. And so now I'd like to say, so here's my charge at the bear. Urge you all to come with me. And so that what I'm going to recommend is the United States needs a national tax on wealth. I expect we all know what's today, April 15th. So good day to talk about taxes, which are actually due Tuesday, I think. My co-author on this project is Walter Dellinger, the former Solicitor General. And so we want to encourage a serious national debate about the wisdom and the constitutionality of a federal tax on wealth. And just to be clear, this would be something different than we have now. New tax, people love those. So not income, estates, gift, capital gains. So it'd be a tax on net worth. Just for an example, a 1% annual tax on wealth in excess, or on net worth in excess of $10 million, in excess of some large minimum. That would affect less than 1% of Americans, far less actually. So you can make it 5 million and still be in the top 1%. So leave the details to people who know things about economic policy. And so I just want to say, this is really something we're just trying to start more of a debate, following up on not just us, but the whole topic of that last wonderful panel. It's not really a hot topic yet, but we're going to try to help make it a hot topic and just spark a national conversation, just as these wonderful books will help to do, I believe. So America's increasing economic inequality, as we just heard, is threatening to destroy our republic. It's translating into political inequality. It's corroding our democratic institutions and the viability of our Constitution. So that is the proposal. Now, I want to acknowledge up front one big problem. Unfortunately, the Supreme Court has suggested, some would even say the Supreme Court has held, that as a practical matter, this is beyond Congress's authority to do, to enact a workable wealth tax. I'm not going to get into all the details, just quickly summarize a little bit here, but I did post with Walter on the Symposium blog, and we'll be writing an essay detailing more on this. But just quickly, to summarize, it comes down to whether a wealth tax would be considered a direct tax under the Constitution, because the Constitution requires that direct taxes be apportioned among the states according to their populations. And that makes sense for like a per capita, per head tax, possibly, but would be completely unworkable for a tax on net worth, because obviously, think about different states. Different states have different numbers of wealthy individuals and wealth per capita. Connecticut, Mississippi, California, Montana, So one interesting thing about this issue is that it's an instance where both the originalist approach and our conventional method of constitutional interpretation lead to the same conclusion, that a wealth tax that is not apportioned would be constitutional. Wealth tax is not a direct tax. And just briefly, back to 1796, the Supreme Court interpreted the meaning of direct tax in the Hilton case, where it upheld a tax on carriages and said that was not a direct tax back in 1796. So I'm just going to read a couple statements. At the time, the justices, the custom was for them to write individually, not as a court. And so here's what some of the justices said. Justice Chase emphasized that because the great object of the Constitution was to give Congress a power to lay taxes adequate to the exigencies of government, this limitation on that power is only to be adopted in such cases where it can reasonably apply. And then Justice Patterson explained the limit on direct taxes was the work of compromise and cannot be supported by any solid reasoning and therefore are not to be extended by construction. And so they identified, the Supreme Court in that case, just per capita head taxes and land taxes as direct taxes. We'll mention too that the compromise that the justice referred to was between the northern and southern states, and the reference to direct taxes occurs in the infamous 3/5 compromise clause, which directed how persons who were enslaved were to be counted for purposes of calculating, quote, representatives and direct taxes. So this is getting very technical, but that's basically the structure of the argument. And following this reasoning, a direct tax, interpreting it only in such cases where it can reasonably apply, would mean a wealth tax is not a direct tax. The court applied this kind of reasoning for more than a century, but then unfortunately took a wrong turn in 1895 in the 5-4 decision Pollock, which today is widely the wide consensus is the universal that the 4 were correct, not the 5, and we enacted the 16th Amendment to overrule Pollock, and now we have an income tax. But some of the reasoning of that decision still is occasionally cited by the Supreme Court approvingly. So that's a project going forward, and one on which the fact that we have Neil Gorsuch instead of Merrick Garland on the court has dramatically changed, I think, the immediate prospects for, or may change the immediate prospects for this, maybe more than immediate. Though I hadn't thought of Mark Tushnet's suggestion about adding justices in the near future. So that would be a different calculation. So that's, I just wanted to say one other thing, that the wrong turn the court took was at the dawn of the now discredited era when the Supreme Court was striking down minimum wage, maximum hour, child labor laws as part of that whole discredited Lochner era, when the court was wrongly constraining the ability of the government to affect private property interests. And so there's just a lot of work to be done and thinking about that. But it brings to mind the discussion in the last panel of the related question with the current court. How are they going to treat the ability of elected representatives, even voluntarily, to regulate economic interests? Leave it there, and you can, here's a plug for our forthcoming symposium issue of the Indiana Law Journal. All our essays will be forthcoming in the fall, and you can read details of these arguments. But for now, I just want to finish with 3 broader points, echoing really what many of our speakers have been saying all day, and trying to introduce and tie together a little bit the coming opening comments. Point 1, the wealth tax helps illustrate this. We need to have conversations like today's, keep having them about principled long-term constitutional vision, what the Constitution requires, and what helps it work. And we need to have those conversations not just in law schools, but in Congress and among the American people, and we need to be doing it at times in constitutional terms and talk about a right to education, health care, labor, economic rights in constitutional terms. 2, who sits on the court matters tremendously. I just want to repeat from my opening at 9 a.m., I don't know how many people were here, then, but see if you remember this. So what was the year when the Supreme Court last had a majority of justices appointed by a Democratic president, Elliott? 1969. May 14th. Okay, thank you very much. We're going to learn that one thing. No, so I think just we need to know that. It's very illuminating. So finally, social and political mobilization. We've talked a lot about them being vital. And next I'm going to turn over to Reva's going to speak next. And she is the authority on these issues about social and political mobilization, have helped in upholding our Constitution and informing constitutional doctrine in some cases as well. And before I turn over to her, I'm going to say two last things. One, the chances of a wealth tax being enacted and upheld by the U.S. Supreme Court 30 years from now, I would propose, is just as strong if we get to work now as it was 30 years ago, that the Second Amendment would be interpreted today to protect an individual right. Back in the 80s, when Ronald Reagan and the NRA started talking that way, I don't think there was a support then that we have now among the American people for a wealth tax. So two, maybe I'm wrong about that, but as I think we get to work, I think puts it in perspective that it's doable and it's a long-term project. Last thing, I don't know really where this fits in. I just want to tell you, no less than private citizen Donald Trump, back in 1999, he suggested we should have a one-time 14.25% tax on net worth in excess of $10 million. And he calculated that that would be the amount needed to eliminate the federal debt. I haven't checked his numbers, but that was Trump's recommendation back in 1999. All right, so that's my suggestion going forward. Now I'm going to hear from Reva, then Pam, and then Adam.
Okay. So first of all, I'll join the chorus in thanking Dawn, first of all, and the ACS and the Law Journal here for bringing us all together. And in the interest of time, I will just wave at a conversation that's been going on all day, namely that conversations outside the court, mobilizations outside the court, play a significant role in the ways courts rule. It's actually only a very rare case that engages public imagination. So this is not the ordinary case, but in the cases that when it happens over the longer run, you can see deep ties between popular debate and judicial reasoning, even if judges talk in different and more specialized languages. And this is visible in affirmative action, it's visible in the gun case, and it's visible in the marriage cases, and it's visible in the healthcare cases, and in a very shorter time frame in the Muslim ban cases, I think, as well. So I'm going to take my time today to talk about this dynamic in the abortion context, but in the spirit of, I guess, utopianism or even dystopic possibilities in the shorter run and utopian ones in the longer run. I'm going to talk a little bit about the ways in which change in the ways that this issue is argued might be possible. So the first thing I think almost anyone would think about the abortion issue is people being over some half-century stuck with one side arguing on behalf of women's choices, their life, their health, their liberty, and the other, the welfare and the life of the unborn. I'll just say, again, in the interest of being very brief about it, that in fact the argument has not been frozen, and that in the last, say, 20 years ago, since the era of the Casey case and forward, opponents of abortion actually have made performed creative efforts to change the shape of their arguments so that it wasn't just one side arguing on behalf of women and the other on behalf of the unborn, but that opponents of abortion began systematically to make claims that abortion hurts women, and that they would be arguing on behalf of women's welfare as well. And those claims surfaced in the Carhart decision, and again fueled the path to the whole women's health case this past summer, even if in the end the claims didn't prevail there. So in the coming showdown over what happens with Roe and the abortion right, I was mulling about the question whether it would be possible for those who are defending women's choices in the matter to also make claims on the protection of life. And at first blush, that sounds puzzling, but I'm talking about these arguments. My placeholder in the blog is calling them pro-choice life arguments. And in thinking about this argument, the key first move in understanding what this kind of argument might be like is that one has to look at the frame in which the abortion debate occurs, that it's generally, typically, narrowly a debate only about abortion, so abortion's in a silo, and then it's a debate looking at the woman-fetus dyad. And in that very narrow frame, the way that you protect life is by controlling women. Indeed, controlling women becomes the sincerest, most sincere expression of a desire to protect life. So my first thought about the pro-choice life argument is to say something is wrong with the frame. One needs to enlarge the frame. And in what follows, I want to take some inspiration from the arguments for reproductive justice, which insist on looking at the larger ecology in which women make choices about the decision to bear children or the decision not to bear children, and ask what happens if we took abortion out of the silo and put it in a larger terrain in which we were looking at state policies on sexual education and contraception and healthcare and the employment safeguards for pregnant women, and that when all of those policies are in view, we could ask, do states that restrict abortion help women avoid unwanted pregnancies, and do they support women with wanted pregnancies? That's the sort of larger question. So do states protect life in ways that enhance or that restrict women's autonomy? That's the pro-choice life argument. And so I'm going to just take my few minutes to put a few examples on the table here. Americans United for Life, which have people aware of the organizations, the ALEC of anti-abortion organizations. It generates much of the legislation that you see in the news, and that was at issue in the Texas case. It ranks all 50 states on their laws restricting abortion, and AUL ranks Oklahoma first as having the most restrictive abortion laws in the country. Indiana's 12th. So despite restricting abortion in this way, Oklahoma does not require its schools to provide sex education, even though nearly half of high school students are sexually active. And if schools provide sex ed, Oklahoma requires teachers to stress abstinence and the importance of limiting sex to marriage. Unlike 19 states that require sex ed to cover contraception, Oklahoma, the most abortion restrictive state in the nation, does not require sex ed classes to teach students about contraception. So that's sort of a enlarging of the frame. AUL ranks Louisiana as having the third most restrictive abortion laws in the nation, but at the same time, Louisiana contraceptive needs of the smallest percentage of poor women in any state in the United States. Again, a juxtaposition. So I won't move through other ways in which one could look at policy choices affecting contraception and simply say one could ask or observe that states might restrict access to abortion without making best efforts to help women avoid pregnancies that they do not want. First observation. So then moving on, do states restrict abortion, states that restrict abortion help women who want to be mothers, help them maintain their pregnancies? So this is turning the question in the opposite direction. I'll point out, I just want to pause over maternal mortality figures, that is to say women dying in pregnancy. At the time of the court's decision in Whole Women's Health in 2016, pregnancy-related death in Texas was higher than in any other state in the United States and the rest of the developed world, a fact that didn't come into the picture in discussions of the whole women's health case, and that rate had nearly doubled in the period from 2010 to 2014, when the state had cut by over half its family planning budget that provide care for pregnant women. So this was all going on concurrently, but outside of the frame and the way that we talked about the case. I'll just skip. Infant mortality rates. Oklahoma, again ranked highest for its abortion restrictions, has infant mortality rates worse or equal to 96% of the state. So it's basically at the bottom. Yet Oklahoma has refused family planning expansion of Medicaid that would provide funds for better care of infants born into poor families. Again, it's not just a set of social facts or outcomes, but it's policy choices alongside of it. What happens if we bring poverty into the frame? I'm sort of thematizing in Pam's direction now. When women are asked about their reasons for deciding to end a pregnancy, 73% of women say they have an abortion because they can't afford to have a child. Now, demographics, 49% of abortion patients live below the federal poverty level, and 75% are poor or low income. So those are some social facts. Yet we debate the constitutionality and the politics of abortion restrictions as if resources had no connection to the decision. I looked on the websites. None of the abortion policies advocated by AUL or the National Right to Life Committee include providing resources, health care, or job protection to pregnant women or infants. I mean, this is certainly an available option, but it's just not in the set of policies that are recommended. And the last point, given the economics of the situation, pregnant women need to hang on to their jobs. 38% of women report that they decided to end a pregnancy because pregnancy would interfere with their job, employment, or career. And yet Louisiana is the only top 10 AUL state that requires employers to make accommodations for pregnant women in the workplace, and that only covers a portion of employees. By contrast, of the states that have the least abortion restrictions, of that 10, 5 of them provide Pregnant Worker Fairness Act, so provide for accommodation of pregnancy in the workplace. AUL's top 10 states don't have family leave laws, while 8 of the abortion allowing states do. So again, nested policy choices. Okay, so I'm gonna, because of time, I just want to stop and say, what does one do with this information? And I think that one could, in Mark's utopian frame, talk about a world, we could imagine a world in which there was a least restrictive means test for abortion restrictions, and ask whether the state has attempted to protect life by less restrictive means before proceeding in this direction. That's the utopian world. In the world we have today, we could talk about the relevance of this background information to balancing under the undue burden test. I think Pam will move in that direction, so I'll skip it. And I'll end with my third point, which is to start where I started. Wherever courts go, it has to do with the larger political conversation in which they're nested. So whether we're fighting with an effort to save Roe's future, or we're in a world in which Roe has already been overturned, making appeals on these sets of facts, looking at the ways in which this country makes choices that fail to protect life, is relevant to having this conversation. It would be a great if abortion were lost and we actually made headway on all of these other fronts, given where it is that we stand. I'm not advocating for that, but I can certainly say that these conversations should be happening together, so that when we're talking about protecting life, we're talking not just focusing on this one woman embryo fetus dyad, but we're talking about the choices a community is making across a range of issues. I'll stop there.
Great. So I too want to thank the Indiana University Law School, the students in the Law Journal, the students at ACS, and of course Dawn for putting together this conference. It's actually in some ways more vital that we're together after this election than maybe we thought it would be, because it's good to realize that you are not alone on occasions like this. To just pick up on something that Dawn said about 30 years from now, 30 years back, there were two things that Chief Justice Burger said in 1986 that turned out to be terribly, terribly wrong in various ways. One of them was that he gave an interview to Parade magazine where he said that any argument that the Second Amendment covered handguns was a fraud. And of course, he was as conservative as there was a person on the Supreme Court at the time, and now we see ourselves in the post-Heller, post-McDonald world. But of course, the other thing he said that year was in his concurrence in Bowers against Hardwick, that of course there was no right for gay people to have any kind of autonomy because, according to Blackstone, sodomy was a worse crime than rape. And you know, I think today there isn't a person in America who would actually make that argument and wouldn't then be sent to the hospital for the criminally insane. You know, things change, and it's useful for you all as students to remember that, because the year I started law school was the year that Ronald Reagan was elected president. So I have spent my whole career up to this point in a world that doesn't look super favorable in a lot of ways, and yet there's been a lot of progress on a lot of issues, and so it's important to kind of keep that faith and keep that hope. Maria Cuomo said that people campaign in poetry and govern in prose, and so I thought I would start my talk with you today with a poem. Do not worry, it is not a poem I myself have written. It's the end of a poem by Philip Larkin called Bridge for the Living, and it ends this way. It says, reaching for the world as our lives do, as all lives do, reaching that we may give the best of what we are and hold as true, always it is by bridges that we live. And I think you've seen a little bit of that in some of the discussion over the course of the conference. And for example, Nancy's point about we have to build a bridge between scholarship and the practical world in some ways. Or Bill Marshall's observation that we have to build a bridge to people who don't agree with us 100% on every issue if we're actually going to make progress. I mean, that is, in some sense, the message of things like Federalist 10, that you build coalitions and those coalitions are shifting over time. And so there are things on which you can make common cause with people that you disagree with on a lot of other issues. But one of the problems we have, and this is the problem I'm going to talk about a little bit in my remarks with you today, is that constitutional law has been super siloed as well, so that doctrines and insights from one area of constitutional law often don't carry over into other areas of constitutional law. The prior piece that I published in the Indiana Law Journal tried to do this by talking about First Amendment free exercise cases and voting rights cases, by using some of the themes that have been developed in the religion cases, like the idea that free people are entitled to free and diverse thoughts and that the government isn't supposed to categorize you in these ways or direct your activities, should also be important in the voting sphere, and that the idea that we don't have an insider and an outsider class of people, some people whose aspirations are recognized by the government and some people whose aspirations are not recognized by the government, which we got from the First Amendment, should also play out in deciding who gets representation and who doesn't. In my remarks today, I want to begin another conversation about a relationship between two areas of law that most people don't think about together, and to give you a couple of tentative suggestions that I'm going to work on in my paper. And these two areas are reproductive rights and voting rights. For a long time now, when it came to redistricting, I used to joke about how reproductive rights and voting rights were connected, because politics, like reproduction, has lofty goals. There are deep passions about identity involved. There's a lot of instincts for self-preservation. In modern times, there's an increasing reliance on technology. And as the Supreme Court observed in a case involving redistricting in Florida, you sometimes have to pull and haul at the very end. And of course, both of these often involve people getting screwed. But in a more serious way, aspects of these two areas of law give us some information about each other, the two areas. And I think this may help us in thinking through these areas and a way of having an opening wedge into some of the issues that both Dawn talked about and the prior panel talked about inequality. So here I want to focus on an issue on which Indiana is in some sense ground zero, the first generation voting cases, sort of voting rights first generation 2.0, that is the new disenfranchisement cases, voter ID, restrictions on early voting, restrictions on same-day registration and like, and talk about those in conjunction with abortion rights. both of these areas of law, of course, lie at the very heart of self-determination. That is, the joint opinion in Planned Parenthood against Casey and what Riva was just talking about, talk about how women can't really participate in the economic and social and political life of this country if they don't have control over their own reproduction. That control is essentially political in some very important ways, because just as women's control over their reproductive capacity enables them to participate in politics, so too effective participation in politics is what guarantees women that right to control their reproductive destiny. And if people had forgotten that relationship, and I think some of the people on the left just thought there was too much crying wolf over this and the like, the election of Donald Trump and Mike Pence and the recent announcement about pulling the funds from Planned Parenthood and the like should remind us of those things. Self-determination for women depends on both individual and collective decision-making. And if you look at how the law in these two areas has developed over the last 40, 45 years, you'll see a number of really interesting parallels. Just if you go back to the Burger Court era, these are two of the areas in which fundamental rights strict scrutiny first emerged. That is the idea that courts have to take especially hard looks at restrictions on people's control over reproduction, and especially hard looks at laws that restrict the right to vote. And so we had strict scrutiny for a while, and that got really eroded during the years of the Burger Court, the Rehnquist Court, and then the Roberts Court, down to a kind of balancing test in both of these areas. A balancing test that focuses on whether there's an undue burden on the right. These are also two areas where I think that argument that we should relax the scrutiny like came out of what I think of as a bunch of jujitsu moves by people on the conservative side. So Riva's written quite powerfully about this in the context of so-called women protective rationales for restriction on abortion. But the electoral integrity rationales that were used to try and get rid of expansive voting rights, ideas about fraud and the like, play essentially the same role. That we used to be the people talking about electoral integrity, that you couldn't have an election with integrity unless everybody had the right to participate, and that got kind of seized by conservatives, and so they make an argument that of course we should be very worried about fraud. And here in Indiana, I don't have to remind you that more nuns were disenfranchised in one primary election in one precinct in South Bend than all of the documented cases of in-person voter impersonation fraud in Indiana. Well, in Indiana, since its statehood in 1816. So, 8 on the one hand, 0 on the other hand. You do the math. So there has been this kind of shift, and we need to seize back. I mean, this is the one thing that I think is so important, is we need to seize back the idea that electoral integrity cannot exist if large numbers of Americans cannot vote because laws restrict their ability to get to the polls, to cast a ballot, and to have that ballot counted. Now, in recent years, the hopeful thing that I think we're seeing is that courts, including the Supreme Court in Hellerstedt, have started to recognize that if we're going to talk about undue burden standards, we have to talk about the undue burdens on the people who are actually affected by the laws. And we have to look at how these laws interact with social and economic conditions to create an inequality in the ability to participate or the inability to get access to reproductive services. And perhaps I think these areas, because they already have the kind of coloration of being fundamental or quasi-fundamental or at least important rights, are a good place to start the arguments about how economic injustice becomes constitutionally problematic. And here, I'll just tell one last story, because it's a story that occurred when I was working on the Texas voter ID case, and we were down in Texas for the trial in the case, a case which, to go back to the first panel of the day, the United States government argued quite strongly showed purposeful racial discrimination by Texas, and the Trump administration has now withdrawn that argument. After spending hundreds of thousands of dollars of government money to prove precisely that. But I want to just tell this one story from the case because I think it illustrates, and it was such a powerful moment at trial that the district court judge put it into her opinion to explain what was going on. When you talk about the burden of voter ID laws, and if you're on the election law listserv, you would have seen today people saying, oh, it's no burden at all. It's not a burden for most of the people in this room because how many of you have driver's licenses? Okay, good. How many of you have passports? Good. How many of you have concealed carry permits? Don't tell me. Right? Almost everybody in this room has access to those documents. And if you didn't have access to them, you know how to get them. Because you're in law school, you're sophisticated, you're somebody who is prepared to yell at a government bureaucrat for a little while to get something if you really need it. I'm sure your registrar feels that acutely. But if you're not one of those kinds of people, it's really hard. And so this is the story of Sammy Lou Bates, who's a woman who's 42 years old. She's voted in Texas for her entire life, but she was born in Mississippi. And she didn't have her birth certificate, which you need in order to get the ostensibly free ID. Texas says they'll give you a free ID, but you have to come with documentation. And among the documents you have to have, one of them is a birth certificate. And of course, where do you go to get the free ID? You go to the DMV. Where are DMVs located? They're located where people tend to drive. So if you don't know how to drive and you don't already have a license, you've got to figure out a way to get there. And we had a lot of expert testimony from demographers and like figuring out how long does it take from population centers in Black and Latino neighborhoods to actually get to the DMV and by public transportation. And the answer is a long time. But Mrs. Bates put a face on this because she testified that she really wanted to be able to vote, but she had to get the $42 Mississippi birth certificate to get the free Texas ID. And here's what she said in her testimony. She said, you know, I didn't have the money, and it took me a while to save it up because she has a monthly income, cash income of $320. And she said, it took me a while to save up the money because, you know, I can't feed my kids with a birth certificate. I can't feed my kids with a birth certificate. And once you understand that there are people like Mrs. Bates, then you understand why these laws create a burden. When you understand that she doesn't have a car, so if she had to terminate a pregnancy in Texas, she would have to get on a bus and travel for hours and hours and hours to get someplace where she could get reproductive health care. Then you understand what the burden of a law that shuts down half the clinics in Texas is. And I think once we get people to understand that, we can start to get them to understand all of the other things that socioeconomic inequality burdens in people's exercise of what we all take to be the rights of living in America as citizens in the 21st century. So.
Excellent. Okay, well, thank you all for being here. Thanks to the law school and to ACS, to Dawn, and to the Law Review, of course, for hosting us and having us here today. My apology to the participants. I've been a bit under the weather today, not operating with full vigor. You might contrast me perhaps with the Second Amendment, which you might think is operating in very full vigor these days and is in fine health. Born in 2008 in the District of Columbia versus Heller case, not really, but the Second Amendment was reinvigorated and brought back to life in some ways by a vibrant social movement for gun rights that resulted in the 2008 Supreme Court decision in D.C. versus Heller. So not only is the Second Amendment alive and well and living in America, but has really come to life in many ways. And indeed, since Heller, there's been a wave of Second Amendment lawsuits, literally hundreds of federal court decisions on the constitutionality of a wide variety of different kinds of gun control laws, the vast majority of which have been upheld. And of course, the Second Amendment is benefiting from the recent filibuster controversy and appointment controversy in Washington. Many reporters were calling me before the election asking if a Clinton-appointed Justice Garland would vote to overturn the Second Amendment, rendering that book that Dawn so kindly showed you mostly irrelevant. So that didn't happen. So maybe I should be happy about that. I'm going to have to deal with that. But there were concerns that Garland might vote to overturn the Second Amendment. Certainly, Neil Gorsuch is not going to vote to overturn the Second Amendment. And to the extent the Second Amendment and the Heller case itself was in jeopardy, not likely to be such anymore. But nonetheless, while I've sort of told you about how healthy and vigorous the Second Amendment is, I think the Second Amendment is becoming increasingly irrelevant in shaping America's gun policy. And the reason why, I think tell us a little something about the nature of the law and the nature of constitutional development and social movements. And especially the relationship between social movements and the Constitution and constitutional argumentation. So there are I wish to suggest two Second Amendments. There is a Second Amendment in law. There is, which is how courts apply the Second Amendment to legal cases challenging gun control laws. This is the case and the hundreds of cases we've seen since. And of course, one of the central purposes of any constitutional provision is not just to provide a rhetorical tool, but to actually do the job, on-the-ground job of sorting out which laws are constitutionally permissible and which laws are constitutionally problematic and thus not able to be adopted, separating out those valid laws from the invalid ones. Let me contrast this version of the Second Amendment, the Second Amendment in law, with the Second Amendment in politics. And the Second Amendment in politics is the Second Amendment that is used by lawmakers and legislators and political actors and social movements to articulate meaning about the Second Amendment. And here the Second Amendment serves as that powerful rhetorical tool used to justify things like reforms we're seeing in the states over the last 40 years. So the last 40 years we've seen a move where 40 of the 50 states have moved from very restrictive policies on who can carry guns on the streets to very permissive policies today over the vast majority of the nation. Very permissive to carry a gun. And that's a result of this Second Amendment, this political Second Amendment. We've seen more and more states moving away from permitted carry altogether. So the rise of what they're calling constitutional carry, again showing how good gun rights advocates are at employing and exploiting the language of the Constitution to say that there's a right to permitless carry. No court has ever said such a thing, but yet that's the vision of the Second Amendment embodied in the political Second Amendment. And of course, the political Second Amendment is closely related to the legal Second Amendment, right? As Riva Scholarship and others here have shown, that you wouldn't have Heller without having that social movement that articulated a political vision of the Second Amendment that became very, very successful and ultimately changed how courts thought about the Second Amendment. But despite those ties, these two Second Amendments are really very different. And it's pretty remarkable that they are so different, being that the political movement that led to Heller, it's not even 10 years old. Not the political movement, but Heller's not even 10 years old. And the version of the Second Amendment that was promoted by that political movement I don't think has really been reflected in Supreme Court doctrine. The political Second Amendment is much more robust today than the legal Second Amendment. Under the political Second Amendment, you'll hear lawmakers say to majority support in legislatures across the country that any kind of discretionary permitting for concealed carry is unconstitutional, a violation of your Second Amendment rights, that bans on assault weapons, military-style rifles, are unconstitutional, and that bans on high-capacity magazines are unconstitutional. And these are not legal claims in the sense they're not claims made in a court of law to try to defend, although those claims are made by members of that coalition as well. But these are arguments about proposing legal reforms in state legislatures to make gun laws more permissive. Now, under the legal Second Amendment, many more gun control laws are constitutionally permissible. In fact, of those three things that we've talked about that I mentioned, discretionary permitting, bans on assault weapons, restrictions on high-capacity magazines, three of the biggest issues in the gun world today, the federal circuit courts are unanimous that these policies are constitutionally permissible, that they don't run afoul of the Second Amendment. Same thing with with discretionary permitting, with bans on assault weapons, and restrictions on high-capacity magazines. So you have this very huge difference between the legal Second Amendment, how it's operating in the courts, and this political Second Amendment, how it's being articulated. And this political Second Amendment, I said the Second Amendment is becoming increasingly irrelevant. Well, this is why we need to divide up these two Second Amendments. Obviously, the political Second Amendment is not becoming irrelevant and is not becoming weaker these days. If anything, it seems to be becoming stronger, and the election of Donald Trump and the Republican majorities in Congress only enhanced that strength, to be sure. There's a major push that the NRA is going to have over the next 6 months for a national reciprocity bill. This would be a bill that would effectively outlaw discretionary permitting. It's not phrased in that way, but that's how the laws would ultimately work. They would require a city like Los Angeles, which has very restrictive permitting policies, to respect a gun permit issued to someone by any other state. And they'll tell you that this is about someone from Utah who has a Utah permit being able to come to Los Angeles and carry their gun while they're on vacation. And some versions of the law just do that. But there's also versions of the reciprocity law that require Los Angeles to recognize that permit even if the person is a Los Angeles resident. Because Utah doesn't require you to be a resident to get a gun concealed carry permit. So a Los Angeles resident can get a permit in Utah without ever setting foot in the state, online, and then carry that gun in Los Angeles. So that would eliminate discretionary permitting. There's a move to lift the ban on silencers, likely to be successful. In the states, the political Second Amendment, as I said, really controls the gun policies of 40 states in the nation under the influence of the NRA. And so the future for that Second Amendment seems pretty good, actually. It's the legal one, where there's a lot of activity, where we're actually seeing a growing irrelevance. And it's in part because of this distance between the political Second Amendment and the legal Second Amendment. This week, the Supreme Court considered a cert petition on whether to take a case on the constitutionality of discretionary permitting. Probably won't take that case. There's not a split in the circuits. As I said, every circuit has upheld discretionary permitting. So while the Supreme Court takes this case, while the justices are debating whether this permitting policy is constitutionally permissible, the states are continually moving away from this kind of policy anyway. That if they get the decision by the court, it's only going to affect the law of about 8 states, and that's if you don't get a national reciprocity bill that already overturns effectively those laws of 8 states. And so national reciprocity, again, the political Second Amendment making that legal one less relevant. And the Second Amendment's also being replaced in odd ways. What we're also seeing is the gun rights movement creating an alt Second Amendment. Right? The legal Second Amendment that they're getting out of the Supreme Court is not very good for them. They're not happy with the results coming out of it. So they're creating an alt Second Amendment at the state level. So states protect the right to bear arms in their state constitutional provision. Indiana's state constitution protects the right to bear arms, for instance. Traditionally, courts in the states do the same thing that the federal courts have been doing since the Heller case, which is pretty much deferential scrutiny and upholding most gun control laws. So there's a big push. They're pushing for referendums in these states to raise the judicial scrutiny to strict scrutiny for gun rights. And this is passed in Louisiana, passed in Missouri. So the movement is trying to create a state law regime through political activity that has a higher standard of review in court. So they're trying to beef up the Second Amendment by creating an alt Second Amendment at the state level. And so what is the answer? And part of the difficulty here and why it ties into the social movements is that, so we see this success and this divide between these two amendments in part because of the political success of that movement. There's been a strong social movement, and we haven't seen that same kind of social movement on behalf of gun control at the same time. And there's an emerging elements of a gun control movement in America, but what does that gun control movement do with the Second Amendment? So if the social movement is very much focused on issues of a constitutional dimension of the Second Amendment, what version of the Second Amendment does that movement articulate? Does it articulate the old view that progressives had of the Second Amendment, that there's no right to bear arms in the Constitution? Well, that could really make the Second Amendment irrelevant, because there'll be a 28th Amendment providing for strict scrutiny for gun rights the moment such a Heller case, or not the moment, but be triggered by Heller being overturned. At the same time, the gun control movement is not likely to embrace the current version of the Second Amendment, even though it's gun control friendly, because it still has this one issue of recognizing the individual right to bear arms. But at the same time, and this is the dilemma, failing to articulate a vision of the Second Amendment that can motivate and shape the social movement, leaves that playing field to the political actors that have been promoting gun rights for the last 40 years in America to keep articulating a constitutional vision. And it runs the risk of, while the gun control movement's trying to figure out what to do and figure out how to articulate a constitutional vision, that the political movement and the legal Second Amendment eventually starts to take on the norms of that more extreme version of the Second Amendment.
Okay, thank you all. I thought I'd just give everyone a minute or two, if we can, if there's anything the panelists would like to say in reaction to each other. If we can do that very quickly, starting with Riva, and then go to audience questions and comments. Riva, any quick reaction?
All right. So in the spirit of a minute or two, I'll just throw out a thought about listening to Pam and thinking back to, I think it was actually Adam's comments towards the end of the last panel when there was a discussion about the potential risks of constitutionalizing arguments for economic equality and all of that. Without rehearsing all of that, I just want to point out that the kind of argument that Pam is laying out is not calling for strict scrutiny of wealth classifications or constitutionalizing equality rights in any straightforward sense, but rather saying, as to the whole range, really, of our constitutional understandings, when courts go to interpret and vindicate rights, what background understandings, whose life experience is central in the way in which they understand and protect rights, and asking that question with attention to, deep, deep wealth inequality could alter the ways in which rights are understood and enforced without having sort of breaking out a separate wealth equality argument. That's one point. So, undue burden then becomes a scene in which we can talk about that. And not only is Pam going in this direction, Carrie Franklin also has a paper that's doing much the same. For a second comment, thought about Adam's remarks, I found myself listening and again wondering about the difference between the legal and political Second Amendment over the longer run. That is to say, if we backed up to, as I did in my Dead or Alive paper, if you start in 1968, there's no legal enforcement. The court is not enforcing the Second Amendment, and you see this decade after decade building out of political claims on the Second Amendment, which then either get legalized or constitutionalized, depending on the language we're going to use here. And one could imagine, if the Supreme Court swings far enough to the right, that some of this would find its way into a Heller line of cases. And then to tie it back to my paper, maybe you ought to have a pro-choice life argument about, if you're talking about, why not talk about the counter-argument to gun rights as argument for life? Why does life only have this one restrictive referent point? How is it, what are strong value claims that can be made on behalf of health rights here, on behalf of life, protecting children, other good things that in some contexts seem to have a lot of power? Why not move them here as well? All right, that was my short comment.
So I just have a very brief observation, which goes to the social movement point and the fact that, at least in recent decades, the social movements on the right have been far more concentrated on single issue voters who clearly, they're going to vote for a candidate because he's in favor of or against gun rights. They're going to vote in favor of or against a candidate because she's pro-choice or pro-life. In a way that it's much harder, and I know I feel this so acutely as a liberal, that if you believe in fairness and you care about a whole lot of things, it's much harder to be a single issue voter. The last time we had kind of really single issue voting on the left was probably the Vietnam War, and we managed to at least make some progress on the war or the civil rights movement. But it's really hard today to ask any of the constituencies that we care about to put themselves in let's vote for a pro-life Democrat because he believes in raising the minimum wage. It's really hard to get people to care in that same way. And I think that's part of what makes it harder to build a social movement on the left that affects the courts, because people don't think of a single issue in the courts as the thing that's going to determine which way they vote and what they contribute to and the like.
Adam?
Right. And we talked earlier sort of how to think about how liberals should approach courts in a conservative era. Should liberals be thinking about delegitimizing the courts, and then that leaves the playing field for conservatives to, say, make that a central issue and use it and leverage it for electoral benefits. Alternatively, I mean, it's important to recognize that even if the courts, we don't have to think that the courts aren't involved in social change, because clearly they are involved in social change. Clearly they need to be the subject of our political focus and debate. But there is a real question for liberals, I think, in terms of how do you go about engaging that question. And I think it's especially prominent in the area of the Second Amendment. I think there is a real confusion on the gun control community about how to think about the issue of gun policy in constitutional terms. And so sometimes it's a right to life, is the way it occasionally gets offered. But as Riva's scholarship is, so much of Riva's scholarship points out, how these arguments get flipped. The right to life argument is very easily flipped in favor of gun rights, right? That's a central argument that they make. And so very difficult to see where that dilemma is. So how that social movement for gun control can sort of grapple with the question of the role of the courts in and constitutionalizing these arguments when it's not clear what kind of text they can go for or a vision of the Second Amendment that would unite the coalition.
And just one last thing about the courts and legitimating or delegitimating the courts that I really worry about, which is a lot of the communities that we care about are involuntarily brought into court in various ways. And so to delegitimate the courts is a really troubling thing when a third of a community is under correctional control, or when people have to go to court because they're challenging deportations or the like. And so you know, it's one thing to talk about, is the Supreme Court getting particular cases right or wrong? And has the Supreme Court become too aligned with partisan interests in one way or another in particular kinds of cases? It's quite another thing to say the courts don't matter. The courts really do matter if they're trying to take away your kids, or they're trying to put you in jail, or you're trying to get your Social Security benefits, or you're trying to get asylum or the like. And so I do think it's important to kind of separate critiques of particular cases from the idea that, you know, the courts should be delegitimated as an institution.
I hesitate to say this, but I started out charging the bear, but I feel...
That was because he was in the elementary school with your children.
Yeah, then I would be a mother bear. So I just feel discouraged. And so I want to thank Pam for how you started with your note of encouragement to the young people. Brought me back to when we were at Yale Law School together, and I was the Northeast coordinator of Students Against Reaganism. You know, it was a pack we formed in Yale Law School. So, you know, it's good to keep that all in context and all the progress. But thinking about how we talk about the kinds of progressive values that, I mean, Riva, I totally, you know, love everything you said. Pam, too, the woman, what was her name? Sammy Lou Bates, you know, so do we really persuade legislatures, as we have to move more politically on these issues, with those kinds of appeals? And the flip side, what everyone was just saying, the court should be doing this. We have to keep saying the court should be doing this. Are we going to persuade the legislatures? And we have, it takes me back to, I was the legal director of NARAL back in the late 80s when it looked like the court was going to overrule Roe. And we changed the name from the National Abortion Rights Action League to the National Abortion and Reproductive Rights Action League, because we wanted to expand the agenda, talk about contraception. Planned Parenthood's all over that. I wrote a brief in Webster making the least restrictive alternative argument for life. That's the courts. legislatures, I just don't really see. I shouldn't play devil's advocate, but I'm just getting into a crouch, unfortunately. No, but so
Buck up.
no, so so here's the thing, and the right is the ideological right so good at, as Pam said, in co-opting our progressive values. So
Think about the story that's all over the national news now. There's an Indiana story all over the national news, which is about that woman who voted for Trump and her husband is being deported. And the whole community therein is saying, like, who's going to the restaurant after the husband gets deported and like, right? And if we think about the most successful progressive legal victory over the last, I don't know, 25 years or so, it's the gay rights movement, right? And how did that turn out so well? Well, it turned out really well because a whole bunch of people woke up one morning and they discovered their kids were gay, right? Now, if we could get them to wake up and discover their kids were undocumented or a racial minority or had abortions, that's exactly right, which is in 1986, gay people were in the closet and women were talking about abortion a lot. And now what you have is gay people are out of the closet and women who've had abortions are in the closet, right? And, you know, I think the power of stories to affect people, especially stories in their local communities. And this goes back to, I think it was the second panel this morning where people were talking about, you know, doing things locally as well as doing things nationally, is, you know, I bet you the people in that community where they don't have the guy cooking, you know, cooking in the restaurant anymore, they're going to think a little harder the next time about immigration policy, because it now touches them in a way. And so some of this, that's what I mean by building bridges, is you have to get people to understand that this is not about somebody else, it is about other people here who are part of our political community. And if you can get people to understand that, I have to have faith that if you can get people to understand that, they will feel differently. I mean, you know, look at Rob Portman, right? Totally anti-marriage equality until he wakes up one day and discovers his son is gay, and now he just wants to go to another wedding. You know, so.
all right, thank you.
I'm sorry.
Thank you. So
did
yeah, no, I'm just swinging here. Okay, so let's go to the audience with questions. We have our microphones there. Great.
Okay, since I was the one who used the phrase delegitimate the court, I want to explain what I mean by it. Doesn't mean that we're supposed to treat the courts as unimportant. For me, it means two things. First, the fact that a court does something has no normative weight whatsoever. Okay? It's either right or it's wrong. That it's done by a court is just irrelevant. So most of the time, in the short run, we'll be dealing with courts that are not on our side. And we should make it clear that the fact that we lost has no bearing whatsoever on the validity of the normative validity and indeed the legal validity of the claims that we make. Okay, that's the first point. Second point is that this was the point of my.
Can I just ask you a brief question about that, Mark? Then how do you respond to, like, Kim Davis?
She's right. So, you know, from her point of view, the court's decision has no normative weight.
So she shouldn't follow it, or she should follow it?
It's an entirely prudential matter. She shouldn't follow it because bad things are going to happen to her.
Does everyone know who Kim Davis is?
Kim Davis is the clerk in Kentucky who wouldn't, among other things.
You can't, in the world that we live in, you can't give normative weight only to the decisions that come out in your favor. It's not going to help.
Are you saying that public officials should only follow the Constitution if it's right in their perspective?
I actually think so, but...
That's actually a different question, though, I think. Don't you think, Mark? It's a separate question.
Yeah, I think it's a separate question. Right. Yeah.
So you could think Kim Davis should, as a public official, but that doesn't mean it's normatively correct.
Could think that.
Yeah,
I think for prudential reasons, we ought to have a rule that says public officials ought to follow the law as stated. but that's purely prudential, not principled. The second thing is
Do a lot of binding with prudential reasons of that sort.
okay. So there's okay.
What's the second thing? That would be good to know.
So it was signaled by the Gorsuch Republican of Colorado. You know, this is a conversation that came up at a conference last week. A lot of people now are willing to say that, of course, what the courts do is political in a sort of broad vision of the world sense, where people divide politically about their vision of the world. I think the next step is to make it clear that in a non-trivial number of important cases, the courts are partisan, not political, okay? So it is not that Citizens United rests on some deep, coherent account of the First Amendment. It is that Citizens United is a Republican decision. Okay? And we can go, okay, that's what I mean by delegitimating the court, by making clear its partisanship and its, I would say, independence of, but if you want to say only extremely loose connection to normative weight, that's okay with me.
Yeah, great. Yeah, so I say two very provocative, important points, I think. Reva.
So I'm aware that the audience wants to come in, and so I'm just going to be very brief and say that I would like to hold out for a richer account both of politics and of law in this story. And so when you say partisan or just the Republican Party, I think we actually are in a condition where we need, I'm now looking at Neil, we need to develop a language of role morality and responsibility and principle that informs our political lives together, because we can't look to courts to save ourselves from one another. And so I'm prepared to say we should talk about the political and find a space within the political to talk about people acting on interest and also people acting from responsibility. We need a much richer vocabulary than we currently have. Everything about the current administration is teaching us that courts can't fix all of this, and we need a much richer language to interact with one another. The Merrick Garland hearing, we could talk about whether that was a constitutional problem or a political problem, but I just don't want to treat it as just a partisan question, if politics means partisan, on the one hand. And on the other hand, I'm looking for a picture of law that isn't the Chief Justice's balls and strikes, so it's mechanical all the way. We need to find a way to talk responsibly to the American public and the voting public about the degrees of discretion and value that informs constitutional interpretation, which explains to people why it is they need to get to polls and vote for people who are appoint justices who will interpret the Constitution in a way that they find right and just. And at the same time, so I'm resisting the mechanical, and at the same time I want to find languages to acknowledge all the ways in which there is indeed discretion and value and what you're going to call politics without it just being only partisan. So I guess I'm saying we need to find these languages in both domains. That was my short response.
Okay, let's do 1 minute from Adam.
Oh, okay, just a quick response.
Yes.
I actually, maybe I'm just the outlier. I actually think it's a real mistake to delegitimize the courts. I think it's really important. When we're going through the confirmation hearings, I know a lot of people, especially law professors and lawyers, think, oh, why is he saying things like judges don't make the law, judges just decide the law, we're a rule of law and we're judges, we're not partisans. I think that's really essential rhetoric to keeping up our constitutional order and having a court that does have the respect of the people, because it has commitments other than partisanship. And while I don't want to be Pollyannish about what's driving judicial decision making, I tend to kind of prefer Frankfurter's vision that it's politics, but in the highest sense of the word, rather than just sort of sheer partisanship. And then again, you can't deny that judges are influenced by some things. I think it was Ganesh was telling me earlier about a study that found that judges whose college football teams lose in an upset fashion tend to issue stricter sentences to juveniles immediately after that. So don't worry, it's not what the judge had for breakfast yesterday, it's whether his football team won.
So I wasn't going to say anything, but that pushed me more to Mark's first point. You know, I just maybe this is a twist on it that I just came to mind. I've heard several judges say, you know, it's reversed by the Court of Appeals or the Supreme Court. Doesn't mean they were right. I mean, it's how judges themselves, you know, look at it. It's what, you know, was it correct or not? And I think we have gone too far in the direction of, remember when President Obama criticized Citizens United, right, at the State of the Union. And there was an uproar that was completely inappropriate and at an extreme. Anyway, so let's go, Tony, to the next question.
Hi, I have a question about voting rights, and it dovetails sort of with what Professor Johnson was expressing as a frustration between whether the courts or the legislature can address something. So external to voter ID laws, which obviously have a host of issues and legal challenges, there are tons of procedural constraints on the voting process, and especially here in Indiana, we have some pretty awful ones. You have to register 29 days in advance of the election. If you don't have a state ID, you have to do it in paper. You can't do it online. 6 a.m. to 6 p.m., I think, is our polling time, which is fairly sort of narrow window. So my question is, are there legal inroads to painting those as undue burdens, or do you think it has to be more of a policy silver bullet? I know that Secretary Clinton had proposed universal registration at the age of 18. Senator Sanders had voting day as holiday. Do you think that there is a silver bullet or any legal options?
I mean, so there are a number of different things you could do to make voting a lot easier. They range from, you know, same-day registration is one of the most effective ones that allows people to register and vote on the same day so that they don't have to worry about the registrations being screwed up or like longer hours, early voting. I mean, there isn't a particular silver bullet. The other thing is giving people more of a sense that their vote actually matters will increase voting. So one of the things we know is competitive elections produce higher turnout than non-competitive elections. And in many parts of the country, at least for statewide and national and congressional office, there's no point in going to vote. I mean, I go to vote in elections in California that are just for president, you know, Senate, House seat, even though my vote is going to make absolutely no difference because I live in the bluest parts of California, and now after the drought, the really bluest parts of California. But I go because I care about it. For a lot of people, it's a little bit costly, and so if they don't think it makes a difference, if they don't think that there's a candidate who's responsive to them. I mean, this goes back to something actually that Kate's written about the hollowing out of the parties so that people don't have a sense that the party that they would affiliate with will be responsive to them. I mean, all of these things it's an ecosystem. So there's not a silver bullet, but there are a lot of things you can do that would increase turnout. I mean, the states that have same-day registration, turnout increased. For all of the socioeconomic disparities and tremendous discrimination in North Carolina, in 2012, when they had on the books early voting, same-day registration, out-of-precinct voting, no voter ID, and Barack Obama on the ballot, who was a real inspiration to the African-American community in North Carolina, they turned out at the same rate as white people.
Pam, I might
So
be wrong.
there's lots you could do.
So I might be wrong about this, but I think maybe Keegan, who's with the College Democrats, and I mean, they've been trying to get these things here in Indiana. Not going to happen. So I don't know if the question was like at a national level, anything the courts can do. You know, how can you help us here?
I mean, you have to change the conversation so that people think it's a disgrace that there are American citizens who find it difficult to vote. And you just have to keep pounding on that until it kind of breaks through that, you know, that it's just a disgrace that people in Franklin County, Ohio should have to stand in line for 6 hours to vote. You know, it's just a disgrace, and we have to keep saying, that's a disgrace. Every American should be able to show up at the polls, cast their ballot, and get to their job, their good job, at good wages.
Okay, we have a question. Let's do 2 in a row now. We can go for a little bit. And so let's have a question here, and then Tony gets someone over there, and then we'll get responses. Yes, go.
All right,
So it's similar to what Professor Tushin has. There's a number of things states can do, and that's declared they do not have to actually protect certain rights. They can defer it to another state or to another community within the state. Kind of like how the governors of Mississippi and Kentucky ran on platforms of making them abortion-free states. And the defense Mississippi had in the Fifth Circuit, when it had a similar case to Hellerstedt, was that people can just drive to another state and get their abortion there, so they're not really infringing on autonomy for reproductive rights. And in the same way, the city of Chicago recently had a blunder when it lost a case defending its complete ban on gun sales within city limits. And they said the same thing, that they can just go to another part of Illinois or go to Indiana or Wisconsin and get a gun. And that lost in the courts, and it's the same with San Francisco did it. So it's kind of like similar to what Jesse Helms once proposed, is building a wall around Chapel Hill just to keep out something that is not in uniform within the culture or the interpretation of a constitutional right within a state, and deferring it to, and just saying we refuse to take on this responsibility and move it somewhere else, or keep it contained to certain communities.
Okay. Tony. Nancy.
First, as a version of what Mark was saying, is the notion that political debate should not be constrained by legal debate. In other words, that's something that's, we have a habit of constitutionalizing our politics, and then when you lose, be stuck by the legal framing of it rather than a wider political framing. But I wanted to focus on Pam and Reva's notion of sort of litigating undue burden. The significance of facts in courts, not just facts as narrative, but empirical facts in courts, can't be underestimated, particularly in these times. The Miller decision, which is the decision that wiped out life without parole, mandatory life without parole for juveniles, was to some degree a common sense view of juveniles, but the fact that it was grounded in neuroscience enabled justices to say it's not a normative decision, it's not a political decision, it's based on facts. And so it seems to me that in all of the areas that we're contesting, empirical, factual presentations take some of the sting out of the normative discussion, and in addition provide the stories you're describing.
Can we keep going? So I think these are great points. So let's keep, I think over here, yes.
So the point I want to make is in response to the suggestion that political government officials may not be are not under any legal obligation to comply with valid federal court orders. This statement earlier that when the Democrats control both the White House and both houses of Congress, what they ought to do, it would be a good thing to pack the U.S. Supreme Court. And every time that is said, people laugh, and I'm not laughing at all. I think this is deadly serious stuff. The point I want to make is that there is nothing at all distinctly liberal or progressive about those ideas, right? I mean, you need courts to protect abortion rights. You need courts to protect voting rights. You need courts to be willing to decide Brown to begin with, and then lower courts be willing to issue court orders to desegregate in the face of massive resistance. So the idea that this is simply Donald Trump right now has been laying the groundwork for a disregard of judicial authority in the wake of a terrorist attack by preemptively blaming the political judges and the news media, right? And if you say, well, they are Republicans or Democrats from Colorado or New York, right, that is just fuel to his fire. So this can cut very different ways ideologically, and I would not want anyone to leave thinking that this is the liberal or progressive view. Think about court packing, right? So the idea is that the Democrats are going to pack the court when they have the opportunity, and that's going to be the end of it, right? Which, you know, it's not that the Republicans will then pack the court when they have the opportunity. It's not that we're not going to start engaging in jurisdiction stripping. We're not going to start impeaching judges and justices on political grounds. And by the way, It's the third time I've heard it in the last week from liberals that we should be packing the Supreme Court when we can. So we're communicating right now to the Trump administration and Mitch McConnell that there are literally no limits. There are no normative or conventional limits about what you can do to the courts in order to achieve a political agenda. So why exactly should they not be packing the court now? Is the only answer that, well, maybe they should. The only limits are prudential.
So I want to just defend Mark for just a moment, because I think he said, maybe not, but a version of what he said could be in this unique normative situation where a seat was stolen. Merrick Garland's seat was stolen. I think he framed it that way. So I don't think it's that there are no... So I think this is a really interesting conversation to have. Now, some of those of us who are speakers, I mean, we're going to talk tomorrow, and I want to talk more about this. This is wonderful stuff. I'm going to... Yeah.
I'm going to say one simple
Go ahead.
thing
Go ahead.
for people to think about, and then I'm not going to say more, which is we're going back and forth between respect the courts or don't respect the courts, and I think it's really important to figure out how to take inspiration from what Mark is saying about not just deferring to what judicial judgments are, and then to take what Neil's saying to find out if there are ways to resist that are still court respecting. And we're going to answer that question really differently, and I could then spend 2 hours, and I'm just going to stop. But all I wanted to say is to keep the question from going into an either-or question, and ask how to think two seemingly opposed ideas. How do they live together? We live in a legal culture, in fact, in which they do. Okay? And then I'll stop.
Yeah, that's great. And then I'm going to let Pam speak, and then we're going to have Bill. But then we can go several more minutes, and I'd love to hear if there are people who are not panelists who we can stay like for 10 more minutes just to have final comments from the audience.
So I wanted to respond to your point about, you can just go someplace else. And the answer to that is, for most things, I think that's right. That is, we have a diversity of communities in the United States, and people sort themselves into those communities, especially people who have enough money to choose where to live, pick in large part where to live based on wanting to be in a place that shares their values. I mean, we are seeing more segregation in that sense, leaving aside the racial segregation that Anarima talked about, that people make those choices. But when it comes to constitutional rights, as opposed to the general kind of social policy thing, the idea is not tell people to go someplace else. And the case that just pops into mind almost immediately about this is a Supreme Court case called U.S. Ex Rel Gaines against Canada, which was, Missouri cannot say, we don't want to have any black kids in our law school. We'll give you a bunch of money, go to a law school in another state, because you have a right, when the state decides to run a program, to equal access to that program. And so there it becomes critical to figure out which things are constitutional rights, which you get to take with you wherever you go, and which things are simple policy determinations that you have to go along with the policy determinations of the place you've chosen to live. So if you choose to live in a town that, that does not allow, RVs on the driveway, you're going to have to find someplace else to park your RV, because that's not a fundamental right yet.
Okay. Yes, Adam.
Just give me 1 minute.
Yes.
So I'll just say that, I think that that Neil's point's a really important one, too, for thinking about how, when we're thinking about utopian constitutionalism as a broad matter, this sort of thinking about how we would want the Constitution to be, we have to remember that we don't live in a utopia. We live in a real world, and we have, it's an interactive game between the two different political ideologies that reign in America, and the changes that are made to benefit progressives today are going to be used and exploited by conservatives tomorrow. And we've seen that over and over again over the course of American history. It was part of the point I was making at the last, in my comments at the last panel as well. And that we're seeing it. I mean, the Democrats' concern with the filibuster and how the Democrats had contributed to the destruction of the filibuster a few years ago. There's a lot of people thinking that maybe that wasn't such a smart move. And I do think that because we are playing tennis, where what we do is going to be, the other side's going to react to it and throw it back to us, I think it's really important that we not be utopian, that we be thinking about the future in a way that's aggressive, but that's smart, and that pays attention to how the arguments we make today are going to be used by people tomorrow in unexpected ways.
Bill.
They don't necessarily just move on, they keep that rhetoric going. Sometimes after we win an issue, we let it go, we let it slide. The next thing we know, healthcare was the big one, by the way. We just let the other side define that forever before we stepped in, and that was in a short period of time. But in longer periods of time, we do this as well. Affirmative action, the logic of affirmative action was really apparent in the 1960s. We sort of said it, we do it, and it's right, and we stop defending it in a political way that we're talking about right now, and the next thing we knew, the cases started hitting us backwards. So the lesson of this panel to me is, if we want some issues, don't let them rest. Keep on repeating what those arguments are in the future, because there will be backlash.
Back here.
So forgive me if this is a dumb question. I'm a 1L.
Thanks for coming.
Yeah. So it's mostly for Adam Winkler, and it relates to some of the comments you made earlier about, what a decision in one particular area means for something else down the road or in a different area. And I'm thinking about abortion and guns in relation to each other. And is there any argument based on substantive due process for a right to bear arms? Has that been tried, or is it just completely nonsensical? Because I could imagine it coming out of kind of like a privacy of the home sort of thing, right to protect your home. I could imagine that working in the same way as like a 13th and 14th Amendment working to protect against discrimination.
So there is a little bit of that. So part of substantive due process also includes incorporation of the Bill of Rights to apply to the states. And so the Supreme Court's decision in the City of Chicago against McDonald, or McDonald versus City of Chicago, was essentially a substantive due process decision in that it incorporated the Second Amendment to apply against the states. I think you were asking a slightly different question about the other strand of substantive due process, the one that holds unenumerated rights that aren't listed in the Bill of Rights, from the right to privacy and things like that, the right to marriage. And that substantive due process right, there aren't arguments that frequently made about that substantive due process right because you have the Second Amendment to handle that issue. But I remember talking to Don's co-author, Walter Dellinger, who defended D.C.'s law in District of Columbia against Heller, argued that the Second Amendment did not protect an individual right to bear arms. And I remember in my interview, I interviewed him and I was asking him about it, and he made a very strong argument that actually the problem with the D.C. versus Heller case was the amendment. And that had the gun rights advocates brought their case under the 14th Amendment due process clause, that Walter thought he would be absolutely obliged to think that that's the right constitutional argument. That if you look at history and tradition and whether there's been a history of extensive regulation of some activity, that a sincere history and tradition approach under the substantive due process might well say that because states have never banned guns, that there probably isn't, there might be a substantive due process right to have a gun, but it just hasn't gone anywhere at least yet.
I have to tell the story. So Walter, my co-author, and I, in the late 80s, were working on abortion rights and Webster and then Casey, when I was the legal director of NARAL, sometime late 80s, when we were going strong. The public was very motivated, politically mobilized to, because they thought the Supreme Court was going to overrule Roe, got a call from the NRA who said, "We love your message. Who decides you or them? Liberty, freedom. We're thinking about a liberty argument. We're thinking about public education effort. Do you want to work together?" horrifying. I mean, it's like,
Maybe you should have taken advantage of it.
I'm
Abortion rights would be in much better
flashback-
shape, maybe.
having
I don't know.
flashbacks here. I mean, they were weak. We were, no, it was, you know, like you're making these civil libertarian arguments and, you know, maybe substantive process liberty, but also to convince, it was very effective with the public. You know, who decides, you or them, the evil government, civil libertarian kind of content there. Just now I'm like flashing NARAL, NRA, a lot of the same letters there. No, so, no, but anyway, so that, I mean, it's a very good, very good argument for a 1L there, and thank you, thank you. Yes?
Can I make just a factual point about this, which is, since Nancy also mentioned facts, which is, if you look at Justice Scalia's opinion in Heller, in order to explain why people have the right to possess handguns, which were not arms in 1789, he says, well, but this is the form of self-defense that people use today, right? It's the common form of self-defense that people use today, so we'll understand the word arms in light of current practice. I actually went and calculated what percentage of women in the United States have a handgun versus what percentage of women in the United States have had an abortion. And it will not surprise you to find out more women have had abortions than have handguns. So if, this is just a point about constitutional method, if you're going to define the word arms, which seems like a pretty specific word, by looking at current practice, then why wouldn't you define liberty by looking at current practice, which is women, the revealed preference of women in technical terms is that part of their liberty is having the ability to terminate a pregnancy.
Just one more
I'm
connection.
gonna, I was just gonna invite final comments.
Myron Thompson opinion?
So I'm gonna just invite, we have to wrap up definitely by 5:30 to get to another thing. But so I'm gonna invite Riva, start us off. Any final comments?
I don't have a final comment. I was about to say Myron Thompson, a great civil rights judge, explained to the people of Alabama why you couldn't shut down all the clinics in the state by saying, imagine if someone did that to your guns. And it's a very powerful, I mean, his opinions are remarkable, powerful. If you think you have a right, what does it mean that way? And it's just a form of it's speaking to the public in terms that he thinks his audience might understand. And it's a very vivid moment. And I think through all of this, if we imagine the Constitution isn't just the text, but it is some conversation with the American people, it takes that form of translation and conversation to keep it alive. I'll stop there.
Adam?
So I'll just say my final thought was basically what I gave earlier. I meant that as a final thought. I thought we were running out of time. So just about pragmatic utopianism. Like, if we want to be utopian, we have to think a few chess moves ahead if we want to have effective policy in the long run that secures the goals that we want. And so I want to encourage the idea of utopian constitutionalism, but make it a pragmatic utopianism.
You can't stop backlash, but you shouldn't be intimidated either, because the arguments aren't going to go away. They're just not going to go away, so it's no reason to close up shop.
My final comment is, Pam, inspire the students again.
Well, we shall overcome.
Thank you all.
Now what happens?
I think there's a reception and then there's dinner.
Sure, you're free to skip the reception and go to the dinner.
I think that even if it's not the abortion issue, it could be a set of other issues.
I'm trying to expand that to other areas. I'm not making so much progress, but
AUL, that group I was talking about, Americans United for Life, they came in on the pregnancy discrimination case Young. They wrote a brief in that case in a way that crossed party lines. So issues in that bundle that would fit within her life ethic, whatever it is. I doubt it's the sex one, so.
Yeah. Oh, great. Thanks so much. Super. Yeah, I think you have both my email and my phone number, right? Great. Super. Okay, super. Yeah. And great, and I'll see you at 6 tomorrow. Oh, no. I'm going to try and sleep on the plane. Great.